I now declare open this public hearing of the Legal and Constitutional Affairs Legislation Committee inquiry into the Anti-Money Laundering and Counter-Terrorism Financing Amendment Bill 2024. I acknowledge the traditional custodians of the land on which we meet and pay my respects to their elders past and present. I'd also like to acknowledge and welcome other Aboriginal and Torres Strait Islander people who are participating in today's public hearing. The committee's proceedings today will follow the program as circulated. These are public proceedings being broadcast live in Parliament House and via the web. For those joining online, I'm Senator Green, Chair of the committee. With me today via video conference is Deputy Chair Senator Scarr. Senators Polly and Senator Shoebridge will also be joining us. I remind witnesses that in giving evidence to the committee, they're protected by parliamentary privilege, and it's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, described as being in camera. If you are a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretary as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that an answer be given in camera. Such a request may, of course, be made at any other time. A witness speaking for the first time should state their full name, the capacity in which they appear, and witnesses should speak clearly and into the microphone to assist Hansard to record proceedings. Mobile phones and other electronic devices should be switched off or turned to silent mode. Left intentionally blank. I now welcome representatives from the Law Council of Australia, the New South Wales Bar Association and the Victorian Bar Association. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can you each please state your full name and the capacity in which you appear today?
Juliana Warner. I'm President-elect, Law Council of Australia.
Congrats.
Michael Izzo, Junior Vice President of the New South Wales Bar Association.
Thank you.
Fiona McLeod. I'm here in my personal capacity in representing the Victorian Bar.
Thank you.
Stephen Stevens. I'm here in my capacity as Chair of the Professional Ethics Committee of the Law Council.
Thank you.
Murray Hawkins. I'm the Principal Advisor on Regulation and Professional Standards in the Law Council Secretariat.
Great. Thank you very much. Now, before we go to questions, I'll ask you to make a brief opening statement. We do have limited time to ask you questions today, so if we could keep those statements as brief as possible. I'll start with the Law Council of Australia. Thank you.
Thank you. The Law Council of Australia welcomes the opportunity to appear before the committee today about this very important legislation. Of course, we acknowledge the traditional owners and custodians of the land where we are providing evidence today, and we pay our respects to elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples attending. Since I don't know if you've had the opportunity to review the fairly complex submission...
We have.
That we
You can take it as read.
Okay.
We're very, very good at reading submissions.
Thank you.
Thank you.
But I would still like to make a few opening remarks,
Great.
which maybe are a little bit longer than we would normally do. First, there's a housekeeping matter. There's a reference on page 6 of our submissions to costs of $1.85 billion per year for the tranche 2 entities. That needs correcting. The correct figure is $1.85 billion in upfront cost and ongoing costs of $12 billion over a 10-year period. And I think we're going to be submitting an amended submission that corrects that and a couple of other typographicals. I'll now turn to the substance of Law Council's position, and first I want to deal with the role of lawyers. There is no doubt that money laundering is a scourge, and no decent, honourable legal practitioner wants to have any part in facilitating money laundering. In fact, the overwhelming majority of our profession are decent, upstanding, honourable practitioners, and we are duty-bound not to facilitate money laundering transactions. There are, of course, bad actors who turn up from time to time, and the entire weight of the law should be visited upon them. But they don't reflect the profession. We don't oppose those parts of the legislation that are aimed at strengthening the profession against unwitting facilitation, even though we understand that there will be a cost burden that goes with that. In fact, we are working very hard to upskill the profession in relation to money laundering issues. But we do oppose those parts of the legislation that we think will impact on and undermine the very important role that lawyers play in supporting the rule of law. We perform an important function. We are different to any of the other professions who are going to be caught up in the regulation of this, or any of the other entities. We are Office of the Court, we underpin the judiciary, and we owe fiduciary duties to our clients. We're bound by a comprehensive set of ethical conduct rules which are backed by statute. As part of our Westminster system, the judiciary is institutionally separate from the legislature and the executive, and it exercises its powers. The judiciary exercises its powers to ensure that the executive and the legislature do not exceed their respective powers. The judiciary cannot function properly without legal practitioners who owe a paramount duty to the court. One thing is clear: we are not part of executive law enforcement, and in fact the criminal justice system depends upon us not being part of law enforcement. This bill would require us to become covert informers on our clients. The threshold for suspicious matter reporting is very low and broad, and is much wider than money laundering. The requirements are not just to report any serious offences, but something that may be relevant to an investigation about any offence against Commonwealth, state or territory law. Under the bill, we cannot tell our client that we've informed on us. For us to become covert informers on our client, which is what this bill would require, is fundamentally at odds with our role and our duties. And we think it is worthwhile bearing in mind what the High Court had to say about Lawyer X. And it's this: EP's actions in purporting to act for the convicted persons while covertly informing against them were fundamental and appalling breaches of EF's obligations to her clients and EF's duties to the court. There are already circumstances where, under our conduct rules, which are backed by statute, they are statutory obligations, we can disclose. And that is where there's a probable commission of a serious offence, and that's for solicitors, or where there's a threat of imminent physical harm, and that's barristers and solicitors. But there's no requirement to do that secretly. This is quite different to what's being required by Section 41. Under the bill, anything that goes to AUSTRAC can go to other agencies, and in fact that is the purpose. They want to be able to distribute to other agencies. There's carve-out for legal professional privilege, but we don't think that solves the ethical problems that legal professionals will face, because many things are highly confidential but not privileged, and they would have to be disclosed. Information that may be privileged might not be properly presented because lawyers can't get instructions about it, so they can't, because of the tipping off provisions, tell their client. They might not be able to make a proper assessment, and errors may occur, and things will slip through the net. If an error is made, privilege is lost, and it can't be retrieved because it's gone to many different agencies. And the process that is being proposed, which is the LPP form, preempts a review that's being done at the moment between Treasury and the Attorney-General's Department about how to deal best with LPP in the scheme, in the context of a whole raft of different legislation. Also, there's another problem with this, which is that the arbiter of privilege appears to be AUSTRAC, and that is just untenable. This should really be dealt with by a court. That's why we say that there needs to be a carve-out for lawyer-client confidentiality as well as legal professional privilege for suspicious matter reports. And the same reasoning applies, frankly, to the notices, not the notice of provisions, because you put the lawyer in the position with a notice where they've got to try and answer it without being able to tell the client, without being able to take instructions, without a retainer, without being able to ask the client to pay for it, for example. Even a major global firm would have trouble struggling to do that. But we're talking about basically a profession of sole and small practitioners in the suburbs and in the regions. How could they possibly deal with that? Now, we have been told that there's a lot of concern about FATF, and I'm sure you're going to hear a great deal about that today. We think there may be substance in that if what we were talking about was excluding lawyers entirely from the regime, but that is not what we are talking about doing. What we are talking about doing is in relation to the reporting part of it, not that part of it that involves strengthening the profession against facilitation. And we also think that on a careful reading of the FATF requirements, the exclusion of reporting by lawyers is left to the domestic policy of individual countries, and individual countries have adopted different positions. New Zealand only excludes legal professional privilege. The UK excludes legal professional privilege plus some other confidential material, and Canada excludes all reporting. We think we should adopt the Canadian model. And Canada has not been grey-listed by FATF. We think that that model, which involves the strengthening of the profession, but at the same time not undermining the reporting, the role that lawyers have in representing clients and in defending clients against upon occasion the state, it's really important. And that balance is we think, correct there.
Ms.
Now,
Warner, I'm going to have to ask you
barristers,
to wrap up, and so I can give your colleagues an opportunity to also give opening statements.
I'm going to let barristers talk.
Yes.
There's one more point I would like to make.
Of course.
And that's in relation to, in fact, there's two very quick points. One is in relation to costs. Our first recommendation is actually that we have a review of this bill in 3 years' time, because we don't know what costs are going to be involved here. We don't know what the impact is going to be on the profession, and we think, or indeed on business. So we think that's important. The last point I want to make is that there are some very surprising provisions in relation to the abrogation of the privilege against self-incrimination, which need to be looked at very carefully. And now I'll let them get a word in edgewise.
Thank you very much. The New South Wales Bar Association, thank you.
Thank you, Senator. The committee has the two-page written opening, and I'm not going to read that out, but I'll just explain what the point that is raised by it is. And it's a specific matter concerning the application of the AML regime to barristers and ultimately the impact on access to justice. And the point is this: the Attorney General's Department takes the position, which is confirmed in the submission that they served last night, that a barrister who is instructed by a solicitor will not be subject to the AML regime. We embrace that approach, and we agree that a barrister in that situation should not be subject to the regime, both because they have no direct relationship with the client and because the solicitor has to comply with the regime anyway. The problem is this, that if you look at the wording, and in particular Table 6, it doesn't achieve that outcome. And the reason is that Table 6 uses a formulation that talks about a professional who assists or otherwise acts for or on behalf of a client in a transaction. And the difficulty that language presents is that that is going to capture barristers who provide advice for the ultimate benefit of a client, notwithstanding that they're instructed by a solicitor in respect of that transaction. It's also going to catch barristers who go to court for a client, again on the instructions of a solicitor, where the court proceeding is necessary to effectuate the transaction. And the simple point is that the drafting as it is doesn't achieve the intention. We think there needs to be express drafting to clarify that the Act operates in the way that the Attorney-General's Department says it is supposed to operate. And we're concerned that if that doesn't happen, then the difficulty you're going to have is first that compliance costs are incurred twice, first by the solicitor, then by the barrister. All of that gets ultimately passed on to the client. And secondly, that a lot of barristers are just not going to be set up to do this work and won't be able to do it. And where barristers are sole practitioners and normally don't employ staff, there's a real issue about whether it's feasible for a lot of barristers, particularly in areas that don't generate enormous amounts of fees, like family law, criminal law and advising small business. There's a real issue as to whether they're going to do that kind of work as opposed to taking the other work that's available to them. None of that is good for access to justice. So we very much press on the committee the need for express drafting to address this issue, and we're more than happy to assist the committee in doing that.
Thank you. Ms McLeod, did you want to make
Yes,
an
I
opening
do.
statement?
Pardon me. Thank you, Chair. I'm very grateful for the opportunity to appear this morning. Could I refer senators to my short personal submission, which is number 14, and also the Victorian Bar submission, number 34. I acknowledge we're on Ngunnawal country and pay my respect to ancestors and elders. I want to address particularly the position of barristers under this bill. Some years ago, I was President-elect and then President of the Law Council when Tranche 2 considerations came before this Parliament on the last occasion. I'm also a former chair of the Open Government Forum and Transparency International Australia and know many of you in my role campaigning for integrity measures, including the National Anti-Corruption Commission. I think we don't have the balance right. And my submission today is essentially that barristers should be exempt entirely from the operation of this Act. Barristers have not been distinguished from solicitors in the manner of their practice or the risk assessment in the AUSTRAC submission, the submission from the Attorney-General's Department, the FATF horizontal review of gatekeepers, technical compliance, or any other risk assessment undertaken that underpins this legislation. For very good reasons, barristers were to be exempt from the operation of the Act when they were last considered in 2016-2017. And the Attorney-General's Department consultation paper, published in May this year, noted the work undertaken by barristers, as well as general advice on matters such as directors' duties and employment laws, would not be captured. From that assurance, we now see the supplementary submission sent last night of the Department. The FATF 2019 guidance note identifies barristers as part of the definition of legal professionals and goes on to say if they conduct designated services, they would and should be captured by the regime. So first I need to note that the reference to barristers in the 2019 FATF guidance note for legal professionals is simply a taxonomic grouping. It does not support the substance of the AGD's supplementary submission about intentions. In some countries, barristers do not practice at independent referral bars as we do here in Australia, and barrister is simply an honorific or a term referencing someone who has joined a bar in the United Kingdom, for example, and then returned home to practice in a firm. Countries such as Malaysia, Singapore, Bangladesh, Pakistan, or other former Commonwealth nations adopt this nomenclature. The guidelines do not in any way assess the money laundering risk of barristers relevant to our practice in Australia as members of independent referral bars. Last night's submission goes on to say the intention is to capture barristers performing designated services, but then says barristers acting on instructions from a solicitor on behalf of a client are not intended to be captured. But as the various bar submissions to this committee note, the drafting does not affect that result, leading to inconsistency. So we have to get this right. There were and are good reasons for the position that barristers should be exempt. Back in 2016 and 17, when we first looked at Tranche 2 and the cases supporting the introduction of Tranche 2, and now. The current draft does capture barristers' work when we consider broad definitions of designated services. I just want to restate briefly, very briefly, why barristers' work should not be covered. First, barristers are not gatekeepers. We do not and are not permitted to handle client money and conduct transactions or do any other relevant thing, and we present low to zero risk. It is ludicrous to say we might do so, so we should be regulated, just as it is ludicrous to suggest that people who publish real estate advertisements should also be regulated. No case study identified in the AUSTRAC report or previously identified by government agencies to the Law Council involves a barrister. And I haven't come across another FATF common law country where a member of an independent bar or barrister's work is considered anything other than low risk. That is reflected in the Bar of England and Wales guidance note to its members, repeating the fact of that low risk in multiple places. So to regulate barristers is inconsistent with the stated methodology of applying a risk assessment approach. Secondly, as has been noted, barristers, like solicitors, are officers of the court. Our role is fundamental to the proper administration of justice, and unlike other professionals and unlike many other lawyers across FATF countries around the world, we are already caught by oaths upon admission to practice, certified ongoing fitness of good standing, duties of honesty and our overarching obligation to courts, our codes of conduct, show cause processes, ethical oversight and regulation. So there is simply no need for further regulation. And I pause here to make the point, yes, I'm watching the time.
I'm going to wrap you up because we have to go to questions. I'm sorry, we've got 3 senators waiting to ask questions and only 15 minutes.
Can I just make those 2 points then?
Very quickly?
Yes. The High Court, if the real intention here is to have barristers available as sources of information for law enforcement agencies, as the Law Council says, that is a fundamental and appalling state of affairs, and one doesn't need a crystal ball to predict what the High Court will make of it. We don't have the primary relationship with the client, and these changes will impact upon the delivery of services critical to access to justice for many Australians each year. So we need a blanket exemption, and I can certainly happy to assist with the options for how we draft such exemption, including as a regulated service or designated services.
Thank you. Senator Scarr, you have the call. You might be on mute still, unfortunately. No, we've got you there. Thank you.
Yeah, thank you, Chair, and thank you for the witnesses. I'm sorry we've only got 14 minutes left to ask questions, but please rest assured we've got your submissions, and I think you all made your points extremely well. So. I'll just make that point. If I could ask first if the Bar Association of New South Wales and the Bar Association of Victoria, Ms McLeod, if you could, if we could take, or I could put a question on notice asking you to provide some drafting which you think would address the issue in relation to capturing barristers. I think you've made a very cogent and strong case, but if I could ask you both to submit some wording which you think would close out the issue, address the issue satisfactorily from your perspectives. Are you able to do that?
Certainly, for our part, we're happy to.
I'm certainly happy to do that, and you'll see in submission number 14, my personal submission, I've offered some suggestions about drafting, but I'm happy to supplement that.
Well, and to the extent that were provided by the Bar Association of Victoria in its capacity, that would perhaps give it added weight,
yes.
Ms McLeod, as well.
Yes, thank you, Senator.
Okay, thank you. I'll go to the Law Council of Australia now. I am interested to know is there an understanding within the Law Council of Australia, within the profession, as to what the imposition of these obligations would mean practically on a small practice, 1 or 2 member practice, which have, as you've said, the majority of legal practices have 1 or 2 partners. Does the profession have an understanding what they need to do practically in order to discharge their obligations in the event that the bill was passed in the form as presented?
If I could say, I think it is dawning on the profession the full extent of what might be involved here. There is a great deal of bureaucracy and sort of paper and documentation that will be involved here. There is undoubtedly cost involved in having to seek specialist AML advice, for example, in risk assessments and the like. We are working very hard to get guidance out and understanding out into the profession about how best to manage these obligations that are coming, but it is undoubtedly going to impose a real burden on very small practices, and that is of concern because so many are in the suburbs and in rural and regional areas.
So, to be frank, it concerns me when I hear a leader of the profession say, or give the answer that you've just given in terms of it is just dawning as to what these obligations may mean. But, you know, before this bill is passed, if it is to be passed, I would have thought we should be quite clear as to what this means for a legal practitioner, say, and indeed a real estate agent and accountant in terms of their day-to-day operation. What would they be required to do after this bill is passed, which they are not required to do now? Do we have any...
We haven't seen the rules.
...clarity with respect to that?
No, because we haven't seen the rules.
But,
a significant part of this regime is a redraft of the rules, which has not yet occurred. It is a process that will be undertaken over the course of the next 12 months, basically.
Has there been detailed consultation, coordination between the profession and the department with respect to what may be in those rules or not in those rules? Is there any transparency or insight in that regard?
Not a great deal. There have been discussions with AGD, but it's really still in the formative stages to work out precisely what is going to occur. Take, for example, a real estate transaction where there are many different people who would be involved in a real estate transaction. Are they all supposed to be doing CDD? Is everybody supposed to be doing PEP and sanction screening? Or is there going to be a way of relying upon someone in the transaction to do the PEP and sanction screening? So there's a lot that is still out there to be worked out as to what it's really going to mean on the ground.
Can I add to that? Sorry, Senator, I was going to add to that answer. Barristers, of course, are sole practitioners, and we practice individually. The burden on barristers individually is not only a double burden if the solicitor or other referring entity is already complying, but it does create a significant burden when somebody is required to know their client and they don't have the direct relationship and report as set out under this Act. And how does that apply when somebody is appointed as a mediator, appointed amicus curiae, or appointed by a court to conduct a matter under a pro bono referral system? There are numerous examples where there is a lack of clarity about how barristers will be affected in terms of the compliance regime.
But, Senator, it may help to understand the context of your question by noting that solicitors do client due diligence day in and day out. It's part of their job. They have to know who their clients are. They have to know their client's circumstances. They have to know what their client wants to achieve. They have to know why their clients want to achieve. And they have to make a judgment about whether that is lawful and proper. And if they're not satisfied, they have an obligation not to provide legal services. So that's a broad way in which the job of a solicitor currently is.
But that doesn't mean that there's not a lot of prescription involved in preparing a risk assessment, doing a risk assessment of particular customers, understanding what might be involved in that. So there's a whole layer of complexity which is still to come, which is where the additional cost comes. And that's why we say this needs to be reviewed in 3 years' time to see what has actually transpired.
I think you've made that point extremely well. In terms of this issue around suspicious matters reports, I note that the Supreme Court in Canada struck out that imposition on the legal profession, and thank you for providing the extracts from the judgment in that regard. What are the learnings from the UK in terms of the imposition of these obligations?
The UK has a slightly different regime because reporting is done to the Solicitors Regulatory Authority rather than to the financial people. It's a different measure of a different definition of what actually has to be reported. It's not as wide as the suspicious matter reporting obligation here. Anecdotally, we understand that there are still difficulties for solicitors in trying to figure out what on earth they're supposed to be doing and how they deal with the ethical problems. And in fact, I had one advisor say to me, you get a solicitor who's caught between a rock and a hard place. There's a very high penalty or there's breaching your fiduciary obligations. What do you do?
Can I add to that? Our understanding is that in respect of the UK, there's two key differences to the proposed regime. First, the suspicious matter reporting is confined to offences involving money laundering and terrorism. That is not the scope of Section 41 of the Act, in fact, as it now is. And Section 41 of the Act imposes the suspicious matter reporting obligation in respect of matters that might be relevant to an investigation of an offence against a law of the state or Commonwealth. So or territory. So it's extremely, while we're all here because there's an act about money laundering and counter-terrorism financing, Section 41 is not so restricted. So that problem doesn't exist in the UK. The other difference in the UK is that it's been made clear that the obligation doesn't apply to barristers if they're giving advice on specific aspects of a transaction, and that, as you understand, is one of the key concerns that the New South Wales Bar has raised, that the legislation, the proposed form, would catch that kind of work.
Okay,
Senator Scarr, I will have to share the call if you've got one more question, and then I can hand the call to Senator Shoebridge.
Well, I'm interested if, just to put on notice, perhaps for the witnesses, if they've got any further observations or details with respect to learnings or differences in approach, particularly in the UK, but in other jurisdictions that are comparable, so we can consider those. I personally find that useful. But thank you very much for your submissions. There's so much work that's gone into them. I found them extraordinarily helpful and compelling. So thank you.
Could I please just add a third difference with the UK briefly? There's going to be, under the Australian regime, a lot more of an obligation to report suspicious matters because the only exclusion is for situations where all the information is subject to legal professional privilege. In the UK, as well as excluding a reporting obligation for legal professional privilege matters, there's an exclusion from reporting for other confidential information described in the UK legislation as information obtained in privileged circumstances.
Thanks. Senator Shoebridge, you have the call.
Thanks, Chair. I probably should, first of all, indicate that I remain a member of the New South Wales Bar Association and retain my practising certificate. So I indicate to the extent that that's an interest that I have in the matter. Could I first of all, we just don't have time to go into detail, and I too will be interested to see what each of you say in relation to the UK model and differences between the UK models. If you've all taken that on notice to Senator Scarr, I look forward to that response. Could I ask the New South Wales Bar Association, is one of the rationales for having barristers excluded is the due diligence has already been done by instructing solicitors. Have you considered perhaps having an arrangement in place where if you satisfied yourself that the due diligence had been done by the solicitors, that would satisfy your obligations under the regime, and amendments to that effect?
It's certainly an approach. The difficulty is that it's very difficult for a barrister to reach that state of satisfaction without having some independent understanding of what the solicitor has done. And it arises in this way, that a lot of the time barristers are consulted in respect of these kinds of transactions in a very ad hoc fashion. So you could have someone come up for an hour to have a conference about what a particular clause looks like. And barristers do that kind of advice work frequently. And the capacity to form a view as to what a solicitor has done in respect of each one of those situations is very limited when you just don't have that insight. And it's not going to go very far if you just accept the solicitor's word for it, because then you'll be criticised for doing that.
There's solicitors' undertakings, of course, but it's got the same problem.
But it's got if there's a defect, you're caught by the defect.
I'm caught by the defect too.
No, but if the some form of warranty, that you could accept some form of warranty from the solicitor, which would at least require you to turn your mind to having got the warranty, but it would be self-defeating if that system then required you to independently satisfy yourself as to the thoroughness of the solicitor's provisions, but some kind of warranty basis. Or the like from the solicitor, which would at least require you to turn your mind to it, having been satisfied, being provided with some kind of assurance, adequate insurance from the solicitor, you could then proceed to give advice. That might be a sort of halfway house.
Quite. I understand the point. I suppose our reaction to it would be that it's difficult to see that it adds a lot of value to the regime, because the barrister is then you're still dependent on the solicitor to do their job.
Well, but I mean, as I understand it, your submission and that of the other bar councils is that that's an entirely adequate position to be, that the obligation should lie with the solicitor. I mean, I've got to tell you, I'm troubled by the scale of the carve-out proposed by the Australian Bar Association. That seems to go A, well beyond barristers, and B, to potentially be a sort of an undermining of the entire scheme. Could I ask you, and I might also ask the Victorian Bar to take on notice if some kind of response to that is a potential way forward?
I understand the point, and we can consider that. Thank you, Senator.
From the Law Council, one of your primary concerns is being able to actually inform your client if a referral is required to be made, and you therefore get caught in a terrible ethical bind. And I understand that, and you set it out in your submissions and in your opening address. Of course, against you is the argument that if you tell your client that there's been a referral and your client does have in possession money that's been laundered, that will, of course, tip them off, and it'll be, converted to Bitcoin and taken out of the jurisdiction quicker than you can say, I got my money from drugs. That's the reason to not have the disclosure. What do you say to that?
It's a balancing exercise. It's a question of balancing access to justice against law enforcement. We do it all the time. In our view, we speak from the access to justice point of view, the fiduciary obligations, the duties to the court. Sure, you can legislate the fiduciary obligations away. but I don't think you can wash away the duties to the court, as my understanding as a practitioner of 40 years standing. Now, in relation to I can't think of a way through that a practical way through that at the moment. There may well be some kind of practical way through.
But again, it may be that there are elements of the UK model that would be worth looking at, and if you could address that in your answer on the UK model, that would be incredibly helpful. One of the other options would be, again, potentially saying once you make a referral, you give a reasonable amount of time to AUSTRAC and whoever they share the information with to undertake some investigations and potentially put in place a freezing order if they need it. But then after a period of time, you're entitled to inform your client of the referral. And I don't know what a reasonable amount of time is. Maybe it's a month, maybe it's a fortnight, which would again potentially be a way through this.
That is the kind of that is the kind of proposal that I actually think would need some serious consultation and would actually take time and couldn't properly be dealt with on notice. It's different to understanding what the UK system might be right now, but understanding what the consequences of that might be takes a bit of thinking through. And if it was something that the committee thought was something that should be pursued, then the answer may be to defer implementation or defer the passing of certain parts of the legislation until there's been consultation about that. That would be a way that would involve a better way of dealing properly with the situation.
First of all, I don't pretend to talk on behalf of the committee. And secondly, if we were to consider something like that, we'd need some assistance from witnesses.
Of course.
So any assistance you could provide in that regard would be useful.
We're happy to assist on that. Yep. But look, at the end of the day, I'll just make the point that our judicial system, our system of rule of law in Australia is based on the importance of promoting the rule of law, promoting the observance of the law, and the important role that lawyers have in that. And that depends on encouraging and giving the public the opportunity to seek legal advice on any matter, whether it's a dodgy client or not a dodgy client. It's really important that people go along and seek legal advice in relation to legal issues, because that is the best way, and that's how our system operates, to encourage people to know the law and to follow the law. Yes, sometimes people don't follow the law, but it's important that they get advice. Now, if the situation is that we sort of bring this bill in and require suspicious matter reportings, particularly very limited exceptions, then we're going to create an environment where people are going to be in a situation where they're not going to frankly seek advice, or not going to be frank in seeking advice if they do seek advice, or they're going to shy away from seeking advice. They're not going to be interested in seeking advice. We're going to discourage people because of the fear that they could be covertly informed upon by their lawyer. That's going to really affect the Australian legal system from what it is, from what the objective is at the moment. Lawyers are officers of the court. Our duty is to promote observance of the law, and our system relies on us encouraging, as a community, people to seek legal advice. And if you are in fear, even if whether you're a dodgy client or not, if you're in fear of disclosure covertly without knowing about it, then that's going to discourage people. We need to balance whether that's an important consideration. I don't think that's been taken into account in terms of suspicious matter reporting. So, as Juliana said, we support the introduction of these measures of the application to lawyers, but there are significant issues, particularly suspicious matter reporting, which we strongly oppose, and we ask that that be considered. And if necessary, based on your proposal, we're happy to look at the deferral whilst it's further considered.
Have any of you obtained advice about potential constitutional challenge or the advice on the application of the Lawyer X principles. Have you obtained some advice on that, given the High Court's observations in the Lawyer X case? And if so, could you share them with the committee?
I'm not aware of any advice on it, Juliana, but I just make the point that the Lawyer X case that Fiona referred to stands clearly on its all four squares. It is a gross breach of the duty of a lawyer to the client and the administration of our judicial system in Australia to covertly inform on a client.
No, I understand
Senator
that.
Shoebridge, I'll have to wrap you up in a second.
We can provide you with a note about that. It's probably not a constitutional issue, but more a fundamental protection of the common law. Yep.
Yeah, that seems to me to be one of the issues. If the legislation is vulnerable to challenge based on the principles the High Court enunciated in that Lawyer X case, actually having that articulated to us in a compelling opinion or the like would actually be of assistance. I think would be of assistance to myself, and I assume would be of assistance to the committee. So, and I assume it wasn't just a throwaway comment, Fiona. It was a matter of some consideration. So we think that consideration would be useful.
Senator, can I add that point is addressed in some detail in the New South Wales Bar Association's submission, and while we don't have something that I would formally call an opinion, I can assure you that submission has the input of several very distinguished barristers, and the difficulty is the fundamental point the High Court identified, that particularly in the criminal justice system, but even more broadly, you can't act for someone and inform against them at the same time. The law might make you inform against them, and it can do that, but then you can't keep acting. Yeah. And the difficulty is, how do you stop acting?
How do you stop acting without doing the tip-off?
Exactly.
If you have that ethical divide, that defeats the very purpose of the confidentiality. If you just mysteriously stop acting and you say you can't explain why, it's kind of like putting a red light on it, isn't it?
Oh, well, this happens in the real world where people are in court, where a court is going to want an explanation, where a regulator is going to want an explanation, where the client and the opponent are going to require explanations. So it's not like another professional services advisor ceasing the provision of services. It can have quite a dramatic impact, particularly in the criminal law.
Public
Thank you, Senator Shoebridge. Thanks very much. Appreciate it. I will also be very brief with my questions. I'll come to you in a second, Ms Warner. Of course, if there are additional information that you want to take on notice of the questions asked by the previous senators, please feel free to do that. Going back to, I guess, the tranche 2 provisions, there's been reviews since, I think, going back to about 2015, foreshadowing the inclusion of tranche 2 professionals in the regime. The most recent was the 2022 review from this committee in the previous parliament. As I understand it, your submission provides support for the general proposition of the inclusion of tranche 2 professionals. Is that right?
Yes, in general terms, yes.
Yeah, okay. And you said in your opening statement that legal professionals, of which I am one, are duty-bound not to facilitate unlawful transactions. Of course, there are bad actors and that they deserve the full weight of the law, but bad actors don't reflect the profession. Have you read the AFP submission?
I have.
Okay.
I have.
The AFP submission outlines, I guess, their experience with money laundering and policing money laundering and detection of that type of criminal activity. And in their submission, they observe that that more often than not, tranche 2 entities are actually unwitting facilitators or reckless to the risk of money laundering or concealing proceeds of crime. So they identify that it's not necessarily bad actors, but actually where legal professionals are unwitting facilitators or reckless to the risk.
Because they don't.
Sorry, I'll put my question to you and then you can answer it. So Do you think that the regime that's being put forward will actually support and strengthen legal professionals in mitigating against these risks that have been identified by the AFP?
Well, not by itself, but allied with the education program that the Law Council and all of the constituent bodies are putting in place to roll out. It is really important that people understand what red flags look like, that they... I mean, it's quite complex working this out. I also think that it is important that this is now taught in law schools and in PLT courses and the like, so that people know when something is trying to be put past you. That is the real part that will stop unwitting facilitation. All of the bureaucracy that goes with it is, to my mind, just focuses the attention more on the need for better education out there for the profession, which is what we're trying to do.
Yep. Okay.
And this is an evolving process. To the extent that the legislation will enhance customer due diligence, that's an important development, but it's not the start of the point. The profession has been involved in educating the profession since 2011. The Law Council has published material guidance for legal practitioners on anti-money laundering and terrorism financing risk issues and checking against it, and the obligations of lawyers are and always have been to only follow lawful instructions, which means you need to go and find out what is your client doing, where are the monies coming from, where are they going to, what's the reason, and if you suspect there is something illegal, then you have to cease acting. That's your obligation currently. Earlier this year, the Law Council put out expanded and very detailed guidance notes on anti-money laundering. We've been moving to do that before the introduction of this bill. It is an evolving process, and to the extent that the bill leads to enhancements to customer due diligence, I think that is important, but it will be an evolving process, and as you can see from FATF, they're changing some of their standards as well. So we need to do everything we can to deal with these scourges, and the Law Council and the legal profession in Australia has been actively involved in doing that, and there's a lot of education going on at the moment about that.
Thank you.
So, Senator,
I'm sorry, we have very limited time, and there's a few issues that I want to give you the chance to go back over, particularly legal professional privilege. The bill does actually propose a complete protection for legal professional privilege, and you outline really significantly in your submission and your opening statement around that, how that might be improved. I'll just put to you that some of the submissions that we've received and some of the witness evidence we'll receive today actually suggest that carve-out that the government has included in the bill significantly lowers the effectiveness of the regime. I'm just interested in your views about why the carve-out should exist, perhaps for people who might not necessarily understand how legal professional privilege operates at the moment.
You would completely undermine confidence in the legal profession if legal professional privilege was not respected. It is fundamental to the justice system. I've read some of the submissions that suggest that, but I mean, this is not all about law enforcement. This is about living in a democracy where the interests of access to justice are appropriately balanced with the interests of law enforcement.
So it's not just a matter of self-interest of lawyers. This is fundamental to the delivery of just outcomes for clients, Australians, but also the proper administration of the courts. So it's fundamental, and that's why it's recognised in numerous pieces of legislation that legal professional privilege is protected, and you can't rely upon a disclosure of legal professional privilege to do various things. So in this act is consistent in maintaining that legal professional privilege with numerous other Commonwealth, state, territory pieces of legislation.
I would add, for any such doubter of the inclusion of legal profession privilege exceptions in the legislation, one only needs to refer to FATF itself. FATF is not saying that legal professional privilege should be abrogated. In fact, it runs the very same argument that it's an important component around the world of our system of administration of justice and rule of law. So it's just that is really a fanciful suggestion that it's an appropriate measure. FATF itself is saying there should be a carve-out for legal professional privilege and professional secrecy,
which is wider, as we understand it.
Just on the matter of the drafting around the exclusion from barristers, we've received that additional submission now, so we will put those questions, I think, to the Attorney General's Department this afternoon. I am interested in the question that Senator Scarr put to both of you around how the drafting might overcome that lack of clarification. Can I ask, are there many instances where barristers would be directly briefed, and how would that would the exclusion that you're seeking or seeking to clarify, would it also relate to direct briefs?
It wouldn't, and the approach that we've taken is that we at least, I think New South Wales Bar have understood the intention which we're told that the Attorney General's Department holds, and we're simply trying to make sure that that intention is effectuated. We accept that even if one approaches the matter the way that the Attorney General's Department wishes to, that direct briefing would nevertheless be caught by the regime. That's a different matter, and it's a matter that Ms McLeod has addressed.
A portion of all bars do direct briefing in criminal law matters, which is seen as a very cost-effective way to provide advice and appearance support to lower courts in small matters. Our conduct rules require us to insist on a solicitor in appropriate cases. So barristers are already required to insist on solicitors where the case warrants it. There are numerous cases where tax lawyers, for example, are briefed directly by accountants. Planning barristers can be briefed by town planners. There are cases of government lawyers who don't hold practising certificates. That's most of my practice is government work.
And the accountant direct brief is the one that may have come up in some of the examples that the AFP has given us, and that's why I asked the question around direct briefs, not necessarily from clients, but from accountants.
Exactly. So, and there's a range. So, for example, if you practice in native title work, you might have a direct brief from a prescribed body or from a philanthropic organisation. All of those potentially have a designated service involvement because of the nature of the advice that's been given. Mediators don't have a briefing instructor. They're engaged by both parties, and barristers perform mediation work. They don't have any... In all of these cases, there's no engagement with property or transactions. They're not handling cash. So.
Thank you. We are running hopelessly over time, but I wanted to fully ventilate as best as we can this morning those issues with you. Thank you very much for your very lengthy submissions and your opening statements. And if there are questions on notice, we'll give you a date to return those to the committee. And thank you for your participation in the consultation that led up to the bill itself. That's all the time we have, unfortunately. I think our lunch break is looking like it's going to reduce slightly today, but that's okay. Thank you very much. We'll get our next witnesses up to the table as soon as we can.
Thank you so much. Thank you for your consideration and the extra time that we've taken.
That's okay. Thank you very much. I might start with my little spiel and that'll help move things along. I now welcome representatives from Transparency International Australia via video conference and Quarter-Mentha. Thank you for taking the time to speak to the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. I understand representatives from Transparency International Australia are joining us via video conference. For the Hansard record, can I ask you to please state your full name and the capacity in which you appear today?
Sure. Clancy Moore, Chief Executive Officer of Transparency International Australia.
Thank you.
Russell Wilson, I'm a Non-Executive Director of Transparency International Australia.
Thank you. And Ms Mason, you're in person today, so we'll go to you next.
Hi there, I'm Grace Mason. I'm a partner in the Quarter-Mentha business based in Sydney.
Okay, thank you so much for appearing today, and thank you for letting us run a little bit over time. Would either of your organisations like to make a brief opening statement before we go to questions? Yes, I think we do. So I'll start with you, Mr Moore.
Great, thank you, Committee Chair. Just to begin by acknowledging the traditional owners of the land that I'm living and working on today. I'm on the land of the Wurundjeri people of the Kulin Nations, and just to pay my respects to their elders, past and present. Thank you for the opportunity to speak today, committee members. Just in terms of our initial framing, it's really important to note that for far too long, kleptocrats, corrupt officials and organised crime gangs have laundered their illicit funds into Australia. When this dirty money flows out of poorer countries into Australia, it can rob local communities of resources needed for essential services. We also know that money laundering enables other crimes and harms the most vulnerable in our society. Unlike 195 other nations, Australia's current AML-CTF regime does not include high-risk gatekeeper professions such as lawyers, accountants, trust and company service providers and real estate agents. As noted internationally and by the AFP and AUSTRAC, these professions often, unwittingly or wittingly, facilitate and enable money laundering. Combined with a lack of beneficial ownership transparency, this means that Australia's doors are wide open for criminals to exploit. Australia's weak laws also increases the risk of financing for terrorism and proliferation. In 2015, FATF concluded that Australia's property market is an attractive destination for the proceeds of corruption. This has also been confirmed by the recent AUSTRAC national assessment, which found that the risk of money laundering in Australia's real estate is high. Our submissions provided also include examples of money laundering allegations into Australia's real estate sector from criminals and political elite from countries such as Russia, Cambodia, China, Papua New Guinea and South Sudan. Committee members, we strongly support the government's reforms to Australia's AML-CTF laws. This also includes bringing in these high-risk Tranche 2 entities to take a risk-based approach to help detect and prevent money laundering and terrorism financing. Despite the significant improvements in the draft bill, there is a risk around the provisions for legal professional privilege as outlined in Section 41. To be clear, these risks create a major gap in the defence against money laundering, in that the provisions could allow not only lawyers but also any reporting entity to not submit suspicious matter reports to AUSTRAC if they hold a reasonable belief that content within is privileged, without any corresponding test for this belief, except through the courts. To be clear, any further weakening of the bill will significantly limit the effectiveness of the reforms and maintain the serious risk of grey listing by FATF. Thank you for your time, and myself and my colleague Russell Wilson will be happy to answer any follow-up questions. Thank you.
Thanks very much. Mr Moore, Ms Mason, do you have an opening statement?
Thank you. Thank you, Chair. Thank you, committee members, for inviting me here today. Quarter-Mentha is an independent advisory firm providing cybersecurity, financial crime, forensic accounting, restructuring and performance improvement and real estate services, and is uniquely placed to comment on the AML-CTF reforms as our financial crime advisory team operates in both the New Zealand and Australian markets and understands the commercial challenges of implementing the obligations as outlined. We have gained experience from a range of roles in industry, including as compliance officers in some of Australia's largest reporting entities, professional advisory firms in Australia and internationally, and in regulatory roles with AUSTRAC. We work across the full gamut of existing reporting entities, so remittance providers, digital currency exchanges, gaming, banking and other financial services, payments and wealth, and with clients that are as small as sole operators, but others that are multinationals. The KordaMentha group of entities itself is going to be affected in three ways by these reforms. That we're, as I mentioned, an existing reporting entity under the AML-CTF regime. We will be captured by the regulation of the new professional service providers and real estate, and we will broaden our range of and our role in assisting reporting entities to comply with the proposed changes. So, similarly to my colleague Clancy Moore, KordaMentha welcomes the proposed changes to modernise and simplify the existing regime, as well as incorporate the additional sectors, notwithstanding the cost and the regulatory impact that we know is significant. We recognise the importance of complying with our international standards, not simply from a global compliance perspective, but from the impact that that will have on the financial sector and our ability to operate internationally here in Australia. We do have strong reservations in relation to the proposed implementation period that we understand is being driven by Australia's Financial Action Task Force mutual evaluation. I look forward to discussing these issues with you today. Thank you, Chair.
Thanks very much, Ms Mason. Senator Scarr, do you have questions?
I do, Chair. Thank you. And I'll move through it as quickly as I can, given the time pressures. Can I ask a question of KordaMentha first? And that is the submission by the Chartered Accountant CPA IPA proposes an exclusion for restructuring practitioners appointed under Part 5.3b of the Corporations Act from the proposed designated professional services. Do you have a view with respect to that?
Senator, we would have a view in relation to that. Would I be able to take that on notice and provide that to the committee?
You can certainly do that. So I'm interested in your views, given your the firm practices in that area. If I can then go to Transparency International, and you know, I'm a big fan of all the work that TI does around the world, including in our Pacific region. You do recognise, or do you recognise the tension here between the legitimate goals with respect to the regime, AML, CTF regime being rolled out to the gatekeepers, tranche 2 entities on the one hand, and then issues like legal professional privilege, which is a cornerstone of our rule of law. You recognise there is a tension there that needs to be reasonably resolved to get the balance right?
Absolutely, yep.
Okay, all right. One of the concerns that's been raised by the Law Council of Australia this morning was in relation to this issue of suspicious transaction reporting or suspicious matter reporting. What's TI's view with respect to the argument that's put that it's simply fundamentally inconsistent with the role of a legal advisor who's giving legal advice to a client to, on the one hand, be giving that advice, but then on the other hand, have an obligation to provide an enforcement agency, a regulator, with tip-offs or reports of suspicious matter reporting, that there's a fundamental tension between those two activities.
Yeah, thank you, Senator, for your question, and thank you for your ongoing support of transparency and accountability more broadly. I might ask my colleague Russell Wilson to respond to this question. He's a former legal counsel at AUSTRAC, worked there for 10 years, so he's quite well placed to respond to your question. Thank you.
Thanks, Clancy, and thanks, Senator, for your question. I was the first General Counsel of AUSTRAC for 10 years, between 2006 and 2016. I think I had the pleasure of working with Grace during some of that period as well. So there's a connection there. I don't think there's a tension, not as much as the Senate has been asked to believe. A lawyer such as I, and such as the ones you heard from this morning, are officers of the court. They also have a duty, therefore, to uphold the law, and they have a duty to prevent a breach of the law, I would say. Suspicious matter reporting is not evidence, it's intelligence. It's very valuable intelligence for regulators and law enforcement agencies to assist in the detection, investigation and prosecution of crimes. So it is very valuable input for those sorts of things. Yes, there is a tension, there is a balancing act, and the balance has to be achieved by Parliament in terms of what it legislates. But we would say that at this point, the legislation in regard to suspicious matter reporting goes too far to protect legal professional privilege, particularly in respect to circumstances where we have in the amendments to Section 41, which deals with such reports, a carve-out completely. If there is any kind of reasonable prospect or reasonable grounds of legal professional privilege being claimed in respect to all of the information which may be constituted in a suspicious matter report. Now, there's an artificial distinction being made here between when all of that information may be privileged or may be have reasonable grounds for privilege, and when only some of that information there may be reasonable grounds for privilege. We don't understand that distinction. When there is only some of the information which may be privileged, then there is certain information which the reporting entity, such as lawyers, needs to provide to AUSTRAC for that claim to be verified as to whether or not it's subject to LPP. Why is that not the case when there is a claim that all of the information may be subject to privilege? Because otherwise, the only way that this can be verified or tested as to whether there is a legitimate claim to LPP is in the courts, and that may not be for several years down the track, after which the circumstances, the damage that may have been caused by the lack of an SMR has happened.
And I certainly understand the time sensitivity in relation to obtaining the intelligence, etc. I think that's clear. Do you, when you were perhaps you bring this experience as having been AUSTRAC's first General Counsel, do you have any observations you can provide with respect to how that tension is resolved in comparable overseas jurisdictions? So we did hear that and I was aware the Canadian Supreme Court had taken a very robust view with respect to the issue of suspicious matter reporting, and actually came to the view that it was as drafted in the Canadian legislation. I don't know the details, but it went too far and was therefore struck out, so there had to be a workaround. Do you have any insight with respect to how this tension has been resolved in comparable common law jurisdictions like the UK, Canada and other jurisdictions, similar jurisdictions?
Not in any great detail, Senator, but I can give you my impressions. It's mainly based on my general reading rather than in regard to when I occupied my role at AUSTRAC. Firstly, LPP has always been preserved by the AML-CTF Act in Australia. It's been there since the 2006 legislation came into effect. So what we are seeing is special provision being made in these amendments to deal with the issues brought forward by some parties in the community to further enhance, I would say, LPP. Now, in the Canadian situation, I understand that that was a constitutional issue, and so there were particular circumstances which I don't think are relevant to Australia. I think the issue is that money laundering, and for that matter counter-terrorism financing, is a global issue, and that's why we have FATF as, in a sense, the global rule setter in this area. And because it's a global issue, the whole system is only as robust as its weakest link. And I think what we need to do is to try to not make Australia that weak link. And I think that's why we need to have fairly robust provisions that cover Tranche 2 entities, including not leaving such a large carve-out in respect to an LPP claim when it comes to the provision of suspicious matter reports.
Senator, if I may, I might just add there's some research from the United Kingdom which shows that when privilege is applied without proper grounds for doing so, it actually undermines the effectiveness of that country's AML regime, noting the differences in reporting in that in Australia, entities would be required to report to AUSTRAC, whereas in UK they report to the regulatory authority. But I'm happy to share that research on notice as well, just for the committee's consideration.
Okay, no, that would certainly be useful. I'm interested in your views
Scott,
with respect
I'll have to share the call after a question. Maybe you can combine a couple. Yep.
I'm interested in your views with respect to barristers. It does seem to me barristers are largely in a position where a solicitor instructing solicitor acts as the intermediary with the client, and that in itself leads to pause to reflect as to whether or not there's any utility in imposing a burden on the barrister which has already been met by the solicitor. Do you have any other particular views with respect to under the Australian system, the distinction between how the law should apply to barristers as opposed to legal practitioners who have that every day-to-day engagement with clients?
If I may, in regard to this, Senator, with respect to the submissions made by others, including those which we heard just before, it is not the case that there is always a solicitor intermediary. Barristers can be instructed directly by clients in order to get advice. So I would think, therefore, it is problematic in those situations where the advice may be for any particular subject matter that may in fact relate to issues covered by the AML-CTF regime. That's a weakness.
But if it's not relating to an actual transaction where property is being acquired, monies are being transferred, it is simply giving advice, say, to a town planning practice on the operation of a particular provision of a piece of town planning regulation, is the AML regime relevant in any event?
It may also be about how do I structure my affairs to minimise my taxes. And inherent in that may be issues about how to deal with assets and money.
Yeah.
Okay. Thanks, Senator Scarr. Okay. I'll have to share the call. Senator Shoebridge, you have the call.
Thanks very much for your work. And again, I am a real fan of Transparency International's ongoing work, and it's a bit frustrating that we're dealing with such a complex piece of legislation so late in the year with so little time. The concerns, I note your position if there's a direct brief from a barrister where they clearly should be caught and there should be the reporting obligations and the like. But where the barrister is being briefed through a law firm and the law firm already has the reporting obligations and disclosure requirements, do you see any value added by also adding that layer of obligation on the barrister as well?
This is not an unusual situation. The current AML regime, in regard to its reporting entities and the reporting that's required, sometimes have what might be seen as a bit of an overlap in terms of coverage, such as what you're describing. Now, that overlap is useful in the sense of AUSTRAC being able to check whether there is a consistent reporting between the two reporting entities. So if the solicitors and the barristers were also caught. There also could be circumstances where the solicitor may have done the check on the client in regard to maybe particular issues or particular circumstances, but the barrister then is asked to advise on something else altogether. So it's not a perfect situation. Yes, ideally we want to avoid doubling up, but there could be circumstances where the initial checks done by the solicitor are not sufficient.
Well, I suppose this is where we get, and I know you may want to jump on this, Mr. Moore, this is where we get to the benefits and the costs of putting that layer of regulation on a profession that is effectively sole traders, where there's already, if this legislation is passed, layers of protection from entities that in many cases, or not all, and you heard the submission from the Law Council, have more adequate structures to deal with a risk assessment. So it's a question of appropriateness, isn't it? And I suppose that's a judgment call.
Yes. Agree.
Yeah, I mean, I'll just talk about the risk-based approach to customer due diligence and suspicious matter reports. Inherent in the Act is the focus on a risk-based approach, which means it's proportional to the business's risks and size and scope as well. So a small, one single solicitor kind of practice is going to have a much different risk profile to a very large corporate law firm. Similarly, an accountant self-employed to a large accountancy firm as well. So therefore, the amount of work to actually undertake, the risk-based approach is going to be much less. They're going to have, less clients to deal with. So I think the cost argument doesn't necessarily hold weight for some of those small to medium enterprises that's being put forward by some of the parties in this process as well.
Yeah, but if there was to be a regime that an amendments that said barristers were not required to duplicate, obviously that wouldn't include direct briefs. If barristers decide to take a direct brief, there'll be absolutely no argument for them to not be covered by the regime there.
Yes, we would expect so.
Yeah.
Yeah, and similarly, Senator, a lot of current real estate agents are already conducting significant due diligence through rental applications as well. So there's also a very clear argument that a lot of the checks that would take place by these new entities are already being done in some way, shape or form.
Some people might say that real estate agents are already in an unregulated and aggressive way performing excessive due diligence on people trying to get a rental and very minimal due diligence on people who are purchasing multi-million-dollar properties. Some people might suggest that too, Mr. Moore.
Yep, and look, the evidence recently of two Russian money launderers in the Gold Coast who purchased over $12 million of property where real estate agents turned a blind eye. They're also supported or unwittingly enabled by lawyers would demonstrate that exactly the point that you made, Senator.
Yeah. Could I ask about I think the Lawyer X case, which has come up a couple of times in the positions being put by lawyers. And the Lawyer X case, of course, is where police grossly unethically effectively had a barrister as an informant. So the barrister was both representing a client and being an informant. The High Court made some absolutely brutal and appropriate assessments of that. The lawyers have put that forward as an argument against roping them in where they're covered by legal professional privilege as highlighting the ethical conflict that it puts in place. What do you say to that, given the experience of the Lawyer X case?
I would say, and I would agree with what I heard previously, I think it may have been from the Law Council perhaps, that that case stands on its particular facts. It's a very unusual case. It's a situation where there was a clear breach by the lawyer of their duties to their client. Of course, the circumstances which led to that were unusual in terms of the involvement of law enforcement to create that kind of situation. We don't want the tail to wag the dog, Senator, in the sense that this is an unusual case. And it's not the reason for there not being regulation of lawyers, nor a reason for a larger than necessary carve-out in regard to legal professional privilege.
Senator, Sorry, could I just add to a comment you made earlier in relation to SMR reporting and possible sort of requirements to leave a period of time before sort of a disclosure to a client. Obviously, in AUSTRAC's dual function as both the AML-CTF regulator and the Financial Intelligence Unit, the SMR and the other reporting obligations is really the start of that financial intelligence process. And really, once those SMRs enter that sort of AUSTRAC system, there would really be, from an operational perspective, not really an opportunity to be able to advise that client of that situation, because for SMRs that are part of AUSTRAC's infrastructure, they are actually part of their network analysis that's done, and that intelligence might be looked at in a year's time, or somebody might be doing an assessment in 1 or 2 or 3 years' time. So in relation to that, from an operational perspective, I would just make the comment that I'm not sure that would be possible in my experience.
Because of how the information can sometimes sit there in AUSTRAC's database and only become relevant once other information comes to hand.
That is correct, because it's just part of the story, yes.
Yeah. But what do you...
I'm just going to wind you up in a minute or two. If I can.
Yeah. What do you make of the argument, though, and it was put by both barristers and solicitors, if they form the view that there is a conflict between their reporting obligations and their ethical duties to both the court and the client, that having informed of them and, for good and proper reasons, and I'm fully supportive of whatever we can do to counter money laundering, but having informed upon them to the authorities, they then form the view that under the bar rules or the legal profession rules, that they then have a conflict and are ethically obliged to cease acting. What do you say to that argument? Because if that then happens and then they just cease acting, don't explain why, because they have confidentiality obligations, perhaps can't explain to the court why they're ceasing to act because they've formed this view, that does create a bunch of very real problems in the legal system, doesn't it? And potentially just blows the whistle as much as a report would.
Yes to all of that, Senator. It's one of those difficult situations where there's not a clear answer, but it's also, I guess it's come into prominence maybe because of the reporting obligations that are sought to be introduced, particularly SMR reporting. I don't have an easy answer to that question. No, I don't think there's any jurisdiction come up with a clean answer to that issue.
But it's a definite problem, and ideally we would be seeking to address it, having been raised with us. I mean, I can just see the very real practical problems. If a barrister just sort of says to the court, I'm ceasing to act, the court wants an explanation why on day 3 of a trial the barrister is ceasing to act, and the barrister says, I can't tell you. That seems to me to be, a direct conflict between the duty to the court and whatever statutory obligations have been put in this legislation, and I think we should have an answer to it.
I'm not sure there is I'm not sure an answer has been found. It potentially puts the lawyer in a situation where they commit the tipping off offence, which we don't wish to do. It is perhaps part of this solution to this is education of the legal profession and the judiciary in regard to this particular issue and others as well. Because
Senator
there may be...
Senator Shoebridge, I will have to... Senator Shoebridge, you do need to share the call. Senator Shoebridge, I'm calling you to order because I've given you an indication a few minutes ago that I'd have to share the call. I know you're having a very helpful discussion with our witness, but I do need to share the call. Thank you.
Well, I might ask you to take that on notice, and to the extent that Court Member has any observations, that would be very helpful.
Great. Thanks, Senator Shoebridge. Appreciate that. I will try to keep my questions brief because I am conscious of time. But I think the witnesses in front of us are really uniquely placed to give us some evidence about what the risk of not progressing with these reforms would be. And to your point, Ms Mason, in your opening statement, you talked about the cost burden on corporate Australia if we don't pass the reforms. And that's because of Australia potentially being grey listed. Can you explain what being grey listed means and what the impact would be on the economy?
Yes, absolutely. Thank you, Chair. Essentially, being grey listed by the FATF would mean that Australia would enter an enhanced sort of process of monitoring. You will hear from far sort of more updated people this afternoon around recent changes to the FATF methodology. That means we are in fact of greater risk of being grey listed by the FATF due to a new sort of methodology that's being introduced for the next round of mutual evaluation that would see sort of a two-option or two-tier approach to being for us being selected for grey listing. Now, what that means for commercial Australia and doing business with the rest of the world is that just like we, entities do due diligence on their customers, international counterparts doing business with Australia do due diligence on us. And if we are escalated to a grey listing level, that means automatically all of the international providers of jurisdiction risk registers at an operational level. So at an operational level, that looks like somebody running a list in relation to their risk assessment in their business. Australia and the counterparts to those transactions in Australia will be needed to be escalated to a higher risk. Now, operationally, that means that those international entities need to have additional resources to do their due diligence on their counterparts in Australia. And in terms of doing business, that is not in Australia's interest to have that level of scrutiny from the FATF.
And it's
Senator, I might just add to your question.
Thank you, Mr. Moore.
Out of the current 40 FATF recommendations, as of this year, Australia is partially compliant with 6 and non-compliant with 4. So 10 of the 40 recommendations, we are essentially failing at this stage. The 4 that we are non-compliant with, and this is really important in terms of the passing of this bill, include the regulation of these gatekeeper professions, but also, that hasn't been discussed, is the creation of a public beneficial ownership register, which is a key defence in combating tax fraud and money laundering and arguably terrorism financing as well. Just quickly on the risk of grey listing, it's hard to know the exact economic damage to Australia, but research shows that countries on average that are grey listed experience an average of decline of 7.6 in GDP and 3% of foreign direct investment on average when countries are grey listed, Senator.
What was that last figure you gave, sorry?
3% decline in foreign direct investment and 7.6% decline in GDP.
And just to add to that, Senator, that was an International Monetary Fund research paper on that matter, which we're happy to sort of identify as well.
Yeah, that would be helpful if you can provide it to the committee or the reference. I was just having a look at some of the countries on the grey list, not to cast dispersions more broadly, but they're not, from a financial risk point of view, they're not countries we would want to be associated with on that list. We've got countries like Haiti, Lebanon, obviously, quite a lot of African countries, also Syria, Yemen, and a few other countries in Southeast Asia. What is the time frame that we're working with here? Because I understand that we will probably be implored to defer these amendments. Parliament will have to consider when to make time to pass legislation like this. What sort of time frame are we looking at? Is it at the end of next year or is it the end of this year before this grey listing might occur?
Senator Greener, I understand that the Attorney-General's Department is speaking this afternoon, so I'm going to speak sort of given my own understanding. We understand that the FATF mutual evaluation on-site will take place in December 2026, and that's sort of the drop-dead date. Once that delegation leaves Australia, that's the date at which our evaluation is considered to have been conducted. So look, it leaves us very short of time, and that's from an industry perspective as well. Our challenge with what's been proposed in the Act and rules is that we're very aware that the organisations and the proposed changes, especially for existing reporting entities, are significant changes to sort of technology and infrastructure as well, which require budget approval. So the reporting entities we're currently working with are going to struggle to meet these timelines and essentially will be non-compliant because given the approval processes and budgetary constraints in the commercial sort of cycle, they wouldn't get these changes approved before, say, June next year, and it would take them 12 to 24 months to implement. So, you know, there might be other considerations that government might consider because, as we mentioned, we wholly support the progress of this bill, but there may need to be other considerations around implementation timeframes, notwithstanding the fact we know AUSTRAC plans to do a sort of a very consultative drafting of the rules.
Mr. Moore, I've got a specific question for you about the real estate sector. We'll get some evidence from the AFP who are patiently waiting behind us. Thank you. About the types of activity that we're talking about, but I just wanted to ask you specifically from the work that your organisation undertakes. How is Australia's real estate sector being used by criminals? And why should they be included in these reforms?
Sure. I'll point to three responses, Senator. Firstly, real estate accounts for about 65% of all assets seized by the AFP last year. So we know there's a large amount of criminal money that's being parked in the real estate sector. Our submission also outlines numerous examples of where foreign funds have been parked in real estate by corrupt officials and foreign criminals as well. The second point would be that the real estate sector is very well placed to undertake customer due diligence checks, report suspicious matter reports, because they're dealing with customers every day. They're almost the gatekeeper. They are the gatekeeper in the front door to the real estate sector and the purchasing of property in Australia as well. It's worth noting that 4 out of 5 large real estate agents in New Zealand are already reporting under these laws, and many other real estate agents are already reporting in other countries. So there's a lot of practice and guidance that can be drawn upon. And thirdly, we know that AUSTRAC's identified it, the AFP's identified it is a high risk vulnerability for our money laundering defences, and that's real estate. So it's really important the real estate sector plays the important role that they can play to combat money laundering, but also detect it and prevent it where possible as well.
Thank you very much. I have so many other questions, but we don't have any more time, unfortunately. But thank you very much for your evidence and for the work that you're doing. The committee will suspend for a very short break. We'll reduce that down to 5 minutes, and when we come back, we'll have the AFP in front of us. So thank you very much. through the statement that I need to make before our other senators. I think we have everyone in terms of quorum available, so thank you. I now welcome representatives from the Australian Federal Police and the Australian Criminal Intelligence Commission. Thank you for taking time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, can I ask you each to please state your full name and the capacity in which you appear today? And we'll start with the AFP. Commander.
Kate Ferry, Commander Investigations of Eastern Command in New South Wales. Was that it? Yes, thanks.
Stephen D'Amato, so I'm the Acting Deputy Commissioner of Crime for the AFP.
Thank you very much.
Morning, Chair. Matt Rippon, Deputy CEO of the Australian Criminal Intelligence Commission.
Thank you very much.
Morning, Chair. Jason Halls. I'm the National Manager of the Examinations Capability for the ACIC.
Thank you very much for being with us today. Do either of your organisations have an opening statement to make before we go to questions?
I do, Chair.
Thank you very much. We'll start with the AFP.
Thank you. And good morning, and thank you, Chair, and thank you to the committee for this opportunity to appear here and to discuss the Anti-Money Laundering and Counter-Terrorism Financing Amendment Bill 2024. So money laundering is the lifeblood of organised crime, and money laundering not only enables criminals to benefit from crime, but also funds further criminal activities. Working to stop the flow of illicit finances is a central pillar of the AFP strategy to disrupt and deter transnational serious organised crime networks. The AFP plays an important role in Australia's anti-money laundering and terrorism financing framework and greatly benefits from financial intelligence gathered under the current regime. Money laundering enables criminals to benefit from or facilitate a broad range of serious crimes. For example, drug trafficking, foreign bribery and corruption, people smuggling, forced labour and fraud. Money laundering strategies can disguise money being used to finance terrorism. Organised criminal groups employ evolving technologies to obscure illicit wealth, moving profits quickly across borders, converting them into numerous asset classes and disguising beneficial ownership through complex arrangements. The AFP is responsible for investigating the money laundering and terrorism financing offences in the Criminal Code. We have an enterprise-wide money laundering strategy that prioritises the targeting of Australian and offshore money laundering organisations, serious self-laundering syndicates, as well as professional facilitators and their criminal clients. But we do not work alone. The AFP-led multi-agency task force AVRIS with the ACIC, AUSTRAC and Border Force, as well as the US Homeland Security investigations, targets money laundering organisations, professional enablers, serious self-laundering syndicates and their criminal clients. Last financial year alone, we charged 38 people with money laundering offences. The AFP also hosts the Joint Threat Financing Group, which brings together the resources and expertise of the AFP and AUSTRAC's specialist financial capabilities to work with private industry and Commonwealth partners on national security investigations into terrorism financing. Since 2002, 22 persons have been charged in relation to terrorism financing, including charges for terrorism financing, sanctions offences and supporting foreign terrorist fighters. The AFP also leads the multi-agency Criminal Assets Confiscation Task Force, so we refer to this as the CACT. The CACT has primary responsibility for investigating and litigating the restraint and confiscation of criminal assets under the Proceeds of Crimes Act 2002. The CACT restrained more than $500 million between 1st of July 2022 and 30 June 2024 in suspected criminal assets. These figures clearly speak to the significant and growing threat and the extent to which money laundering and terrorism financing disrupt the economy and weaken our community. In our view, the expansion of the AML-CTF framework into Tranche 2 services is long overdue and improves Australia's ability to counter vulnerabilities targeted by criminality. The AFP's criminal and proceeds of crime investigators see time and time again lawyers, accountants and other advisors either knowingly or unwittingly involved in organised crime. We also know that real estate, precious stones and metals are common vehicles for laundering. These reforms will provide a new source of critical intelligence for the AFP's investigations, but more importantly, they will harden these industries against infiltration and exploitation by money laundering organisations and other criminal enterprises. They will improve Australia's ability to deter, detect and disrupt money laundering and terrorism financing. Finally, this bill also helps to modernise that framework and keep up with new technologies such as virtual assets. This is critical to ensuring Australia's financial systems are sufficiently hardened against the contemporary threats of money laundering and terrorism financing. Thank you, Chair, and thank you, Committee, and we welcome your questions.
Thank you. Mr Rippon, do you have an opening statement?
Chair, no, our submission is as read and we're ready to take questions from the committee.
Great, thank you. We'll start with Senator Scarr.
Thank you very much, Chair, and thank you to the witnesses for appearing. Going through the examples in both the AFP and the Australian Criminal Intelligence Commission submissions, there are clear and strong examples with respect to issues involving gatekeepers and money laundering. Most of them, though, in terms of the examples which are given, are examples where the gatekeeper, if I can put it that way, the lawyer, real estate agent, has almost been involved in the criminal enterprise itself, as opposed to falling in the unwitting category. I'd like to understand better how these gatekeepers can be unwittingly involved in money laundering, as discussed in the opening statement and opening comments.
Senator Matt Rippon here from the ACIC. Thank you for your question. I think you're correct in that there's a spectrum, if you like, of complicity from professional facilitators, whether they be lawyers, real estate agents, accountants, etc., from, as you describe, an unwitting participant right through to someone that is fully complicit in the transnational serious and organised crime business model. So there's a spectrum there. How do they become unwitting players in the game? Well, they're at times shielded from the broader picture of the criminal enterprise and asked to do compartmentalised tasks within that enterprise. So they're not fully aware of the full activities of the enterprise, and the ACIC and our partners at the AFP and other agencies have reported publicly before that many of the highest threat transnational serious and organised crime groups and the heads of those groups are located offshore in what we would call jurisdictions of risk, etc. So local real estate agents, lawyers and accountants might not always be conscious or aware of the full spectrum of activity that head of an organised crime syndicate might be responsible for, and deliberately so. Organised crime groups deliberately compartmentalise their activities so that they can protect themselves from prosecution and law enforcement and intelligence activity.
Can I? Okay, so I guess the point I'm not grappling with, but trying to understand is the examples which are given. You know, they're quite clear and obvious. The lawyer, the real estate agent, the accountant are actually, I'd say, part of the criminal enterprise itself, right? Whereas we're trying to introduce a regime that would apply to thousands of say, small accounting practices, small legal practices, real estate agents who are not members of criminal enterprises, and to the extent that this issue touches them, it touches them without their intent or their or any deliberation on their part. So from my perspective, it's trying to get the balance right in terms of what regulatory burden we impose, especially on the small end of the sector, what is actually proportionate to the risk. Is it, from your perspective, in terms of one of these gatekeepers actually complying with the law, being able to identify a suspicious transaction which should be reported, would it be reasonably clear as to whether or not it needs to be reported, or to what extent are there matters of fine judgment? To what extent will practitioners simply report everything because they want to cover themselves? How someone who doesn't have the depth of understanding in relation to how organised crime works, how are they meant to identify or flag matters which are genuinely suspicious, especially when you're dealing with such sophisticated organisations, I guess, that do the sorts of things you refer to in terms of compartmentalising and trying to make their activities as opaque as possible?
Stephen D'Ameto here, Senator from the AFP. Just to go back to the point about these professions are open to exploitation. So one of the operational benefits of this legislation is actually hardening the environment, because making access to these sectors more difficult for the criminals makes their life a lot harder. A good example in our submission was Operation Fuji and Echo Stealers. That's a joint AFP Victorian Police operation. It's alleged in that operation that one individual, yes, he was in one of the professions, but he was charged with laundering $20 million. But he used a range of other accountants and real estate agents to invest that money, who were unwittingly involved, to invest that $20 million, which were the proceeds of crime, into different real estate. Now, the trouble for law enforcement is that there is intelligence gaps there when this money, and similar to what my colleague said before, they compartmentalise different parts, buying different property with different agents. If there was reporting that came in regard to that matter, then it gives an opportunity for law enforcement to understand the vulnerability and understand the actual operation in regard and what they're trying to do in regards to that specific operation. So that's just in regard to, I suppose, an example where the gaps are because of that compartmentalised and because we don't have all the pieces of information, given that they spread that risk around. What I should say in regard to what they should report and not report, I know AUSTRAC will be appearing with in front of you later this afternoon, but what's a suspicious transaction? I mean, we can give examples where they pay deposits for large amounts of property in cash, and then the question needs to be asked: where does that cash come from? And it's about knowing your customer and customer due diligence in relation to that. There's circumstances where an individual may not explain the sources of that cash, or the manner that it was provided may be unusual in some sort of way that the real estate agent or the other services are not used to. So these would be just very simple examples, Senator, where...
I think sorry to interrupt. I think obvious there's a whole range of transactions, I think, which are just manifestly suspicious, right? So someone comes into my office and says, I'm going to pay for this house with 50 instalments of $9,990, whatever it is, right? It's clear you'd be a deal not to understand it's suspicious. I guess I'm trying to get a feel for, well, if I'm dealing with someone who appears reputable on the face of it, and they said, well, I made this money through investments and the transaction seems to run like any other ordinary transaction, to what extent do I need to delve into it to really, what's expected of me as a gatekeeper, as an accountant or a real estate agent who's moving on to my 150th transaction of the year? Is it going to be clear to me as to when I need to report something or not report something? That's the distinction I guess I'm grappling with. At the extremities, I think it's clear, right? But I'm trying to bring the scale back to areas, given the sophistication of some of these organisations, where it isn't so clear, and unless you've got some sort of degree of insight, which you only get being a specialist like yourselves, I might continue to be unwitting, to use that word, and to what extent is this regime going to uncover intelligence which would not otherwise be uncovered?
Senator, I don't want to talk too much in the regulatory space because we are an intelligence agency. However, you did use the term using judgment. And I think that it is difficult for folks when they're dealing with multiple clients, but they have obligations to conduct due diligence, and you do that by asking questions, and you get a feel of all the component parts of the business enterprise or individual that you're dealing with when you ask them questions. So acknowledge that it is difficult, but you've got that spectrum that you talked about, and the Chair referenced earlier this morning that there are bad actors in every profession, but it doesn't necessarily reflect on the entire profession. And when we're talking about examples that we've seen at the ACIC and the AFP, where you've got real estate agents or accountants and lawyers being delivered bags of cash to send offshore or to integrate into other legitimate systems, then obviously that's a clear issue around reporting and a bad actor. However, I understand what you're trying to say around the difficulties, but it does come down to judgment and conducting due diligence and asking the right questions. And I'm sure the regulator this afternoon will have some observations around that.
Senator Scarr,
just my last question.
Scarr, I do need to share the call. If you could have one last question, thank you.
My last question. In terms of this concept of politically exposed people, and of course I understand the necessity for greater focus to be based on people of that nature. To what extent are there systems or processes that especially a small firm can tap into to actually uncover whether or not someone is a politically exposed person or they've got some sort of familial connection to someone who's a politically exposed person? In particular, if you're dealing with foreign countries, how easy is it to identify? Clearly you can ask someone, but if they say, well, no, I don't have any connection to a politically exposed person, and they're the cousin of a general from Sudan, how are you going to find that out? To what extent will the gatekeepers be able to tap into intelligence that's available and collated by government agencies and etc. to actually uncover what they need to uncover to determine or assess the risk?
So, Senator Kate Ferry, I'm the Commander of Investigations for Eastern Command. I sit over the Money Laundering Task Force for the AFP and lead the Money Laundering Strategy for the AFP. My understanding, and again, I think it's best addressed to the regulator, but I understand it would be the same way financial institutions do now, that they can run that name, and it is really about verifying the identity of the people or the customer that they're dealing with, and then checking that against the name that is held in the same way that banks and tellers do that at the moment.
Thank you. Senator Scarr, I need to share the call. Senator Shoebridge, do you have questions?
Yeah, I do. Thanks for the submissions that you each gave. There is a very real concern that, I'll just give you a concrete example of a jurisdiction like China, where somebody one day might be politically in favour with the regime, might be, in the regime's eyes, a successful business person. The next day ceases to be in political favour of the regime and then becomes a targeted criminal. And, you know, those changes are notorious. many people would see that as a politicised use of the criminal justice regime in a country like China. What, if any, checks and balances do you have to ensure that Australia doesn't become an unwitting or even a witting partner to that politicisation?
My understanding, Senator, initially would be, so in regards to the industries we're talking today, they would put in a suspicious matter report if they believed there was a politically exposed person involved. And then it's a matter of us as an organisation, what offences are we looking at? Is it actually an offence in the criminal code that we're looking at in regard to that? Again, it would require offences to be committed and to follow the criminal code, and that would be, I suppose, the safeguards, for want of a better word, that we would be using in regard to this.
Well, I suppose I'm asking you to test, if you form the view that the money was laundered from a foreign jurisdiction, on what basis are there any checks and balances to ensure that we're not playing a part in the politicised use of the criminal justice system? And I'll give you China as a notorious and actual example. What do you do to ensure that we don't play an unwitting or witting part of that?
Senator, are you talking about illicit funds coming from China, or are you talking...
Yes, funds that China identifies as illicit.
Yes.
And I gave you, I won't repeat the preliminary question that I put, but those circumstances are in my mind.
So the AFP does not determine who is politically exposed person and who is not. That's not something that we can comment on. But absolutely, there are funds from all different countries that come into Australia that are illicit and that are used as they use Australia as a safe haven to store illicit wealth.
Look, I accept that. What I'm putting to you, though, is there are jurisdictions around the world that are quite willing to politicise their criminal justice system. Somebody may be perceived as a legitimate business person one day, but the next day they fall out of favour. A politicised review, criminal justice review, is done. It's alleged that the money was unlawfully obtained and laundered or the like. They then become persona non grata, and then we then participate in that political attack on them. What checks and balances are there to ensure that doesn't happen?
Senator, for the AFP, there has to be, whether they're politically exposed or not, a criminal offence in Australia. So we would just look at that in terms of whether a criminal offence has been, that money is laundered criminally and is an offence within Australian law.
But the threshold for money laundering is the money was obtained illicitly in some fashion overseas. And I'm asking you, what, if any, checks do we have? In that case, what, if any, checks do we have that assertion by an overseas jurisdiction is not politically based?
But the legislation does go into things, uses terminology like general crime or a predicate offence has to be identified. So just from the examples that we have used and examples where we have charged people with money laundering, we have been able, our case is around that this money has come from, whether it's been a fraud, whether it's been from drug importations, organised crime.
All of that is clear. If you have evidence of fraud, drug importations, that we're not talking about that. We're talking about circumstances where there is an assertion that perhaps fraud might be the example. There is an assertion of fraud based upon what may well be a political prosecution in a foreign country. If the answer is there aren't any checks,
yes, Senator, there's very
then that's fine.
Those sort of matters. Predominantly, the money we see coming into Australia, we investigate under Australian law and not at the request from another country. If that makes sense. I can't think of any
only one would be enough for me. If we were to provide information or arrest or prosecute somebody because of the a political determination by another jurisdiction, only one would be enough for me. So when you say very few, that's cold comfort. How many are we talking?
I can't think, I would have to take it on notice. I can't think of any in my time in the AFP that we have done criminally on behalf of another country.
Could I ask you about, under this regime, if the information is provided, well, perhaps that's the AFP, how about our other witness?
Senator, nothing to add to the AFP's evidence there from an intelligence perspective.
So it happens, but it's not common?
No, I don't have any evidence to offer.
Evidence.
I don't have any evidence to offer around whether it does or doesn't happen. I can take that question on notice so I don't mislead the committee.
Do you have any? Can you provide any assistance on what checks and balances are in place to ensure that we're not a witting or unwitting accomplice in a political prosecution?
Can I just, sorry, Chair, I'll just, hopefully, Senator, this will help. End of the day, we still need to meet the elements of the offence. If there's money going through an individual here and information's come from a foreign country, if they can justify that it's legitimate money, there is no issue here. There's not. I suppose it becomes to whether the money is legitimate or not legitimate. Now, I understand what you're saying about potentially that money could change. If I understand, Senator, and I apologise, but it could change, go from legitimate to illegitimate, depending on the instructions of a foreign country. That does not occur for us here. But we still need to meet those elements of the offence that I described before.
Senator Shoebridge, I'll have to share the call in a moment.
But I was asking that question of the Australian Criminal Intelligence Commission, and I assume you're taking that on notice too.
Hi, Senator. Jason Hall from the ACIC. Yes, look, I'll have to take it on notice. I can say that if it was a foreign jurisdiction that reached in to suggest that some illicit funds or funds coming into the country was illicit in nature, I mean, the checks and balances that you're asking, we would look into that, and certainly the AFP, not speaking on behalf of those, but I can't think of any that has occurred.
They didn't.
Pardon me?
The AFP said they didn't. The AFP said they didn't. That was their evidence.
Yep.
So you must have heard different evidence than what I heard just 5 minutes ago. They said they didn't do that.
Thanks, Senator Shoebridge. I'll have to share the call. Senator Polly, you have the call now.
Thank you, Chair. And thank you for the submissions and the evidence you've given us thus far. But I just wanted to recap, actually, what is actually being observed in terms of the gaps and the vulnerabilities that exist now without the change of this legislation to the AFP.
Yep, thank you, Senator. I can answer that question. So I suppose we should start off to say that these sectors, both internationally and the word gatekeeper has been used, are considered high risk for the use of money laundering. And a lot of that's got to do with the skill sets they got as well. And money launderers are trying to hide the money, the source of the money, and the skill sets used by especially the professions, is a big part of that. What's missing is that what we get out of this legislation is not only, as I stated before, about hardening the environment, but the services that are to be regulated hold a lot of information and insights into not only criminal investigations, but also our asset confiscation action. And that's particularly around serious and organised crime. So when we're looking at things like real estate agents, as we said, as I know it's been evidenced before, but I think the evidence was before you received about how much has been seized as real property. I can say to you from 1st of July 2022 to 30th of June 2024, $354 million has been seized in real property, restrained in real property, I should say. That's 68% of the total property. So that tells us that it's clear that organised crime groups are using real estate for their proceeds of crime. And as I said in my opening statement, this is not just for the personal benefit of the criminal groups, this is to reinvest in criminal activity. So this is the sort of money that we are talking about, that they reinvest in criminal activity. In regard to professional services and a whole range of other things, again, the information they hold allows the AFP then to get an idea of what the organised crime groups are up to, how they are moving money, and also helps us then to understand the vulnerabilities in the Australian sector more broadly and the risks in relation to that. I should just say something, of course the legislation also includes precious metals and stones. This is a very common way of people making significant purchases of these items. They keep their value. They're very easy to move across borders without disclosing. And so, again, that's a very vulnerable way that is used by organised crime groups to move large amounts of money without having to go through the risk of moving actual cash, either through the system or through smuggling it across borders. So what this bill really does, one of the key benefits for the AFP, but for our intelligence agencies as well, is really highlighting those intelligence gaps and giving us an understanding of the sector.
Thank you for that. The issue around real estate, as this inquiry is all about law enforcement and protecting the community, but using money that's being laundered to push up property prices impacts on all Australians. But can you also outline to the committee the connections between money laundering and terrorism, child abuse and the other heinous crimes that are happening and the impact that's having on our communities?
Yes, I'll start off with terrorism, Senator. So terrorism, you probably don't see the large amounts of money that we're talking about in regards to terrorism. But there's certainly a motivation for these groups to move money, to hide the source. And of course, the danger with terrorism is where the money's going to, because that's likely to fund the actual terrorist act itself. And so that there is that motivation in regards to terrorism to hide the source of the money, and some of it can be legitimate money, some of it can be illegitimate money, that to then conduct a terrorist act. And the same could be said about the child exploitation space. The money used in that criminality, again, there's a lot of motivation for the criminals to hide the source of the money, to hide how that money moves through the system. And so that's where the benefit of this, we know that there are specific skill sets with lawyers and accountants, for example, that they can set up companies, they can set up structures to hide money. Again, as I stated, Senator, that this gives us the opportunity to fill in those intelligence gaps.
Just taking on from, you touched then on the business community, how is this crime impacting and abusing Australian businesses? And is there not a real danger currently of infiltration of those criminal syndicates into Australian businesses now?
So, Senator, when we say businesses, are we talking about the professions subject to the legislation?
Well, into those, but other businesses as well.
Yeah, so we've a number of examples, which I'm happy to go through, but there was a number of examples in our submission where lawyers, accountants were being used and were part and arrested as part of these syndicates, whether it's to do with laundering money and obtaining the benefits from a tax fraud, or also in relation to money laundering organisations. We've seen lawyers and accountants involved. Similar to this previous question by Senator Scarr, that they actually are involved and have got into these industries, for want of a better word, to use to move those proceeds for those organised crime groups.
Senator
Can
Polly,
you just outline?
Senator Polly, I'll just add to that, if it's helpful, that the business model of transnational serious and organised crime means that they adapt to the environment as legislation changes, they adapt to the environment as law enforcement have successful disruptions, and they move across various ventures and methodologies as the environment changes. So the legislation and the bill as proposed does help to provide a better intelligence picture of those methodologies and allows us to better and more effectively and efficiently target those compartments of serious and organised crime so that we have a better opportunity to harden the broader environment. Shifting from professional facilitators as an accountant or a lawyer to moving money through luxury goods, vehicles, jewellery, high-end jewellery, real estate during COVID, being focused on the movement of Daigao arrangements, all a demonstration of the characteristics of transnational serious and organised crime to jump from opportunity to opportunity and look for weaknesses in the system. And this bill and the proposed measures from an intelligence perspective help us to get a much better threat picture of what's coming down the pipe for the Australian community and to help protect businesses and identify vulnerabilities for them.
Senator, sorry, Jason Halls from the ACIC. I just might add, my colleague over there, Commander Ferry, and myself have just returned from our Five Eyes meeting over in the US around money laundering, and the issue of money laundering is not unique just to Australia, obviously. And talking about really the diversity in which those serious organised crimes groups use and the various means by which they use to move value, obfuscate the proceeds, etc., is always a challenge for law enforcement and us as the Criminal Intelligence Agency.
Senator Polly, I'll have to give you a wrap-up and if you've got one more question.
What I was going to ask then from the ACIC and also from the AFP is if they could just explain the tangible operational benefits from this new law and how it's going to impact law enforcement and the work that ACIC actually do.
Senator, yes, from an ACIC perspective, as you know, from the briefings that we've held with your other committees also, we are primarily a criminal intelligence agency. Our job is to assist our partner agencies in painting the strategic threat picture for the country and then assisting the collection, assessment and provision of intelligence through a range of capabilities, both covert and overt, to be able to assist our partner agencies point their apparatus towards that threat in a more effective manner. So from a functional perspective, that's the ACIC's macro role. In relation to this bill, as I mentioned in evidence earlier, this is about getting a better appreciation and access to some of the conditions that are presenting themselves across sectors of business that we may not have had as much of visibility of in the past. So hardening of the environment, opportunities to have access to broader intelligence and data sets lawfully through our arrangements in task forces and memorandums of understanding to then conduct our statutory role to assist our partner agencies.
Thank you. And from the AFP, just briefly, I think.
Yes, and I'll be quick because we agree with everything my colleague has here said. But what I just want to really highlight 2 points maybe not being covered, that this helps us then identify further criminal offending because follow the money is very much key to what we do, not only in the terrorism space but in the organised crime space as well. I also think this will raise awareness of the vulnerabilities for the sector itself and the sectors themselves, and also gives them a legal mechanism to report suspicious activity now that becomes available. I might just pass my colleague very quickly because I think one thing that we haven't highlighted is that it does enhance our international partnerships as well.
Senator, it does. I'll just quickly first say also that financial intelligence is the #1 capability that any investigator within the AFP has to investigate any crime. So whether it's money laundering or human trafficking or cybercrime, if you have financial intelligence, you can do anything. And the better that quality of that intelligence is, the better those investigations are going to be. And more importantly, obviously, a lot of the crimes that the AFP investigate are international now. We need to be able to pass good quality and timely intelligence to other partners, trusted partners internationally, and they do the same to us. So it's coming up and where they are also at and being able to provide that information.
Thank you. Thanks, Chair.
Thank you very much, Senator Polly. That's all the time we have for questions, unfortunately, but thank you very much for your submissions and your evidence today. And if you've taken questions on notice, we'll give you a date to return those to the committee by. Might be a bit of a short turnaround, but we'll see how it goes. So thank you very much. We'll have a swap over of witnesses at the table, so just give it a moment. But I now welcome representatives from the Real Estate Institute of Queensland joining us via video conference. And we also have the Property Council of Australia, who I believe are joining us in person but also on video conference today. So we'll just wait until they can come to the table. I'll read out my introductory remarks. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witnesses and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can I ask you to please state your full name and the capacity in which you appear today? We can start with REIQ.
Good morning, Antonia Mercarella, Chief Executive Officer of the Real Estate Institute of Queensland.
Thank you. And the Property Council of Australia?
Thank you, Chair. Dan Rubinak, National Policy Manager, Capital Markets at the Property Council of Australia.
Thank you. And joining us online?
Jeff Mooney, Head of Compliance for Stockland Group, attending in conjunction with Dan from the Property Council.
Great. Thank you for joining us today. Apologies that we're running a little bit behind time, but we're catching up. So
there was one more, Chair.
Oh, sorry.
It's all right. Can I also add, I'm Tamara Davies. I'm Head of Ethics and Compliance at CBRE and here as a representative of Property Council of Australia as well.
Okay. Thank you very much. Sorry for skipping over you. Do either of your organisations have a brief opening statement before we go to questions?
Yes.
Yes, there's some nodding. We'll start with the Property Council of Australia and then I'll come back to REIQ.
Thanks, Chair. Good morning, Chair and committee members. My name's Dan Rubinak. I'm the National Policy Manager, Capital Markets Division at the Property Council of Australia. Firstly, on behalf of the Property Council, I wish to acknowledge the Ngunnawal people as traditional custodians of the land that we're meeting on today and recognise any other people or families with connections to the land of Canberra and the ACT region. Obviously joined today by teleconference by Tamara Davies, Head of Ethics and Compliance Pacific at CBRE, and Jeff Mooney, Head of Compliance at Stockland. Both are very valued members of our Property Council Corporate Governance and Regulation Committee and have made themselves available for the committee today, and I thank them. As the committee would be aware, the Property Council represents the owners, fund managers, superannuation trusts, developers and investors who intersect with Australia's property industry, shaping our cities, creating the homes that Australians need, while providing the jobs for more than 1.4 million Australians. Our submission raises a number of outstanding matters which we have identified as requiring further investigation. These include land lease and residential site agreements, as well as initial refundable deposits, and I would refer you to those. Throughout our engagement with the department over many months, we've seen a significant improvement in the proposal from government. Firstly, the department agreed with our view to remove a number of low-risk, high-volume transactions, which would have made the regulations exceptionally onerous, including residential tenancies, commercial leases and property management. Recently, the department has clarified the status of auctioneer services as well as the provision of services between related bodies corporate as being outside the regulation, which has been welcomed by industry. Of course, for real estate professionals, the impact of additional regulation will differ depending on the size and function of the business affected. My fellow witness from REI Queensland, as advocates for many of the smaller businesses in our industry, are best placed to advocate for their needs. The Property Council, Ms Davies and Mr Mooney are available to discuss the impacts on our larger and largest businesses. To be clear, from our perspective, the key takeaway for this committee is to encourage the Parliament to pass these reforms before the end of the year. It's very clear that Australia needs to reform its processes before the next mutual evaluation period with the Financial Action Task Force, which is to take place in 2026-27. The sooner the bill is passed, the sooner the regulator AUSTRAC can engage properly with industry to develop the AML-CTF rules and then the AML-CTF guidance for real estate professionals. Any delay to the reforms at this point would just introduce further uncertainty for business and create risk for Australia's property industry, which would be regrettable. I thank the committee for its time, and we're available to answer your questions.
Thank you very much. We appreciate that. And the Real Estate Institute of Queensland, do you have an opening statement?
I do, thank you. Good morning, Chair and committee members. I would also like to begin by acknowledging the traditional custodians of the land on which I sit today, the Turrbal and Yagara people, and I wish to extend my respect to their elders past, present and emerging. Thank you for the opportunity to provide our views and input into this important proposed legislation. The Real Estate Institute of Queensland, or the REIQ as we're more commonly known, is the state's peak body for real estate, representing the profession here in Queensland for 106 years. We provide training, advocacy, support and advice to Queensland's real estate community. And in addition to that, we also provide education and support to the broader Queensland community. REIQ, via its membership model and other service offerings, represents around 45,000 property professionals, and this comprises principal licensees, salespeople, property managers, auctioneers, business brokers, and of course commercial and industrial agents. The REIQ is supportive of the government's commitment to these important statutory protections. We understand the importance of combating money laundering and preventing criminals from engaging in transactions to disguise the origins of funds connected to illegal activity. Although we do support the proposed regime, we remain concerned about the compliance costs and administrative burden of extending the regime to real estate agents. We wish to make a number of key preliminary comments and recommendations. As the peak body in Queensland, we know that the majority of Queensland real estate businesses do not possess the resources, skills or expertise to comply with onerous AMF and CTF laws. We believe there is an opportunity to significantly reduce the cost and administrative burden by using technology. By way of example, an existing platform like the PEXA Exchange, we believe this could be used to dramatically reduce compliance burden. We know that the PEXA Exchange is classified as critical infrastructure by the Commonwealth, and of course today it is responsible for around 90% of all property transfers across the nation. Under our recommendation, real estate agents would certainly still play a vital role, undertaking tasks like mandatory verification of identity and monitoring suspicious behaviour. So in conclusion, the REIQ supports the government's commitment to protecting the integrity of Australia's financial system and improving the AML and CTF regime to ensure it's fit for purpose, responds to the evolving threat environment and meets international standards. However, we do remain concerned about the impact that this will have on real estate businesses. We acknowledge the difficulty in developing an appropriate regime that meets the core objectives. Nonetheless, a balanced and practical approach remains critically important and appropriate. Thank you.
Thanks very much. We'll go to questions from senators, and I'll hand the call to Senator Scarr. Is there and ready to join us, I think. Senator Scarr? I can always hand to Senator Polley to kick us off if we... Yep. Senator Polley, do you have questions?
Yes, Chair. Okay. Thank you
We'll come
very
back
much.
to Senator Scarr.
Yeah, so I'll put this to the Property Council. What will be the impact of Australia being grey listed, and why are you concerned? You referenced some significant negativity about the impacts on capital flows interest stream based on a recent IMF paper. What would this actually mean in practice?
Thanks, Senator, for your question. And obviously, very importantly, we've front-ended our submission with a discussion on that grey listing. We thought it was very important just to bring that to the attention of the committee to sort of preface the discussion that we're having on this bill. You've referenced the IMF paper in 2021. It makes it very clear that there would be large, significant negative impacts on grey listing on capital inflows. I think they've referred to a figure of around 7.6% of GDP. To be taken with a grain of salt, though, of course, I believe much of the data they refer to was in emerging economies. We'd need to do a bit more work about what the impact of grey listing would have on certainly a developed economy such as Australia, and I don't profess to be an expert senator on that fact. But I think just more generally, the impacts of grey listing, which we understand as an industry, and this is certainly something we suggest the committee engage with the department to really dig down into as well. But certainly there would have to be a higher level of international due diligence for entities that are in grey listing countries. So there wouldn't just be an obligation on us to do something, obviously to fall into line, eventually be compliant with the FATF standards. But when the international community looks at this country and deals with Australian businesses, they would have to undergo exceptionally more due diligence than they would already if we were considered to be grey listed. Obviously, the costs of cross-border transactions would increase, as senators would be well aware. International investment is incredibly important into the property industry. I think of commercial property, for example, 2020-21, $82 billion worth of investment in commercial real estate. We need to be making it easier to get international money, international capital into this country to partner with Australian businesses. We shouldn't be making it harder. Of course, payment delays and supply chains, and I won't go into the details of the issues that we saw during COVID, but I think disrupted supply chains and slowed down supply chains, senators would understand the issues. I understand potential downgrading or consideration by rating agencies. And the big one, Senator, which I want to probably leave with you, and I understand through their impact analysis, the department has done a bit of work on what the impact of avoiding a grey listing would be in terms of a monetary figure. But I'm not sure whether we've actually been able to quantify, at least in a monetary figure, what the actual reputational damage would be, Senator, to Australia. So obviously not only to the financial system more generally, but certainly for those tranche 2 entities who are as yet unregulated. If we ever got to a process where we were grey listed as a country and tranche 2 entities such as real estate professionals, of which the Property Council represents many, if we were considered to be an unsafe jurisdiction because of money laundering risk or counter-terrorism risk or proliferation risk, that would be extremely regrettable, and we need to avoid that.
Thank you for that. I think it's fair to say that internationally more and more countries are moving in this direction, simply as you just outlined how detrimental it could be to their own countries if they're grey listed. But you also talk in your submission in relation to referencing the amendments and clarifications that you welcome for the property industry. With these reforms and simplifying and clarifying the regulations around money laundering, etc., can you just recap for the benefit of the committee, what this actually means?
In what respect, Senator? What will be required of our businesses?
Well, in terms of the clarification and the amendments that have now been made, does it not give more security and outlines much more clearly the responsibilities of your members?
Thank you, Senator. I think just going back to the point I made earlier in our opening statement, obviously we've seen a few things removed from the proposed regulation: residential tenancies, commercial leases, property management. We welcome that. Key to those points were those issues, whilst raised by the department at the beginning of this process, is my understanding not actually part of the recommendations from the Financial Action Task Force. So that is good news that those have been removed. And obviously through this process we've been able to get further clarification from the department on a myriad of other things which won't be included. I think the key point we're trying to make is That's all well and good, but it's probably very difficult and a big ask to expect the department or the government to include that in legislation when the legislation itself is not necessarily the place to explore those issues. In full transparency, we're having ongoing discussions with the Attorney General's Department, which we've welcomed, and they've been able to assist us in seeking a bit more clarity on some of the issues in our submission. I think the key point is we need to get to the next stage, Senator, to really drill down on these issues and get them sorted through the rules and through the guidance. But we can only start that process once this bill is passed. So if we're obviously got time considerations on both ends, Senator. We're coming towards the end of this term, the end of this parliament. We've got a mutual evaluation period in 26-27, if I remember correctly. There's a short period of time where we have to work with the regulator, work with the government on really fine-tuning these reforms to make sure they're the least onerous as possible, and we need time. So the sooner we can get the bill passed in that respect, Senator, the better.
Absolutely. Thank you very much. For the Real Estate Institute of Queensland, question to you. Are you aware that criminals and unlicensed agents are operating across Australia's real estate sector, including in your state of Queensland?
Thank you, Senator Polly. I don't have specific knowledge of such matters in terms of unlicensed persons carrying out real estate activities. Obviously here in Queensland and indeed across, I think, all jurisdictions, there is a requirement to possess certain educational qualifications and certain licences to be able to facilitate transactions. That said, there is no legal obligation, obviously, to engage a real estate agent to sell real estate or manage real estate. So certainly there may be persons out there who are acting as self-represented vendors.
So you're not and haven't been aware that there are in fact criminal groups and organisations that are using real estate to actually launder their ill-gotten gains through real estate, and they're looking for real estate as a very good option as it stands currently now to legitimise and clean that money for them. Is that not a worry to you?
Yes, Senator Polly, to be clear, that is clearly a concern of ours. We are aware of the statements that the Australian Federal Police have made, for example, in their submission, noting that real estate transactions have been used for that purpose. And of course, that concerns us as a peak body. That's illegal activity with real estate transactions at the heart of that illegal activity is something that is, of course, of concern to us.
So in those circumstances where we already know there's evidence that's been not only given in submissions, but we know that it is actually happening here in Australia. So what sort of regulation reforms, if you're not supportive of this legislation, what sort of reforms and regulations would the real estate sector be willing to accept? And can I ask you also, what consultation processes have you actually been part of around this legislation?
Thank you. The first point I'd like to make, and I'd like to be very clear about this, is that we are supportive of this regime. We are not opposed to it extending to real estate transactions, so I want to be abundantly clear on that point. What we are concerned about, however, Senator Polly, is the level of responsibility that real estate practitioners are expected to be responsible for. So we're simply saying that we think, as I've made in the point I made in my opening statement, is we believe that technology can play a critical role in making this easier for those tranche 2 entities. But what we're saying is that we We understand that most real estate businesses are very small businesses. There are many real estate businesses that are one-person shows or 2 people, or the vast majority are under 5 people. And what we're saying is when you look at some of the AML and CTF obligations, expecting real estate practitioners to undertake activities that currently are reserved for very well-resourced banking institutions and perhaps also far better educated legal practitioners, again, with more extensive resources. We're saying that we don't think it's reasonable to expect a real estate practitioner to undertake that full suite of activities. Where we think a real estate agent can play a vital role and again, acknowledging that the way that real estate transactions are facilitated will vary depending on where in the nation it occurs. But if I focus on Queensland, where I am, here in Queensland, a real estate practitioner has a rather unique right to actually not only negotiate the deal, if you like, but also to facilitate that contract all the way through to completion. So some of the activities that we think a real estate professional is well placed to undertake include things like verification of identity, and provided that we can develop clear guidance notes and rules, perhaps even reporting suspicious activities. But when it comes to the more onerous obligations, so things like source of wealth or PEP and sanction screening, we think those sorts of activities are not reasonable for a real estate practitioner to be expected to undertake. That's not to say that those activities aren't important, but we think that they can be performed later in the chain by the likes of legal practitioners and banks who are better placed and better educated to undertake those sorts of activities.
Senator Polly, I have to share the call if I can. You were sensing that, I think. Thanks very much.
I think I was.
Thanks very much. Senator Scarr, we've got you back. You've got the call.
Yeah, I found the right window, Chair.
That's good. The right button. Thanks.
Okay, thank you, and thank you to all of our witnesses, especially our friends from the REIQ Queensland. Thank you for all the great work that you do. Greatly appreciate the submissions that were made by everyone. I think just to go to REIQ first, as I understand the submission, essentially the REIQ recognises and accepts that there will be this added layer of regulation, but the question is around how real estate agents should discharge their obligations under that regulation and who should bear what responsibilities, and in particular, and this is where I'd like you to respond, in particular, what specific avenues are there to leverage off platforms, including the PEXA platform, to make sure that real estate agents can leverage off the KYC processes, etc., that have been undertaken by others in a real estate transaction. Can I just give you an opportunity to respond? Is that a correct summation of the REIQ's position?
Yes, thank you, Senator Scarr. Yes, really, we do. We understand the need for this regime to extend to real estate transactions. We are accepting of that, and some of the other evidence that we've listened to today has confirmed that that is appropriate. We're simply saying that we're really looking for ways that we can recognise the different level of education, expertise and resources that each practitioner or professional brings to that transaction. And this is why we say that real estate practitioners absolutely should have a role, and we as a peak body, for example, can play an active role in that too. So by way of example, REIQ runs a platform called RealWorks. That is a forms platform, and that is where the majority of virtually all residential sales and tenancy agreements are facilitated through that platform, and a good deal of commercial transactions also are facilitated through that platform. So as a peak body, for example, we could integrate some verification of identity technology that real estate agents could use contemporaneously when they're completing a contract, by way of example, and that seems a very straightforward process. Again, that aligns with existing statutory obligations that Queensland real estate practitioners already have to verify the identity of their clients. In this case, it would extend to both parties, of course, but again, we think that's quite proportionate and reasonable. And similarly, reporting certain suspicious activity could be something that, again, as a peak body, and with other peak bodies around the country who represent real estate, those are the sorts of activities that we think could reasonably be undertaken by real estate practitioners. And again, the more complicated processes and activities could come down the track. But to be clear, that's not us suggesting that a real estate agent simply steps away. The model that we're interested in specifically is one that is underpinned by reliance and information sharing. And so the platform, if you like, could be, the technological platform could ensure that that transaction cannot actually complete until those various AML and CTF obligations have been ticked off. And so to that end, the real estate agent could rely on that later party or that subsequent party being responsible for those activities. And so whilst they might not be directly responsible for those activities, there would be the necessary technological structure to ensure that the integrity of the regime is maintained.
Okay, so I was just considering a basic vanilla property transaction, if there's any such thing, where you've got a vendor purchaser, potentially you've got a bank acting for the vendor or has a mortgage over a property, you've got a solicitor acting for the vendor, you've also got an agent who's been appointed by the vendor, and then you've got a purchaser who may have a bank, may not have a bank, may have a lawyer, may not have a lawyer. So the concept is that if one of those gatekeepers has performed the necessary processes, then others in the transaction should be able to rely on that. And that should all be automated through an appropriate system, whatever that system is, but obviously leveraging off technology. Is that correct?
Yes, that's correct, Senator Scarr.
Okay.
And just to that end, I might just add, just note that the financial action task force has specifically made some statements about the role that technology-based solutions can play to improve compliance, avoid overlapping administrative burden, and obviously keep costs down. So that is a model that we are very much interested in.
To what extent, and I'll open it up to all of the witnesses, but if I could ask you first, to what extent has there been consultation with the government with respect to implementing such a, it appears to me, sensible approach, which would avoid duplication, would avoid costs therefore, which ultimately have to be borne by the customer? To what extent have there been substantial discussions with respect to how we can leverage technology and leverage off the work of the strongest institution in the link, as it were, that has the capacity to undertake this compliance procedure?
Thank you, Senator Scarr. We have been involved in extensive consultation. We're very pleased with the level of consultation that's existed around this issue. We've been working with the Federal Attorney General, the Department, as well as with AUSTRAC. We're already well underway in terms of deeper dive stakeholder conversations. We've just, and of course, in addition to that, we have provided the written submissions as well that no doubt you have before you. So certainly we're pleased with the level of consultation. I think there's been a lot of positive work that's been done. The devil is always in the detail, of course, whenever legislative reform is on the table. And to that end, I think it's really important that that there is continued consultation and a recognition also of the fact that real estate is governed by state and territory laws, and therefore those unique differences must be considered. And I think to that end, that's where the rules and guidance notes become very important to recognise those nuanced differences.
Okay. Do any of the other witnesses have any comments with respect to those points which we've just discussed?
I'll respond, Senator, on behalf of the Property Council. So certainly mirror the comments made by RAIQ. Our understanding is the legislation as it currently stands is technology neutral. So I used the PEXA example previously. We're not going to preface that sometime in the future about being implemented, which I think is a good thing. I think it's very...
Can I just hold you up on that?
Yes.
It's one thing for the legislation to be technology neutral. It's another thing for the legislation to impose a positive obligation or for government to make a commitment, the executive to make a commitment to actually utilise the most effective and efficient technology in order to minimise the regulatory cost. So, you can use everything from my concern is, sure, it's technology neutral. You can use everything from a pen and a notepad, and everyone does their own thing. But my concern, and I would have thought a concern of many of your stakeholders, is we want to be using the best technology that's available to promote efficiency, to promote productivity, and to decrease, to get the cost benefit working in the right proportion. How do you respond to that?
Senator, in complete agreement with you. I don't think we're too far off our position now. I just think it's important to also recognise that I guess the obligations on each individual business or entity is going to be different. They're going to be risk-based. So certainly when the new regime is implemented and we've got tranche 2 is in with tranche 1, the obligations on a bank is going to be very different to the obligations on a sort of a large residential developer, which is going to be sort of different to what the obligations are on a real estate small business of one person. They're just going to be different ways of doing things. So to your point about a technology solution, we would love to see that. We very much encourage government to implement that. But we're probably in a better position using existing processes that exist. Many of our members, Senator, are already regulated as tranche 1 entities in this country. Many of them are already regulated as tranche 2 entities overseas, many of which speak to some of our members on the call might be regulated in New Zealand, for example. So these aren't entirely new processes for large segments of the market. They just need to roll them out in Australia. But going back to the point, we're happy to see the legislation being technology neutral, and we would of course support the government if anything they can do in order to simplify the regime for reporting and reduce costs. We would of course welcome that.
Okay. Other witnesses, do you have anything to add in relation to those issues?
It's Tamara Davies here. I would just add, I think, to support, we would very much support a technology solution if it could be used industry-wide, because there are a lot of privacy concerns, cyber concerns, and other such matters that all the real estate or tranche 2 reporting entities will need to come to grips with in terms of if we're collecting a lot of personal data to do these verifications. Having a centralised technology platform would be helpful. For also the fact that clients then who may be working with lots of different real estate agencies could be verified once, and then each of the companies could use that information to do, as Dan said, we have to each do our own risk assessment under the legislation because everyone's risks of a particular client might be different. But having that information centrally housed and tightly controlled would be very beneficial. Another point that I raised at the Attorney General's consultation would be that as part of these kind of know your customer or background checks that we need to do, we have to look for a lot of information. Currently in Australia, on the ASIC website, all the company's information has to be individually purchased. It's not publicly available as it is in other countries such as the United Kingdom, where you can go in and find company information very freely, and that enables those tools that do the data mining and go and look on background checks to be easily able to pull that information and to scan it and provide a report. Where we have to then be buying additional documentation, that can be very expensive and add, additional layers to the searches. So anything the government can do across other departments to support and facilitate the, efficacy of these checks would be welcome.
And I just might add to that point, Senator Jeff Mooney here from Compliance, Head of Compliance at Stockland. Yeah, I agree. And as a technology-based approach can also potentially assist in screening of politically exposed persons and sanctioned parties as well, because in practice in industry, the participants and regulated entities access generally third-party databases which source a number of different global reference points with regards to PEP and sanction screening from the State Department in the US to Australian legislation as well as EU directives as well. So we definitely support a centralised technological approach as well.
Okay. All right. That's understood. The Property Council of Australia, you advise that you're reasonably, and I don't want to verbal your submission, but as I read your submission, you're quite positive in relation to the engagement you've had with the government in terms of resolving a number of issues, which that's pleasing, but there's still a number of issues, a number of things which are captured by proposed designated services that you still have some concern about. I noted the concern around leasehold interest thresholds. The materiality of increasing from 20 to 50 years, do you have a heap of members who have got 40-year leases, do you?
Senator, I don't mean to be cheeky. We certainly haven't done a deep dive into that exact figure. I think the key point about us sort of proposing a different figure than 20 years, which is what the department has suggested, is probably one of the areas we'd like a little bit more information is understanding what methodology the department has done to choose 20 years. So in our discussions with them, they've tried to set the date at some time where, quote unquote, ownership-like qualities are transferred. So obviously if a lease is for 1 year or for 99 years, there's going to be a different relationship there in terms of ownership-like qualities being transferred. And they've put that at 20 years. Our members were probably a bit more happier with the figure between 50 to 99. Obviously 99 would be their preference. We've made the decision to try and find a happy middle ground at 30, Senator. So I don't have anything further than that, other than I would certainly encourage the committee to investigate that issue with the department to understand what their thinking is and methodology for picking that particular relatively arbitrary number.
And Senator, I might just add to that from a industry perspective is that there are a number of leases that do occur in the commercial property space around the 20-year mark, sale and leaseback transactions, but also to logistics type facilities where a single tenant is looking to occupy a site for a significant period of time, but ownership doesn't change as it would for the sale of a 99-year ground lease as well. So 20 to 25 years is common in the industry with respect to logistics type facilities leases as well.
Senator Scarr, I'm just conscious of time if you've got a few more questions.
Okay. The issue around initial refundable deposits, as I understand it, the argument is that it's almost like paying an option fee, if you like, to hold a property. It doesn't necessarily mean that you'll proceed with the transaction. So is it right to say from the Property Council's perspective it's too preliminary a matter to trigger the whole suite of AML obligations? Is that the argument?
Senator, I'll refer you to Mr Mooney, who can provide some good background.
Yeah, thank you, Senator. You're correct. It is a initial refundable deposit or a holding deposit just purely to register an interest in a lot or a piece of land. They're generally low dollar value amounts between $1,000 and $10,000, and again, further to our colleague from REIQ, is that it is dependent upon state-based legislation as well. Generally, no documentation changes place, and the transaction is cancelable at the direction of the buyer, and it is fully refundable within certain timeframes as well. It's only when the buyer looks to proceed with the transaction that they move to paying what's called the balance deposit, and that generally occurs at exchange of contracts, is when a real estate transaction is generally entered into.
Okay, I wonder if you can, if I can just, and my time's come to an end, but if I can just ask you to take on notice if there's any particular drafting you propose that would accurately capture what we're talking about there. So I would find that useful in terms of considering proposing amendments to the bill. And I'd say that in relation to a range of the matters ranged by the Property Council of Australia. If you've got any particular drafting that you think would close out the issue, any exclusions that should potentially be drafted for, because we want to make sure that the drafting captures the practical reality and is tight, I would find that useful. So if I can ask you simply to take that on notice. And lastly, if I could ask the REIQ and indeed the other real estate institutes, if you would like to take on notice, I'm very interested to learn more about the experience in New Zealand. So the REIQ, in your submission, you touch upon the experience in New Zealand and how there have been some learnings in a New Zealand context. Very interested to know what those learnings are with specificity,
yes.
with the more detail, so we can perhaps leverage off the experience, both good and bad, of our brothers and sisters across the ocean in New Zealand. Is that possible?
Yes, indeed it is, Senator Scarr. That's been a really good exercise, so we're very happy to provide that to the committee with greater level of detail around that. I think there is an opportunity to learn from the experience in New Zealand and indeed other overseas jurisdictions, and for Australia to implement, to learn from those experiences and to implement, dare I say, a better regime.
And that's experience both good and bad from my perspective. So including leverage of any technology, that would also be useful to understand.
Yes, Senator Scarr, I'll provide the committee also with some information also around what's happened in, for example, Belgium and Slovakia, and also a few bits and pieces about what's happening in the UK. So we're very happy to provide more comprehensive information about that to the committee.
I've always wanted to buy a weekender in Slovakia, so I'm keen to see.
Haven't we all? Yeah.
Senator, in relation to your question about taking that on notice, we're happy to do that and provide that to the committee.
Great.
Thank you.
Thanks very much, Senator Scarr, and thank you for the evidence and for being here today. We appreciate it. The committee is going to break for lunch and come back at 1 o'clock with our next witnesses. So thank you very much. Thank you, everyone. We'll resume our public hearing of the Anti-Money Laundering and Counter-Terrorism Financing Amendment Bill 2024. I now welcome our representatives from the CPA Australia, Chartered Accountants Australia and New Zealand, and the Institute of Public Accountants. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you. For the Hansard record, can I ask you to each please state your full name and the capacity in which you appear today?
This is Belinda Zoraid McConnell and I appear for CPA Australia.
My name is Karen McWilliams and I'm appearing on behalf of Chartered Accountants Australia and New Zealand.
Good afternoon, everyone. My name is Erwin Bushnell. I'm from the Institute of Public Accountants. I'm a technical advisor in the Advocacy and Professional Standards team at the Institute of Public Accountants.
Okay. Thank you very much for joining us today. We've got the benefit of your submission, so thank you very much for that. And I was just going to ask if you have a brief opening statement before we go to questions.
Thank you, Senator. Yes, we do. And thank you for the invitation to present to the committee today. The three accounting bodies do have a joint opening statement. Firstly, we'd like to acknowledge the traditional custodians of the lands of Australia and their continued connection with the land, waterways and communities, and pay our respects to their elders past, present and emerging. Chartered Accountants Australia and New Zealand, CPA Australia and the Institute of Public Accountants together represent 350,000 professional accountants in Australia, New Zealand and around the world. Our members work across a wide range of sectors, including in practice, from large firms to sole practitioners, in business from major multinationals to SMEs, the public sector, not-for-profit, and in academia. We support the Anti-Money Laundering and Counter-Terrorism Financing Amendment Bill 2024, which expands the regime to include professional services, many of which are offered by our members. We welcome the proposed competitively neutral approach, as the designated services can be performed by other providers, not just professional accountants. We were pleased to see much of the feedback we've made to earlier consultations has been reflected in the drafting of the bill. We are concerned that the designated services, which include assisting and planning corporate restructures and handling a person's money, may unintentionally capture registered liquidators appointed under Section 5.3b of the Corporations Act 2001 to a small business as a restructuring practitioner or to a small business restructuring plan. Under these appointments, they do not stand as an officer of the company, rather assist the directors of a company. We seek for their explicit exclusion from the regime. Our members in practice vary greatly. For some, the provision of the proposed designated services currently comprises a substantial portion of their business, while for others, it comprises a small or incidental part of their business, and some others do not provide these designated services at all. The cost of complying with the regime for those of our membership who will be newly brought into it will vary significantly. However, all practices will incur a substantial time and financial cost in advance of the commencement of Tranche 2. We are concerned the cost of preparing to comply with the regime will disproportionately impact small practices because some costs will be foundational and independent of the size of the practice. The timely passage of the bill will help to minimise costs because it will allow sufficient time to develop the rules and industry-specific guidance and models, and for new reporting entities to use these to prepare to comply with the regime. Ongoing costs could be reduced by the introduction of complementary legislation, including the establishment of a beneficial ownership register and the linking of director IDs to company registers. Additionally, the fees for reporting entities to search various ASIC registers to undertake customer due diligence should be removed. Currently, an industry contribution levy is paid by reporting entities, with some entities exempt. Given there will be a cost burden for new reporting entities to become compliant, and that the extension of the current regime to such entities benefits all Australians, we consider that no additional costs, such as an industry contribution levy, should be imposed on the new reporting entities. The definition of a qualified accountant in Section 5 of the Anti-Money Laundering and Counter-Terrorism Financing Act 2006 should be updated to align with Section 88B of the Corporations Act 2001 and ASIC Corporation's Qualified Accountant Instrument 2016-786 to include members of the Institute of Public Accountants. To conclude, we are very supportive of the need for these reforms. We acknowledge that many of our members are providing these designated services, and we've welcomed the engagement with AUSTRAC has had with the 3 accounting bodies to date. We look forward to working with AUSTRAC and the Attorney General's Department in the development of the rules and the guidance to support our members in implementing these requirements. Thank you, Senators, and we're willing to take any questions if you have any.
Thank you very much, and thank you for that opening statement. We're going to go to questions. I believe, Senator Scar, you have questions. We'll go to you first.
Thank you, Chair. You can hear me?
Yes, we can. We've got you loud and clear. Thanks.
That's excellent. Registered liquidators. Why shouldn't registered liquidators be caught?
Well, the registered liquidators are appointed as an individual. They're not appointed, so it's not a report, an individual appointment. Now, the point we're making is that such that I guess registered liquidators actually won't be captured generally as part of the AML, because when they are appointed, they stand in the shoes of the company. And so therefore, they're not actually advising the company, but standing in the shoes of the company. However, the one exception to that is under the new legislation that came in during COVID for small business restructuring practitioners. Now, in that particular instance, the small business restructuring practitioner, who is appointed as an individual, actually still continues to advise the company. Sorry, Belinda, could you perhaps go on mute?
Sorry, if I can just interrupt you for one moment. Ms McWilliams, we've got a bit of a feedback loop. Someone might have the live feed going at the same time. It's very helpful if you can all mute your... Turn off the live feed. Turn off the live feed, just leave the video, I think. I think we might be okay if we all do that. Thank you. Sorry to interrupt you, Ms McWilliams.
No problem. So I guess as I was explaining, the newer part of the legislation, which is the small business restructuring, the way they are appointed is they actually act as advisors to the company. So the company is still in the control of the directors. So there's a slight difference in that, and we're concerned that they may be captured, particularly in relation to handling client monies and also in terms of restructuring a business. Now, in those two instances, they are what they do is bound by the legislation. They're heavily regulated already by ASIC. They are, and they're also basically directed in terms of the directors and obviously accountable to the creditors. So I guess what we're saying is there isn't much risk of money laundering when you're dealing with a small business restructuring. And it's really, I guess registered liquidators will be exempt under all of the other areas that they deal with. But this particular one, because they don't stand in the shoes of the company, they could be captured through that, and we're just seeking for a specific exemption of those particular appointments.
Okay, so it's I better understand now. It's a particular concern with respect to this new category, or relatively new category, of restructuring practitioners who assist in small business restructures, which theoretically is an easier and less expensive way for a business to deal with solvency issues. So typically they'd be accountants, is that correct?
Yes, they would be.
Right. So
and we're not.
Yeah. So presumably it's the way the exemption would work would be in the course of providing that sort of restructuring advice, that itself wouldn't be a designated service, correct?
Correct, but we would only be seeking the exclusion for that specific appointment under Section 5.3b of the Corps Act. So obviously any other restructuring advice that is provided in any other format obviously is not regulated under the Corporations Act to that same level, and that is not sort of what we're seeking. So we're specifically seeking it for those appointments.
Okay, understood. Have you had any discussions with the department in relation to that, or is this just an issue that's emerged on the basis of the current drafting of the bill? So do we know if there's a policy reason behind this?
We're not aware of it. We have raised it, and certainly our concerns earlier in the consultation process was that potentially all registered liquidators would get captured. The way it's currently drafted, our main concern relates to this particular type of appointment, because the way it's worded such that because other appointments, the registered liquidator would stand in the shoes of the company, that would not meet the sort of proposed definition. So it isn't something that's particularly new. It is something that we have been raising ongoing, but this particular one, I guess, remains outstanding.
Okay, understood. Okay, thank you. We'll certainly raise that, or I'll certainly raise that with the department, see if we can't flush that out. In relation to the Financial Services Council, given the planned implementation date of 31 March 2026, just moving back from that, when would you really need there to be reasonable certainty with respect to the content of the rules?
Look,
from a logistical perspective, what should be the time frame? Let's assume the bill's passed before Christmas. There's still a few sitting weeks, so let's assume the bill's passed before Christmas. When would you need, what sort of period of time would you need between the implementation of the rules, or reasonable certainty with respect to the content of the rules, and when the new scheme goes live? Is there any, feel free to take it on notice, but it's obviously it's a key issue. You're not the only ones who've raised it, and people need time to prepare. At the same time, we've got this review occurring with respect to whether or not we're meeting our obligations under the relevant treaties, etc. So I'm just interested to know, in terms of logistics, what do you think's required for preparation?
Look, I think we are reasonably accepting that there are other deadlines at play here. So, everybody would like as much time as they could have, but that's not going to be possible in this instance. I think we are reasonably comfortable that if the rules can be finalised very early next year, then that gives a good full year, over a year for implementation. It's not perfect, but it's reasonable, I think. But if we're going to see these rules take a long time into next year to be finalised, that would be, would very much eat into that implementation time, particularly because we don't feel that, I guess, the guidance and all of the other support in education can really be properly developed until we actually have the rules in place. And that's going to be the key piece for us, obviously, is being able to talk to our members and be able to say, this is what your existing obligations are, and this is how they would relate to the AML requirements, and these are the kind of extra things you would need to do. Now, we will only have that clarity once the rules are finalised. Okay.
Is there any visibility now with respect to what's going to be in the rules? So do your organisations, as peak bodies, do you have some sort of expectation as to, these are the things we expect to see in the rules, or what? Obviously, this scheme's been rolled out in other jurisdictions, so does that mean there's some level of understanding of generally what's required? I'm just trying to get a sense, if you like, as to whether or not when the rules come out, the first draft of rules is released, this is going to be a revelation and my goodness, this has all come out of left field, or to what extent can we reasonably predict what's going to be in the rules?
I think we can have a reasonable prediction around what's in the fundamentals. For us, it's really going to be the nuances in relation to how they are drafted in order to recognise our members' existing professional and ethical obligations. And certainly we noticed, for example, that the legislation wording was changed in relation to the client customer due diligence, trying to expand my acronyms. So the customer due diligence to refer to reasonable steps. Now that, I guess, enables our members to also consider the kind of steps they take under customer due diligence in relation to the ATO's Know Your Client obligations. So it's those kind of bits, perhaps, that we would seek to try and clarify. And I think the reality is we're not going to know that until we see them. And it's those nuances that are going to be quite important to our members.
Okay, understood. And also, in terms of access to resources, if I've got a small accounting practice and I want to hire a consultant to come in and assist me to do a risk assessment, to review the business, review the services I'm providing, my client base, and then roll that into a set of, into a policy, into procedures, how's that? Do you have any thoughts with respect to how those services are going to be mobilised, the capacity in the market for the provision of those services, the roles for peak bodies in terms of assisting their members to comply?
Look, I think that's probably a different one. I wonder, Belinda, if you might be in a bit more of a position to just start that one off and then I'll take over.
Certainly. We have already begun working with AUSTRAC in terms of the educational methodology, how to reach our members. We've been talking about how we'd like to engage them in terms of developing realistic scenarios and the development of tools and models which would be suitable for our members to lever off as they develop their AML programs. So that conversation has already begun, but we certainly would like to, we'll be planning on expanding that with webinars, obviously online materials, and various different kind of modes of education and information updating. And as Karen said, the sooner we have the rules and subsequently the guidance developed, the sooner we can develop those education materials.
Okay, understood. Any other thoughts just on that subject from any of the other witnesses we have with us?
I might just jump in with permission from the chair. It's Erwin Bushnell from the Institute of Public Accountants. The AUSTRAC have commenced the engagement with the professional bodies around this. So they've set up very specific industry groups. So to date, we're very encouraged with the engagement we've had with AUSTRAC on this, and we're very much part of the process. So I just wanted to add that in. It has voluntarily commenced, and as Belinda was saying, we've had the first engagement around the communication to our members, and we're very much looking forward to the following industry engagement with AUSTRAC on the development of the rules and then the guidance and tools for our members.
Are there any learnings we can benefit from in terms of implementation processes, in particular in New Zealand? And I know Chartered Accountants Australia and New Zealand should be well placed to provide commentary in relation to the good and the bad in terms of implementation in New Zealand. Are there any learnings from that experience and matters that we particularly need to focus on?
Yes, certainly. I think, look, one of the key pieces has been, and we're certainly cognizant of that, is actually engaging with our membership during the process of developing the guidance. Now, that's not to say we weren't engaging during it in New Zealand, but actually it was very hard to get our members engaged at that time because often our members have so much that they're currently dealing with in the current realm. It's very hard to engage them in what's coming forward. So we're certainly very conscious of actually getting that real life member insights, what they're doing in order to ensure that the rules and the guidance really link into what they're currently doing. Another key point I would make is probably we had, I guess, although the legislation is going to be principles based, and that's very important, the lack of clarity sometimes around whether a particular service is captured or not captured is really quite fundamental. And we certainly had the experience in New Zealand of having a decision come out the day before the legislation commenced, which then basically sort of created a lot of confusion around whether a particular service would be captured or not, with nobody, including the supervisor there, really being willing to say it's in or it's out. And of course, then our members are left, being told, well, you've got to go get legal advice. And that, we had a number of members who thought that they were only doing this particular service, they wouldn't be included. Suddenly they're now thinking, well, am I? And so that certainly that experience was not something we want to be going through in the Australian regime. So we're certainly looking to ensure that we do have clarity and can really be clear to our members, if you're doing this particular activity, it's in or it's out, and not that kind of grey area in the middle, because that means that, they aren't in a position to prepare properly. And certainly for some of our members, that made the difference between being part of the regime or not. So quite a significant piece. The other thing I'd probably mention is around that sort of tools and...
Sorry, just on that point with respect to tight definitions of designated services, as I understand it from your submission, the only grey area you're concerned about at the moment is in relation to restructuring practitioners. But I'd be keen to know if there are any other areas, take it on notice, if there are any other areas where you think the drafting should be tightened to avoid that situation, because we don't want those subject to the Tranche 2 reforms to be subject to that uncertainty, right? So if we've got an opportunity to leverage off the learnings across the ditch, that would be very beneficial. And then I interrupted you. I think you were talking about tools.
So, yes, I think the final point I'd probably make is in relation to tools and guidance. I know certainly our members would have really liked to have had, I guess, supervisor issued templates or guidance, and that was probably quite limiting at the time. And so we as a professional body did develop some how-to guides, but we had to be quite careful, because obviously we're not in a position to tell our members exactly how to comply with the law, and obviously this is a sort of legal obligation. So I guess the more that, and as Erwin's indicated, really the way we are working closely at the moment with AUSTRAC is actually very positive. As the three bodies together with AUSTRAC, I think we certainly feel like there's the opportunity here to really sort of co-develop the guidance to ensure it's fit for purpose for our membership, but also ensure that it is coming from AUSTRAC and therefore our members can have real confidence in it. Because certainly the tricky thing would be is if we don't have that certainty from them, and then everyone's trying to work out, well, how would the supervisor, how would the regulator in this case interpret that? And that does creates more time and a lot more confusion for the membership.
Yep. No,
Senator Scarr, I'll need to share the call shortly. We may have some time at the end if we're not joined by Senator Shoebridge, but I'll just flag that with you if you've got another question or two to put, and then I'll hand the call to Senator Polley.
Yeah. Well, I've just got one question. It's a very genuine question. Can someone explain to me, walk through what proliferation financing is?
I think the reality is, Senator, probably none of us are in a position to do that.
Okay.
It's not our it's not a space that a lot of the risks associated with the accounting profession are more closely aligned with the money laundering aspects than they are with the proliferation financing. So that's generally where we have probably focused more of our attention.
What is proliferation financing?
That's probably a good question, but I'm not sure we're the ones who are going to be in a position to answer that.
Okay, right. I don't feel so bad now.
We might be able to ask one of our other witnesses, Senator Scarr.
Okay. Thank you.
I will hand the call over to Senator Polley now. Senator Polley?
Yes, thank you, Chair. And can I thank you also for your submission and for making yourself available today. This is a very important inquiry. I just want to have a sense from the Chartered Accountants. You support the bill, but I was just wondering if you could just outline in a bit more detail how you see the role of Chartered Accountants and their involvement and how they play such a crucial part in detecting and preventing criminal activities.
Yes, certainly. I guess, look, we are supportive of the bill, and as I think as Senator Scarr indicated, a large proportion of our members in New Zealand are already complying with similar requirements in New Zealand in that jurisdiction. So I guess our members are bound by ethical obligations. and they are certainly not out there wanting to, have clients who are involved in these sorts of activities, and they also support the broader economy and community. So I guess our support for this is really bound by the fact that this is something that is important to Australia's interest and to the broader economy, and therefore we want to ensure that our members are meeting, I guess, global sort of best practice expectations of themselves, and ensuring that they are not in any way inadvertently being caught up in criminal activity. And so these sorts of processes, I guess, that will be put in place, and the vast majority of which our members are probably already undertaking. But I guess that increased awareness and heightened understanding of where the risks for money laundering sit will enable them to actually better manage their risk as a practice.
Thank you for that. I should declare a conflict of interest. I have a daughter who's an accountant, so I better declare that. Just in terms of, I don't always admit to that, I must say, in some places, but in terms of the work that is done in this space, just wondered what have been the designated service models that this bill is using. You said already there's New Zealand, you've spoken about what they do over there. Is there any other designated service model that this bill has been based on?
I'm not entirely familiar with other ones. New Zealand is the one that I'm probably closest to. I have spoken to some of our counterparts in jurisdictions such as the UK and Canada, and know that they take a different approach. From our perspective, we're quite comfortable with the designated service approach, particularly because in this jurisdiction, anyone can call themselves an accountant. Not anyone can be a member of our professional bodies and be bound by our code of ethics. So we are particularly concerned that if, but I suppose we're particularly happy that the designated service approach has been taken, because that ensures that, I guess, criminal actors aren't able to go, well, okay, we won't use a professional accountant for these services, we'll find someone else who can do them. And I think that's one of the things that's quite important to note, that the services that are being designated can be undertaken by others who are not part of a particular profession. And I think this way we ensure that we're displacing that risk by, I guess, only regulating our members and putting them to a higher bar, but others who call themselves accountants and do that kind of work are not having to actually comply with these sorts of regulations.
Great, thank you for that. Just in terms of the consultation process, obviously, you know, your submission outlines quite a few things, but I was just wondering, in terms of the consultation that was done, have there been any other issues that you brought forward which the department has taken on board when drafting this bill?
Yeah, I'm happy to. Belinda, did you want to answer that one?
Certainly, thank you. Senator Scarr mentioned earlier about the definition and the drafting of some of the designated services, and we did have a concern about the drafting of several of them during the earlier consultation back in June with the Attorney General's Department, and those our comments and feedback were taken on board. So, as I said in the opening statement, we've been very, very happy with that, and you can probably tell by the brevity of our submission that much of that feedback has been taken on board.
Yes, no, that's great. I just wanted to get that again on the record. But you note in your submission that bill minimises regulatory burden for new reporting entities. Can you outline in ways in which that's in the legislation?
I think, Senator, that particular comment related to the removal of a requirement to risk rate pre-commencement customers.
Is about to be tested. This is a test.
Sorry, there's testing, but it's all right. We'll be able to keep going, but just please ignore the alarms. Timing is everything.
I can always take over for you as well, Senator Polly, if it gets really noisy.
You're on fire again, Senator Polly.
I'm always on fire, Senator.
Pre-commencement customers. So one of the particular things that we were keen to see was in an earlier consultation, it had indicated that new reporting entities would have to risk rate all of their pre-commencement customers. Now, that would create quite a significant burden for reporting entities. And I guess particularly when you consider some of what the designated services are and how accountants might interact with their clients. They might do one of those designated services for their clients and then not do another one for quite some time. And so I guess we were quite pleased to see that that exclusion was put in within the bill, so that actually the focus is on risk rating customers when they have a designated service. So basically from the start of the bill ongoing. And I think that certainly does reduce that unnecessary burden, because some of those pre-commencement customers may never come back with a designated service. So it would be quite a waste of effort and just be a significant additional time and expense.
We've timed that very well. I managed to mute before the noise started. Just my final question, Chair, and that is, it's already been evidence that's given today, or it's been outlined by a number of witnesses, that we need to get on with this. We're running out of parliamentary weeks, and I was just wondering what your views were on the current commencement date and the need to prevent any delays for new reporting entities. So would you be encouraging, the Parliament to get this passed in the next couple of weeks of sitting? Would that be your view? I don't want to put words into your mouth, but I'm just interested.
I think, as we indicated to Senator Scarr into his question in relation to the rules as well, our members need as much implementation time as we can give them. And we need the rules, therefore, to be finalised for us to work on the guidance and the support, and sort of working backwards from that. Obviously, none of that can start until the bill passes. And so I guess that's where we're really coming from in terms of that sort of timing. I think there are some, minor things as we've raised in relation to the bill, but I think it's not something that we want to see. We still want to see it passing and hopefully fairly quickly, because the risk is it delays, and then we're certainly eating into our members' implementation time, and that's not something that we want to see.
Thank you very much. Thank you, Chair. I think they're going to test again, Paul. I'm still on fire down here. Thank you, everyone.
Thank you, Senator Polly. Good to hear, I think. Senator Scarr, we don't have our other Senate colleague, Senator Shoebridge, back yet with us. Do you have any other final questions? And then we might have a short little break while we get our other witnesses in front of us.
Look, I did have another question. I was just interested to, if someone could walk me through the significance of the definition of qualified accountant and the need for it to align across the different legislation. Why is that of particular importance? So just for the benefit of Hansard, the definition of qualified accountant in Section 5 of the Anti-Money Laundering and Counter-Terrorism Financial Act 2006 must be amended to align with Section 88B of the Corporations Act and the ACIC instrument that's referred to there. Why is that important, and what's the confusion caused by the lack of consistency at the moment?
I'm happy to talk to you about that one, Senator Scarr. So the Act as it stands at the moment, 2006, has a definition of a qualified accountant in Section 5, which says, as a member of the chartered body and CPA Australia, Chartered Accountants Australia, New Zealand and CPA Australia, and any other body named in the rules. And the rules don't, as they currently stand, don't further expand on any other body as such. Since then, we've had contemporary legislation in the form of the Corporations Act 2016, Section 88B, which gave ASIC the authority to pass a legislative instrument or a class order, which expands on the definition of a qualified accountant. And that class order has a definition of a qualified accountant as being a member of the Chartered Accountants Australia, New Zealand, CPA Australia, and the Institute of Public Accountants. So to sum it up, it's pretty much bringing the Act in line with the current Corporations Act, just to make that alignment, because the definition in the Act at the moment is a lot narrow, or not as expanded as what's in the current Corporations Act and the ACIC class order. Does that explain things, Senator?
Yeah, it does. It does beg the question, though, as to what extent would members of the Institute of Public Accountants be captured by the legislation? To what extent would they be providing designated services?
To the extent as the other two bodies or members of the other two bodies would be. Our members provide very similar services, albeit perhaps a different client base in terms of the designated services.
So it doesn't really, sorry to interrupt, it doesn't really matter to an extent who you're providing the service to. It's really the nature of the service, and then who you're providing the service to could well inform the steps you need to take in response to your obligations. So if you're doing a transaction for a Commonwealth department, that's a different kettle of fish to doing a transaction for someone who's just flown in from a distant jurisdiction and is carrying a bag of money. Yeah?
Yeah. So the designated services that, like I said, the Chartered Accountants and CPA Australia offer are no different to what the Institute of Public Accountants members would offer. So we really need to be part of that definition of the qualified accountant. Okay. And it's also, like I said, to bring the Act into 2006 into alignment with contemporary legislation 2016, where the definition does include our members. So really crucial for us. If I can leave the senators with anything today, that would be the thing I would please ask you to provide for us.
I have heard your exhortation.
Thank you, sir.
Thank you.
Thank you,
Chair.
Thank you, Senator Scarr. I believe that's all the questions we have for you today. So thank you very much to the CPA Australia for your attendance and your submission and your involvement in the consultation process. So we've taken on all of your views on board as a committee. I think we have our next witnesses with us already, so we might move straight to the next panel. I now call representatives from the Uniting Church in Australia and the Academy of Excellence in Financial Crime Investigation and Compliance and Griffith University. Was I right? Yeah, okay, good. Trying to buy myself a longer break. Now, I believe all of the next witnesses are joining us in person, so that's fantastic. I'll wait till you get settled. We've got Senator Scarr online and Senator Polley, as you saw. So, would you mind just removing the name tags from the last witnesses? Thank you. Great. Oh, no. Wonderful. Thank you. Well, thanks for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can I ask you each to please state your full name and the capacity in which you appear today? And Dr. Zernak, we might start with you. Hello.
Hello again. Dr. Mark Zernak, Senior Social Justice Advocate for the Uniting Church in Victoria and Tasmania, Synod of Victoria and Tasmania.
Thanks for joining us.
Professor Andreas Chai. I'm the Director of the Griffith Academy Academy of Excellence in Financial Crime Investigation and Compliance.
It's a mouthful. Hello.
Hi, I'm Shirinjit Jo, Professor in Accounting and also the Deputy Director of the Academy.
Good afternoon, my name is Jason Sharman. I'm the Sir Patrick Shear Professor of International Relations at the University of Cambridge.
Good afternoon, my name is Gordon Hook. I'm a Senior Industry Fellow at Griffith University with Professor Andreas.
Thank you very much for joining us today. Do either of your organisations have a brief opening statement you'd like to make before we go to questions? I'll start with you, Doctor. Thank you.
Thank you. I'll confine my comments particularly to the suggestion this morning that the bill should be modified to mirror the restrictions on lawyers that apply in Canada. I find that deeply, deeply disturbing suggestion. The Canadian regime is described as a self-regulatory regime where the law societies actually enforce it. Lawyers are not required at all to make suspicious activity reports unless they are required to do so under the Canadian Criminal Code around terrorism and sanctions regime. Lawyers are permitted, there's no restriction on lawyers tipping off their clients. In that, you've got a case from 2017 where a lawyer was found to have laundered $26 million through his trust account and ignored the disciplinary hearing, found that he ignored a sea of red flags. And despite that, the penalty he got was a 6-month suspension in relation to that. The FATF analysis of Canada actually criticised Canada for failing to regulate lawyers and for not requiring them to make suspicious activity reports. And an AUSTRAC official was actually part of the 2021 FATF analysis of Canada. In addition, there was a Canadian Financial Intelligence Unit report from 2022, the FinTrack report, found there were 92 cases in which legal professionals were found to have been involved in professional money laundering schemes. In Canada, the lawyers use legal professional privilege to set up shell companies and trust accounts to facilitate the money laundering. FinTrack also found that law firms were openly advertising services used to launder money in Canada. I would point out further, it was disturbing to hear evidence this morning indicating that it appears a number of entities failed to meet their obligations under Australia's sanctions regime currently. The evidence seemed to be that they don't do any current due diligence checks to ensure they're not dealing with people who are on the sanctions list, and breach of their sanctions obligations already carries 10 years in jail. So the unintended benefit potentially for the bill that's before us may be to actually get entities to now take their sanctions obligations more seriously. I'll leave my comments there and happy to expand under questioning.
Yeah, thank you very much.
Thanks very much. Good morning, esteemed members of the Senate Legal Constitutional Affairs Committee and the Chair. I'll keep my comments relatively brief. I've got with us today a range of experts. So Professor Shirinjit Joel is a professor in accounting, and she's conducting research on tranche 2 readiness in Australia. Dr. Gordon Hook is affiliated with our academy, but he is also the former executive secretary of the Asia Pacific Group on Money Laundering, in which capacity he participated in 14 mutual evaluations, including Australia's last mutual evaluation, and has made a submission very much on the topic of legal professional privilege, which Dr. Mark has just mentioned. And we've also got Dr. Jason Sharman, who's one of the world's leading experts in the area of identifying sources of financial crime and assessing financial crime compliance. So he will also be making a small opening statement. What I would like to just emphasise in the recommendations that we've made is we're trying to advocate for 3 small points in this bill, which we very much welcome. First of all is about greater information sharing. So subsection 123 of the subpoint 5 states that the tipping off offence does not apply if disclosure is made to another reporting entity for the purposes of detecting, deterring or disrupting financial crime. In this particular regard, we encourage amendments to be made so that the reporting entities are able to share this information also with universities conducting research in financial crime prevention. This is really important because right now, identifying financial crime in bank transactions is like finding a needle in a haystack, except if you imagine that needle to be broken up into different bits, and those bits being displaced around different haystacks, which different banks are looking at. So no one bank or financial institution can identify all of the needle. And it's really important for us to develop regulatory sandboxes, which is in line with Australia's AI ethics principles, for financial institutions to share data, for researchers to conduct insightful research about the latest money laundering typologies and share that information with financial institutions and the law enforcement agencies. So we advocate for the inclusion of universities in that particular area. In terms of addressing legal professional privilege, the submission that we've made has basically pointed out that more clarity needs to be made about the scope of LPP, and without enforceable requirements on lawyers and a regime of supervision to ensure compliance, the bill will not yield effective risk mitigation outcomes. And we also make a point about the need for training programs. We just heard it from the CPA about the importance and the regulatory burden. We think that there should be a bit more clarification about the quality and amount of training for different entities, so small, large and medium. With that, I'll pass on to Jason, who's also got an opening statement.
Thanks very much. I suppose there's an old joke about if you invite two academics, you get three conflicting opinions. Just very briefly, I confine my remarks just to the impact assessment, or the balance of cost and benefit, the document that went along with this legislation. I have to say I'm strongly opposed to this legislation. I hope it does not pass. I think in looking at the impact assessment, it shows that in fact the costs are considerably greater than the benefits to Australia. And in fact, the benefits that are mainly diagnosed in the impact assessment depend on some very dubious assumptions about the impact of grey listing by the Financial Action Task Force. I think I won't go into the detail, but I certainly can for question. And for me, it's notable that there's likely to be a massive expansion of regulatory burden that falls disproportionately on small businesses and consumers, conspicuously missing from the impact assessment. And in fact, the benefits seem to me to be very under evidence. Living in a country of the UK that does in fact regulate lawyers, accountants and so on, I can say that the experience has been a disappointment, and there's been no discernible effect on money laundering prosecutions, on the recovery of assets or on decline of predicate crime, but there has been a substantial increase in regulatory costs to anyone doing things like buying a house or engaging in fairly common financial behaviour there as well. The analogy of looking for a needle in a haystack has already been introduced. It seems to me that this legislation just makes the haystack bigger by having more reports. And in fact, I think that it's got a self-defeating quality. If success in money laundering was correlated to the number of reports received, Australia would be the outstanding achiever in the world. But in fact, this massive number of false positives and the proportion of funds recovered, basically for every $1,000 that's laundered in Australia, $1 is recovered, gives evidence that there's kind of reinforcing failure in this proposed legislation. Thanks.
Thanks very much. We're ready for questions. We'll go to Senator Scarr first.
Thank you. And if I can ask some questions just in relation to the point the witness just made there. I don't think those points are necessarily expressed in detail in the submission from Griffith University. Is it possible to ask you to take on notice to provide some more substance, if you like, around those points, around those issues you've raised? Because clearly, during the course of the day, we've talked about implementation issues in different jurisdictions. So whatever experience you can enable us to tap into in terms of the experience in the UK, the benefits that have been achieved, that would be very useful. Is that possible?
Yeah, definitely, and I should apologise for not providing a written submission. I'm something of a last-minute ringer in that I'm an ex-Griffith person, currently at Cambridge, and Professor Chai kindly invited me to have the invitation to speak today. But yes, I'm happy to provide those in written form, and I understand that that would be most helpful. Thank you.
Okay, thank you. And, you know, we are given these numbers around the cost to the Australian economy. I don't know if you've had a chance to look at any of the other submissions that have been made, but numbers like the cost of the economy of, say, $60 billion a year, notwithstanding a regulatory burden of in the billions, that still outweigh to the overall cost of us doing nothing. How do you balance? What comments would you give us in relation to balancing those different assessments in terms of the ratio of cost to benefit?
Sure. I mean, my main focus there would be the impact assessment that's provided along with the legislation. I noticed that even the headline figures of $13.9 billion in costs versus $13.1 billion in benefits indicate that the costs are greater than the benefits. But in fact, most of the benefits are not in terms of reducing crime, either money laundering or predicate offences, but in fact $10.7 billion of those benefits are in fact chalked up to avoiding being grey-listed by the FATF. Unfortunately, the report is based on some things that are flat out wrong about the way that the FATF goes about grey listing, and indeed the likely consequences of grey listing for Australia too, in that it adopts some very kind of tendentious points and some extremely pessimistic assumptions in the way that it comes up with that $10.7 billion figure, which is about 80% of the benefits that the impact assessment foreshadows for this assessment. I think that figure is just flat wrong.
Okay. In relation to the FATF issues, the argument's been made that we've signed up to these obligations to roll out to Tranche 2. We're one of the parties to this regime that has not implemented these amendments. We haven't rolled out the reform to Tranche 2. That puts us in a very small category of countries that haven't done this, and quite often, and I've heard this argument over a few years, people will recite the countries who have signed up and have introduced Tranche 2, and they'll say, well, these countries have, but Australia hasn't. What's going on here? To what extent do we need to be mindful of the fact that we have made commitments to do certain things in relation to these matters, and it does seem on the basis of objective evidence that we are one of the few countries that hasn't rolled out this regime to Tranche 2 professions, to the gatekeepers. Why shouldn't we be concerned by that?
A majority of countries in the FATF stocktake report of April 2022, in fact 58% of countries have not regulated DNFBPs to a standard that the FATF regards as fully or largely compliant. And prominent amongst the countries that haven't are the United States and China. I think kind of more fundamentally, I mean, who is this legislation meant to serve? The Financial Action Task Force or the national interests of Australia?
No, well, that's a good point, but the 58% figure of countries not regulated to a standard fully or largely compliant, where would you put, is Australia part of that 58%, or are we totally non-compliant?
We're part of the 58%. We're in good company with the world's two largest economies, the United States and China, which have not regulated DNFBPs, do not look likely to, and will not end up on the grey list.
Okay. So the practical, people have been talking about the grey list, and a number of witnesses to this inquiry have spoken about the grey list and from their perspective, the priority not to end up on a grey list. What is, in essence, the grey list? How do you get on it? What are the ramifications from being on the grey list? Can you give us, from your perspective, some insight into the so-called grey list?
I can answer that, Senator. It's Gordon Hook from Griffith University. The grey list is part of a monitoring regime that is implemented by the FATF in a working group called the International Cooperation Review Group. There's a threshold for countries to be referred to the grey list if they have a set of poor ratings. I can provide you what those ratings would be in a mutual evaluation report, which Australia runs a risk of receiving in its next evaluation in 2026, but they're quite technical in terms of what they are. The overall threshold is if a country has $50 billion in financial sector assets across all broad money, not just cash, but broad money. Australia was initially in the third rating, the third round evaluation in 2005. Australia was criticized heavily by the FATF for not implementing measures against DNFBBs. And at that meeting, which I was at, and was in Paris, Australia indicated it would implement DNFBB coverage for those entities within a period of 4 years. However, that's almost 30 years ago now. Australia is still lagging behind the majority of countries, not to show any disrespect to my colleague, but the 58 countries that are referenced in the FATF report, some of those countries do partially regulate DNFBBs, so the 58 is not at full exclusion. Australia sits in a smaller number of countries, I think it's 5, where they have full exclusion for DNFBBs. Canada, for instance, doesn't regulate lawyers, but it does regulate the other DNFBBs, such as accountants, trust and company service providers, real estate agents, precious metal and gem dealers, etc. The United States partially regulates some of the DNFBBs as well. So I just say that because the picture that was painted may not be entirely accurate. Australia's cost in terms of being possibly grey listed by the FATF is primarily in terms of Australia's reputation. I attended FATF meetings in excess of 22 years across all of their quarterly meetings, and Australia comes up regularly as an entity, as a country that is lagging behind the rest of the world community. In terms of the risk of being grey listed, the IMF in 2021 published a report indicating that the possible costs of any country being grey list is a hit of 7.6% against GDP. There have been a number of countries, and I'm familiar with those in the Asia Pacific, that have been grey listed. What stands out prominently is Sri Lanka, who as a result of its grey listing in 2018 fell into an economic crisis and had to be bailed out by the IMF in 2022. Reputationally for Australia as a G20 country, Australia would be the only G20 country to fall into ICRG process, with the exception of Indonesia 8 years ago. Australia, I know, doesn't want to, is concerned about falling in that group of countries, but how that reputational risk to Australia translates into a direct risk, whether it's a 7.6% hit, as the IMF said, in terms of foreign direct investment or not, is a matter of speculation. The comments that were made by Professor Sharman a moment ago, there is some truth to that in terms of what an economic consequence would be for a country like Australia. But nevertheless, Australian agencies have reflected a concern that there would be economic consequences. It's a matter of speculation to the extent of what those consequences would be. I hope that answers your question, Senator, but I'm more than happy to take any follow-ups.
No, that's very useful. I'm very interested to drill down into this difference, which I think you posited between the position in the United States at the moment and the position of Australia at the moment. How would you define the difference between the current status of the United States in terms of its compliance with these particular matters as opposed to Australia's compliance, and what the position will be if this bill is passed in Australia?
Yeah, so I have had discussions with senior U.S. Treasury officials, most recently about 7 months ago when I was in Washington, D.C., about their efforts to implement policy around DNFBBs. As I mentioned in my submission a moment ago, they do partially regulate, but not all DNFBBs. For instance, like Canada, the U.S. has issues with bringing lawyers within the reporting regime and the supervisory AML regime. That is because for similar issues Canada has with respect to legal professional privilege, and the Canadian experience arises out of a Supreme Court of Canada decision that was issued as on appeal from the British Columbia Court of Appeal back about, I think it was 12 or 13 years ago. I do know, for instance, and I was in Canada just recently and had a meeting with their Department of Finance just yesterday. They are now implementing policy measures to bring within their DNFPB scope lawyers. The Supreme Court of Canada decision that I referenced a moment ago did not indicate that lawyers could be excluded from the regime. They indicated in their decision that the policy proposals that the Supreme Court had decided, the policy proposals rather put forward by the Department of Finance, infringed legal professional privilege. So the door was left open to come to a better proposal in terms of policy. And Australia, I see, is working to implement a similar regime that would get around the issues of legal professional privilege, notwithstanding that Griffith University has made comments about some weaknesses in the proposed regime in the bill. China, I know, does, for instance, that was referenced, they do partially as well regulate DNFPBs, but not the full gamut of those entities that engage in the financial functions that are defined in the FATF recommendations that would bring an entity within the scope of what's defined as a DNFPB. Australia, definitely from a financial action task force point of view and from the Asia Pacific Group, which is a sister organization of which I was affiliated, is definitely an outlier when it comes to implementation of these measures. I do take issue, and granted, Jason, Professor Sharman commented that when you get more than one academic in the group, you'll get differences of opinion. I do take issue with the broad brush comment that implementation of AML-CFT measures for DNFPBs, and for that matter for financial institutions as well, are not producing the results. The primary policy objective of the FATF is to preserve the integrity of the financial system by preventing criminal proceeds from entering the system. How you measure prevention is problematic, but the fact that you're just relying on those statistics that reflect prosecutions and investigations is not the whole picture. You have to also consider the extent to which criminal proceeds have entered the system. And I grant, as I said a moment ago, that's a difficult process. And some academics and some policymakers have tried to measure that, but it is difficult to do.
Okay. Can I also add to that? In our submission, we point out the role that lawyers and other professionals can play in actually obstructing and making the task of law enforcement more difficult. So you actually increase the ability, or you decrease the ability of law enforcement to actually hold criminals to account when you allow these professionals to facilitate the money laundering.
And good to see you again, Dr. Zernsak. So thank you for your submission, much appreciated. If I can ask a question in relation to one of the recommendations in the Griffith submission, which I was pondering, and that is this question around information sharing, which is seen as something which is very important. Presumably there are risks to the extent that you share information with more institutions, with more bodies, that increases the risks of tipping off, of leakage of information. Is there any practical experience in overseas jurisdictions with respect to those issues? Or I know you've quoted from the USA Patriot Act, but can you put any additional meat on the bones in terms of what we can learn from overseas jurisdictions? Because at the moment, as I understand the regime, everything's funneled into AUSTRAC, and then it's up to AUSTRAC to then do what AUSTRAC does, as opposed to institutions, albeit reporting entities, liaising with each other, and the research by universities is sort of a second limb, which I'll come to.
Yeah, absolutely, Senator. I can answer that. So what's important to understand is AUSTRAC gets information from financial institutions and other entities, which are SMRs, which are basically summaries of what people see as suspicious, potentially suspicious activity. And that's a very short summary with a bit of information. And the tipping off provisions means that this can't be shared with anyone else. for fear of tipping off the person who's under suspicion. Now, the issue is that if you're a money launderer, many money launderers or the typologies don't just go to one bank, they go through many different banks. So this is an issue where through the Fintel Alliance, there's already action around information sharing to reporting entities. Internationally, we've seen the Netherlands and Singapore. Singapore is setting up an entity called Cosmic. Japan is also considering similar steps. And so what that is doing is that in real time, the transactions from the different banks are coming together under a single entity, monitored in real time and shared. And that's sort of the cutting edge. What we're proposing here particularly is something that's not that, but something in between, which is to research the typologies, which basically means how money launderers carry out their activities. We need to see all the data stored in one place, and then we can conduct research around that, which helps with the prevention of those crimes. And so that means for that information to be shared, we have to respect privacy. So we can undertake steps to respect the Privacy Act to make sure that there's no sensitive information in there, but it still allows us to study the typologies and at the same time get law enforcement on board to make sure that if we do discover certain findings about how these things occur, that the entities that share that information are not subject to law enforcement or regulatory action. So the concern is that really is that, if reporting entities, if they share with universities things and we find stuff, then they might get pinged for it, if I could put it down in very brief terms. And so what we need is a safe space where people could share things without the fear of being fined for it. But that nevertheless provides public, information or insights that are not necessarily public but can be shared amongst financial entities and law enforcement that helps us implement preventative measures and helps us share and coordinate information about how these financial crimes are taking place. I hope that makes sense.
No, it does. Are there any other institutions?
Question, and then if there's time, we'll come back to you at the end.
Sure.
If you've got one more question to put, and then I'll hand the call to Senator Polly.
Yeah, so this will be my last question. Are there any examples in overseas jurisdictions of universities having access to this sort of information that you could refer us to? Feel free to take it on notice so we can actually refer to templates or precedents where this is occurring and there's benefit to the common good in terms of addressing these issues.
Absolutely. I can send you some examples. I'll take that on notice.
Thank you. Thank you, Chair.
Thanks very much. Senator Polly, you have the call.
Thank you very much, Chair. I refer this to the Uniting Church. Your submission actually strongly supports the bill, and you speak about the real harm that money laundering actually causes within our communities, allowing criminals to profit from harms they cause. And we know that they're involved with child exploitation, obviously money laundering, cyber crimes. Can you elaborate from your experience about the real impact of these crimes on our community?
Sure. So our focus has been primarily we've looked at money coming in from the Global South countries. So a lot of the impacts on impoverished communities in the Global South, where countries in the Global North have ended up being havens for that money stolen, and that has real impacts on the ability to deliver services and the well-being of people in those countries. Particularly, we did quite a bit of work around Papua New Guinea earlier on when Task Force Sweep was in operation, looking at funds coming into Australia from that point of view. In addition, we have had a focus on online child sexual abuse, the commercial operations, and clearly that's a horrific crime that does very severe damage, and the driver for the commercial operations of child sexual abuse are the ability to make profit. So killing off the ability to profit from the crime helps target the predicate offence. Sometimes it's hard to get to the actual predicate offence, so being able to go after the funds is a better way for law enforcement to try and deter and disrupt the criminal activity in that space.
And these criminals, these syndicates, are involved in a variety of crimes. And I just wondered, have you done any work around cyber crimes and the impact in particular that it's having on young males between the age of 17 and 24 in relation to the impact on those individuals? And in fact, evidence that was given to another inquiry recently was very alarming in terms of the amount of young men that have taken their lives because of this cybercrime.
Yeah, so I think what you're referring to there is obviously a growing incident of sexual extortion online, particularly targeting children, often male children in their mid to late teens in this space. There is some evidence of that now being an organised activity where there is large banks of people who are recruited in and in some cases coerced into carrying out those extortions. And again, law enforcement would need to tell you about their ability to disrupt the financial benefits from that type of crime. I would suggest, though, that would only make up a very small part of the overall money laundering activities that would be concerned about. So while that is definitely a highly concerning crime type that has very severe impacts, as you indicated, in the space of even young teenagers taking their lives, it would only be a small part of the overall money laundering problem.
But in terms of, we've had evidence already and other submissions outline the concerns around real estate agents being, that profession as being targeted and using in terms of, that has an impact on the Australian community as well by pushing up prices of houses where we know that we're already facing a huge shortage. Have you got any case studies that you've done that has actually involved either accountants or lawyers that you can outline to this committee?
We do, in terms of, we have in our previous submissions given cases of properties being purchased within Australia by funds taken from Global South countries particularly. We have highlighted here, we did highlight the case of JBS being able to purchase, the two brothers who expanded the company confessed to bribing 1,829 officials. That included representatives of the State Bank. Through that, they were able to obtain loans from the Brazilian State Bank. And with those loans, in part, those loans were used to purchase businesses in both the US and Australia out of that. So, again, they're probably the kind of cases that we can immediately point to. But we have got previous submissions we did make to the Attorney General's Department. For example, again, we had Papua New Guinea, we had funds coming in from Malaysia being used to purchase properties here in Australia.
Can I just add, Task Force Virus by the Australian Federal Police found about, I think it was over $20 million in Sydney real estate, and that was the last 2 years. So, yeah.
Thank you for that. Your submission expresses your disappointment in the way the bill protects legal professional privilege, and we've heard evidence today from various legal sector groups that the bill goes too far in regulating lawyers. Just wonder what your views were in relation to that, and then, I'm very happy for representatives from Griffith University to respond to that as well.
Our concern here, the concerns we expressed in this is there is evidence of the misuse of legal professional privilege, and particularly we pointed to the ATO indicating significant misuse of legal professional privilege in examples. They had the PwC case stands out. You've even had the former General Counsel of PwC, Meredith Beattie, appear before our committee and admit that PwC had misapplied legal professional privilege, which allowed them to avoid having to provide information to the ATO in an audit around JBS in that case. I think the other concern, well, the concern we're then raising is legal professional privilege, as highlighted in the explanatory memorandum, cannot be applied for improper purpose. Yet what we appear to be hearing from the legal profession is they seem to ignore that. So if I'm approached to set up a regime, a legal structure, in order to conceal the beneficial owners, in order to conceal the transactions, in circumstances that are highly suspicious that it may either be money laundering or financing of terrorism, our view would be that would be an improper purpose. Yet what we're getting from the legal profession seems to be their cognitive faculties will fail them in being able to assess that there's a suspicious reason why this structure is being constructed, so they will be able to say, well, the advice is privileged and therefore they won't have to make a suspicious matter report. And the only way that would then get detected is down the track, law enforcement actually figures out there was a money laundering and traces back to the fact there was a legal structure, and that legal structure was set up by a lawyer who misapplied legal professional privilege. And then the police or AUSTRAC are going to have to spend time, if they really want to pursue this, going through the courts to try and prosecute the lawyer for the misapplication of legal professional privilege, which possibly won't result in much of a penalty anyway. For example, with PwC's admission of potentially having misapplied legal professional privilege to thousands of documents in the JBS case, not a single lawyer in PwC, as far as I understand, has been sanctioned for the misapplication of legal professional privilege.
Thank you for that. Anyone from the Griffith University?
Yes, thank you for that. I'm happy to sort of quickly summarise the submission that was made by Griffith University. By the way, I'm a Canadian lawyer. I'm familiar with legal professional privilege in Canada, and I'd be the first to say that the Federation of Law Societies case that was on appeal from the British Columbia Court of Appeal significantly expanded in the text of that judgment what the concept of legal professional privilege is in Canada. I understand that the Law Council of Australia has relied to some extent, I won't say wholly, on the content of that decision. But I do note, and it's contained in the submission from Griffith University, that the Law Council defines what legal professional privilege is in Canada, and that is in keeping with the concept of legal professional privilege in New Zealand and the UK, where they do require lawyers to report suspicious transactions and regulate them, supervise them for compliance. And the submission indicates that the concept, traditional concept, which is a British concept, is that it protects advice. Advice either in the context of client communications or in the possible or pending litigation. And the privilege belongs to the client. It doesn't belong to the lawyer. So it's up to the client to determine whether to waive it or not. Our concern in at Griffith University in terms of what's proposed in the bill is that while it's laudatory that it's trying to make an effort to bring lawyers within the scope of reporting and supervision and addresses the concept of legal professional privilege, the mechanism is weak in the sense that if a lawyer feels that a suspicion of money laundering is warranted but falls within the concept of legal profession or the scope of legal professional privilege, that lawyer will file a certificate with AUSTRAC. The problem is there's nothing in the bill that we could see, including possible guidance that's not in the bill but will be issued once the bill is passed, if it is. There's nothing that would allow AUSTRAC to look into that certificate and determine whether or not what's being claimed as legal professional privilege falls within the definition or scope of legal professional privilege. So it's, in our view, doomed to fail on the order paper, so to speak, because it'll be a toothless tiger. It'll indicate, yes, lawyers, you're required to report, but you're exempt if you feel it's legal professional privilege. So we're back at square one. What is legal professional privilege? As a lawyer, you'll do everything you can on behalf of your client, so it wouldn't be unlikely, and I'm speculating, that lawyers would assert it in just about every case, as they are doing now in Canada, and I speak from experience in Canada, but to a certain extent in Australia as well. So hats off to Australia trying to fix this problem, but more needs to be done. And that can be accomplished, in our view, by allowing requiring lawyers to report, but only within the traditional concept of legal professional privilege as outlined in the Law Council's own website where they define it, because that's the proper definition and not the more expansive scope that many lawyers in Canada and Australia have asserted, which is it applies to anything, even facts that are provided by clients to lawyers, whereas the scope of it is restricted to advice, not facts provided by the client themselves. Thank you.
Thank you very much. And my final question is in relation to your submission for the United Church. And you've outlined some of the concerns that you have in relation to the impact on Australians. And we've had other evidence today that, this is going to be onerous on, the legal fraternity, accountants, real estate agents. I just wanted your views about, our obligations as not just as individuals, but as community leaders and organisations and professionals to do all that we can to combat this very serious organised crime and the damage that's doing to our country. The fact that, there's a cost involved, there is always a cost, but the greatest cost is always the impact on the individuals. And so I just wondered if you got anything else to add in relation to your concerns and whether you agree that, there's always a cost, but the cost should not outweigh the benefits, whether it's, and we shouldn't be just looking at the monetary cost involved in this and the costs and the benefits from, not just from a dollar return. Otherwise, what do? Do we just, shrug our shoulders and say, hey, the criminals, they're also well funded, we can't beat them. Have you got anything to add for me?
Yes, I would definitely agree with you that we need to be looking at what the human harm is and what human harm might be prevented in addressing this, and that applies to a range of cross-border crimes that we would see. We don't sort of weigh up when we look at human trafficking or modern slavery and sort of say, well, it's a financial benefit to Australia to get goods that are produced through human trafficking or modern slavery, so, we shouldn't do anything about it because we're actually the beneficiaries of it, and actually addressing those abuses will increase the cost. We took a similar view on illegal logging, where there was substantial harms to communities where timber was being illegally logged. The Parliament rightly took the view that it was worth there being some additional costs potentially in the sourcing of timber, and it also favours then businesses doing the right thing, businesses that actually are acting ethically and morally and not having to compete then with businesses that are engaged in criminal activity or highly unethical activity. So I think it's far too narrow to just think about the financial costs. I do think some of the costs are also exaggerated. I think the government can be doing quite a bit to help reduce costs, but also I think even if I look at the Law Council's previous study where they looked at their own profession, a lot of their members are not going to see the kind of activities that will require them really to do much at all. And we already have in the reporting entities under the anti-money laundering laws, we already do have small entities that have to comply, and the expectation is based on the size of the entity. So it's not expected that every entity, regardless of size, bears the same cost or has to have the same regime. So, we need to make sure it is tailored appropriately to both risks and also the capacity of the entity to meet its obligations in what can be reasonably expected of them.
Thank you very much. Thanks to the witnesses. That's all from me, Chair.
Thanks, Senator Polly. Senator Scott, as promised, we do have a little bit of time left if you have a further question. Otherwise, we'll go to our break.
I can answer the question that was made before we started, and that is, what is proliferation financing?
Oh, well, there you go, Senator Scarr. You've got an answer to your previous question to a previous witness.
It's an important question.
Chair, I am going to compare the answer we were about to receive with the answer that Google provided me.
Might be one in the same.
It's a very important question, and it's a very important part of the Financial Action Task Force standards and the implementation of those standards in the domestic regime. To cut to the chase, proliferation financing is the financing of weapons of mass destruction in contravention of UN sanctions, and they relate primarily to DPRK or North Korea, and autonomous sanctions, and they may relate to any country that Australia has initiated sanction against. That would include Russia, perhaps Myanmar, Iran. Iran used to be the subject of UN Security Council resolutions, but those sanctions in relation to proliferation financing expired last year, and they're not likely to be reinstituted given Russia's ability to veto the UN Security Council resolution. So multilateral PF relates to DPRK. Bilateral PF would relate to the autonomous sanctions that Australia has put in place to prevent the financing of weapons of mass destruction. That's it in a nutshell.
Yep, no, that's better than the answer I got on Google. Can I ask you, to what extent does experience indicate that there have been Australian entities or Australian issues with respect to that issue of proliferation financing? Is it something which is more relevant in an American context or a European context than the Australian context, or are there particular sensitivities in terms of our own region in that regard? You mentioned Myanmar as an example.
If I could just follow up on that and link it to Mark Zernsack's remarks earlier. I mean, I think proliferation finance is one of the unfortunate one-size-fits-all dysfunctions of the global anti-money laundering system, in that most countries have nothing to do with proliferation finance, and yet they have to introduce standards. So, for example, Papua New Guinea, speaking about the human costs, has 6,000 avoidable deaths from asthma every year, which is the product of corruption, people stealing the health budget. What is Papua New Guinea spending its time on in preparation for its mutual evaluation review? Not corruption, proliferation finance, even though Papua New Guinea has no problem with proliferation finance, because apparently, like Australia, Papua New Guinea puts more weight on doing the right thing by the Financial Action Task Force than it actually does in tailoring its legislation and regulatory action to actually advance the interests of the country in question.
The only thing I can add is I did actually look up prosecutions for our sanctions regime, because I was intrigued. You know, all entities currently have to abide by the sanctions rules, and under Australian sanctions rules, if you become the possessor of property that's owned by a designated person under the sanctions regime, you're forced to freeze it, and you actually have to report it to the AFP, and there is no exemption from that. You don't get to claim legal professional privilege on that. But I was trying to look up prosecutions. I can only find media releases from the AFP on 2 prosecutions around the sanctions regime. So one was an individual who was trying to ship missile parts to North Korea, and the other was a person who was involved in breaching sanctions to Iran. But I would agree with Professor Sharman that I don't think it's a major issue for Australia around proliferation financing from an Australian point of view.
Yep. Okay. Thank you. I think that's all I have, Chair.
Thanks. Thank you, Senator Scarr. I just want to ask Professor Joel, is that how you pronounce your last name? Yeah. Just one question around the work that you're doing. You said at the start that you're a Professor of Accounting, but looking into the tranche 2 reforms. So what are you working on? Is it preparedness and how that transformation or the timeframes that will be required?
I was looking, what we are looking at, right? We have got a group of colleagues as well working on the same thing. And we're looking at the readiness of tranche 2 entities. So what we like to do is that we like to look at the different aspects of readiness, like what sort of training do they need, right? Or where the skill gap is, and working around that, right? At this, and also later, right, looking at things like, what sort of resources that are required, right? And in addition to that, it could be also, is there a need for further education, like, going to a proper sort of education through it can be micro-credentials or any sort of thing. Yeah. So the focus is more towards training. And I guess, with training, all right, ongoing training, all right, you do a better job, all right, in detecting suspicious activity or suspicious crime. So that was, pretty much in a nutshell at this point in time. All right, still working around the literature because the literature around this area is quite sparse and limited, and we like to contribute to that body of literature.
Yeah, great. One of the reasons I was asking is we've heard evidence today that although there's sort of this imperative to pass the bill as soon as possible, hopefully before the end of the year, one of the reasons is that it will take some time to get those entities on board, and almost we're sort of giving ourselves 2 years almost to get those entities onto the regime. It's not something that can be done overnight. Yes. Is that what your work is sort of?
Yeah. Like certain population of the entities, all right, would probably have been doing to some degree of due diligence, all right, and I guess those are the ones in the the bigger ones in the market, like those who are already providing some sort of consulting, But for the small ones, they definitely need the right time to prepare, and that's where I think we feel that the gap is needed, and they would need at least a year or a year plus. And by doing this research around readiness and having some kind of index, all right, and sorting it against different size of entities, that will give a lot of insight into the various groupings as well, and what targeted training is required, depending upon their profession. Yeah.
Thank you. That's really helpful. That's all the time we have for questions. So we thank you very much for your time and for your evidence today, and for your submissions as well. They're very helpful. The committee is going to have a short break and be back at 2:40 with our next witnesses. And I now welcome representatives from the Australian Banking Association, the National Australia Bank and Commonwealth Bank of Australia. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. For the Hansard record, can I ask you to please state your full name and the capacity in which you appear today? I can't, from what's on the screen, I can't tell which organisations you're from, sorry, just yet. So
I might start. Chris Taylor, Chief of Policy from the Australian Banking Association.
Thanks, Chris.
And John Fogarty, I'm the Executive General Manager of Financial Crime Compliance for the Commonwealth Bank of Australia.
Thank you. I think you might be on mute, Mr. Jektovic. Happens to the best of us.
That's Paul Jektovic from the National Australia Bank.
Yeah, great. We'll come back to you, Mr. Jektovic, and we'll go to brief opening statements. Mr. Taylor, do you have one from the ABA?
I do, yes, and for expediency, I've got one on behalf of all participants, so we only have to do it once.
Wonderful. Over to you.
Thank you, Chair. Good afternoon, Chair and committee members. Today I'm joined by colleagues Paul Jektovic from the National Australia Bank and John Fogarty from CBA, who've contributed to the ABA's submission. They each bring extensive expertise in Australia's anti-money laundering and counter-terrorism financing regime. The ABA supports passage of the bill with proposed drafting changes as set out to the submission to this committee. For over 2 decades, Australian banks have operated under AML-CTF laws, helping to safeguard a financial system relied upon by millions of customers from criminal exploitation. This experience has given banks a practical understanding of the importance of a risk-based and outcomes-focused approach. This is why we strongly support a move away from the current regime, which is complex and in some cases overly prescriptive. Our banks support efforts to simplify these laws and to extend them to higher risk sectors to close potential gaps. Given that many of these sectors are also our customers, we recognise the importance of protecting our customers and the community from criminal exploitation. Our submission provides clear, targeted recommendations to simplify the regime in a way that ensures compliance with FATF standards and recognises the need to balance benefit and burden. Our banks also request additional time to implement some of the significant changes that are required. I will now briefly address 3 key areas of concern. Firstly, the proposed changes to initial and ongoing customer due diligence is overly prescriptive and moves away from an outcomes-focused approach. The proposed obligations would likely require significant changes to banks' customer-facing processes, disrupting customers' timely access to banking services such as account opening and transactional activity. The bill shifts the collection of customer data and due diligence and a risk assessment prior to any product or service being provided to a customer. This would also necessitate a redesign of IT systems and may be counterproductive to a bank's ability to identify or mitigate financial crime risk. We also note that the cost would disproportionately affect smaller and mid-tier banks. It will also result in delays to customers accessing services. FATF standards support a risk-based approach, and we have suggested amendments to promote this approach, which would reduce customer disruption and unnecessary costs while better aligning with international standards. Second, the ABA supports the policy intent behind the travel rule and international value transfer obligations to improve international operability and the transparency of payment information. However, as currently drafted, the travel rule obligations are complex and ambiguous, incorporating new concepts not widely recognised by other international jurisdictions. We suggest a refinement of these provisions using simpler language to make reporting obligations clearer. Furthermore, changes to the travel rule and IVTS need to be carefully considered in the context of broader changes in the payments landscape, such as the retirement of BECS by 2030 and the adoption of ISO 20022. Implementing the proposed changes now would require a fundamental overhaul of the banking payment systems, only to potentially revise them again in a few years. we recommend aligning the implementation of these changes with the timeline of other payment system reform to avoid redundant effort and expenses and to better balance the impact on smaller stakeholders. Thirdly, the ABA recommends that the tipping off provisions commence promptly after the bill receives royal assent. This will allow early alignment with compliance measures across institutions and enable greater sharing of information to identify and support the disruption of criminal activity, protecting our customers and the community from criminal harm. Finally, modernising and strengthening Australia's AML-CTF regime is paramount to addressing the risks and threats faced by bank customers and the Australian community. We recognise the impending review by FATF in assessing Australia's compliance and the effectiveness of its AML-CTF regime. But in our haste to ensure compliance, we should not abandon the will to get this legislation right and to strike the right balance between benefit and burden. Thank you, Chair. We're very happy to take your questions.
Thank you very much for that and for that combined opening statement. Mr. Jekovic, does your microphone work now?
Let's hope so.
It does. Well done. Okay, fantastic.
Thank you.
Well, we've got your name for the Hansard record, I think, already. If you could just give us the capacity in which you're appearing today.
Yes, I'm the Group Money Laundering Reporting Officer in the Executive Financial Crime for the National Australia Bank.
Wonderful. Thank you. And Senator Scarr, we'll start with questions from you.
Thank you. Thank you, Chair. Mr. Taylor, to what extent have the concerns and the particular suggested amendments that you've helpfully proposed in Appendix 1 to the submission, to what extent have they been provided to government, for government to consider as part of this process? So are these issues, I'm just trying to get a flavour for whether or not any of these issues will surprise the government witnesses who we're seeing later today, or are these issues which are in current discussions with the government on? Sorry, I think you're on mute. Yep.
Thank you for the question, Senator Scarr. There have been several iterations of this process that have been run by the Attorney-General's Department, and there have been a number of submissions put in by the ABA and ABA members as part of this process. We have, as part of the review and the submission that we've provided to the committee, provided prescriptive drafting suggestions. And as I'd mentioned in my opening statement, we support the policy intent of the bill, being the simplification of the AML-CTF Act, as well as the expansion to Tranche 2 sectors. But there are some drafting matters that we are looking to continue to engage with the department on. And we do note the department has also provided a supplementary submission to the committee overnight, I believe, that referenced some of these points, and we would flag an ongoing willingness to get the drafting of the bill right. I might ask if my colleagues have anything that they'd like to add as well.
I think, thank you, Chris. Senator, the only thing I would add is the importance of not only the legislative bill, but the drafting of the rules. Yeah. And that will be a critical opportunity for us to take a holistic view to the both opportunities and potential challenges. So I would only highlight the importance of the drafting of the rules, and we've had very strong and clear indications from both the regulator and the department that the intent is to fully engage on the drafting of the rules. So we look forward and welcome that.
Okay.
Yes, I would agree with that. Thank you, Senator. I think it gets to the point on the simplification piece of the bill, and I think the more consultation that we can have, and as we move into the rules section, I think post-finalisation of the rules, we can then talk about the implementation time period post the implementation of those rules, at least post-agreement of those rules, and we move to hopefully potentially an 18-month implementation period.
Okay. So, because I must say, when I read the ABA submission where it talks about we're simplifying the system, but in simplifying the system, you might have to go back and engage in a fundamental redesign of IT systems. That fills me with dread for you all in terms of the cost and the technical challenges in that regard. Do you think the executive that you're engaging with, the government officials you're engaging with, now have an understanding of those technological issues and logistics?
Senator, these are certainly issues that have been flagged in submissions and in the direct engagement we've had with AGD in the previous consultation processes that have been run. But this is a complicated regime. It's quite technical by nature, and the legislation which didn't have the benefit of an exposure draft. This process is a really important a part of ensuring that the legislation is fit for purpose and that there are not unintended consequences or burdens in how the language and the drafting is finalised.
And I do note your comment that we did receive a supplementary submission yesterday or late yesterday, which I thought was very useful. So if I could ask you to take on notice, either collectively or individually, either way, to give your comments with respect to that supplementary submission. I'd find that very useful. And I think it is very useful. The Attorney General's Department did provide that supplementary submission, and that gives me confidence. One area which stood out in your submission was this matter of obligations relating to transfers of value, and I quote from the submission, "The level of uncertainty is so high that it is not presently apparent how the provision could be translated into business requirements for the IT systems that are needed to implement them," end quote. Did anything, I don't know if you've had a chance to read the supplementary submission yet, but did anything in the supplementary submission give you some confidence that that issue's now well understood and there's a pathway to try and resolve that? Because I must say it's somewhat concerning to me that there'll be that degree of uncertainty in relation to an area to the extent that you don't know how you'd accommodate it in terms of the business systems internal to the bank.
Thank you for the question, Senator. I think this highlights the need for some further engagement with AGD to ensure that we get the transfer of value provisions right. But I might hand over to John or Paul to provide more context about what it means in terms of systems, which might help answer your question.
Thank you, Chris. Thank you, Senator. Maybe the way we think about it, the technology changes really impact small parts of the bill. And one of them being the value transfer, the other one being the customer due diligence elements. And CBA supports the passage of the bill. These elements certainly are areas where we may need to get technology changes, and particularly when we move into the definition of originator, intermediary and beneficiary, which is talked about in the bill. The bill seems to go further prescriptive nature in defining hierarchies for each of those three definitions. And when you talk about the value transfer of a payment, each of those definitions, it'll be uncertain to us who is actually performing what role at any given point in time. And given this is a technology flow from a payment, that is where some of that technology changes would need to play out.
So what's the reason, do you think, for, and I don't necessarily want you to speculate in terms of why we're in this situation, but listening to the evidence, sitting here today listening to the evidence, it's somewhat concerning that you would give the testimony that you just gave about having difficulty identifying which in the chain of a transaction, if I can put it that way, who is doing what, and how to dovetail what happens in practice with the terms that are used, the hierarchy that's established in the legislation. What's the reason for that? Is it a lack of understanding of the? Well, I won't speculate either. I'm just trying to get my head around why we're in this place.
Yeah, I won't speculate on that, Senator, but what I will say, I think in looking towards international jurisdictions such as Singapore or the UK, they use a similar terminology in recommendation 16 from FATF. And I think if we move to that sort of regime, as other jurisdictions have, without the hierarchy, I don't believe that they use a hierarchical approach into each of those definitions. I think it becomes clearer and simpler, and that's in line with making the bill simpler for operationalisation.
Okay.
Yeah. I think, Senator, that's the important point, is that the ongoing dialogue with the department will continue to sort of represent the challenges we see with operationalising the draft bill, and hopefully, there's a place where simplifying, operationalising can meet with the intent that the drafters have, and I'm confident that the ongoing dialogue will get us to a place where both those outcomes can be realised.
Okay. There's a serious question raised in relation to the impact of the bill in relation to initial and ongoing customer due diligence. And I just want to take you to point A3, Mr. Taylor, if I can, regarding current bank practice and what the differences, which would be the differences with what's proposed under the bill and the practical consequences of those differences. And you include the statement, a risk-based approach that recognises the customer onboarding is a process rather than a single moment in time is more appropriate. So is the point that's being made there is when you're onboarding a client, if I can put it that way, you're obtaining additional information as part of the process, and that takes time. You can't necessarily have access to all the information at a single point in time. Is that the key point takeaway?
Essentially, yes, Senator. I mean, every bank has their own bespoke systems. Banks obviously are of varying sizes, and how they approach the implementation of these principles will vary between bank to bank. Actually, probably Paul or John, you might be able to provide more context on this point for Senator Scarr.
Yeah, happy to.
Go, John.
Okay, thanks, Paul. At initial onboarding, you can only collect as much information as you possibly can with a customer. And we recognise the importance of customer due diligence and its effect for FATF and the prevention of money laundering and terrorist financing. And that's why we support the passage of the bill. The implications of some of this means that we can't collect all that information at scale at the point of onboarding a customer. Some of these processes we undertake as a day 2 process. And so by the time we understand a sanctions element or a politically exposed person element, that could be on the 2nd or 3rd day once we've run it through global systems, and those alerts are then looked at to confirm whether it is an accurate hit or not. That is the importance of allowing something to be done in duration of that onboarding process. So the risk assessment of a customer is not just at the beginning. It happens over a period of time.
Okay, understood.
The only thing I'd add, Senator, to that is that I know that it's proposed that the CEO of AUSTRAC be given powers under the rules to provide certain exemptions. I think our desire would be that those powers are inherent in the bill itself, so that we can avoid having to apply for exemptions unless in extenuating circumstances. So that's part of the simplification and the modernisation that we would be seeking to realise.
Yeah. Can I ask you, as a practical measure, and I've been pondering this in terms of especially the rolling out of these obligations on perhaps smaller accounting practices, lawyers, small practices of lawyers, real estate agents. How do you practically screen for politically exposed persons and family members and close associates? What you referred to accessing global systems. What can you share with us what you actually do practically? Presumably you have questions you ask someone, but if they're not forthcoming with the information, how do you engage in that due diligence KYC process to ascertain whether or not they're a politically exposed person, or even perhaps more problematically, whether or not they're related to someone who's a politically exposed person or have some other sort of association?
Simply put, Senator, we engage vendors and we utilise vendor systems, and those systems connect into those global lists.
Right. Okay.
And in conjunction with the provision by vendors, as John said, which is widely practiced across our industry, we also have additional capabilities around open source, Senator, and maximising other intelligence that might be available to us. So it's a combination of those things.
So one of the issues we've been grappling with or thinking about, and a lot of these, as you've noted, a lot of the gatekeepers, as we're referring to them, the real estate agents, accountants, the lawyers, will be your clients in different capacities. So one of the issues we've been discussing is in the context of, say, a real estate transaction. A vanilla real estate transaction, you've got a vendor and a purchaser. You could well have a bank who has a mortgage over the property, a bank on the other side that is going to place a mortgage over the property for the purchaser. You could have lawyers either side of the transaction acting for the purchaser and the vendor. The bank could have a lawyer, and then you've got the real estate agent typically acting for the vendor. To what extent do you see an opportunity to leverage off, and I'll use a phrase that was used by one of the witnesses, the KYC process or CDD process undertaken by the strongest link in the chain, right? So to the extent that CBA or NAB has a CDD process and can access those sorts of global systems, I suspect you're going to have better access to things than the two-partner real estate agent down the road from me is going to have access to. To what extent can we leverage off CDD, KYC processes that have been undertaken by a reputable institution with the right processes that's involved as part of the transaction?
It's a very good question, Senator, and I might lead off, and I'm sure John will join in. But it starts with recognising that the proceeds of crime and money laundering are an ecosystem, and at different points in the ecosystem, different sectors have a role to play. And if we stay with the example you did, I come from a background, Senator, where one of the key outcomes of these reforms for me is that we enrich the intelligence dividend. And if you think about a real estate agent who is meeting in person with someone who is purchasing a property, there is no doubt that there will be potentially observations that the real estate agent can make that will not be captured in a digital transaction. And, that could stem from, a degree of a person could be under distress in the company of someone else as they are engaging with the real estate agent, as has often been seen by frontline bank staff. So from my perspective, it is that additional intelligence dividend that is absolutely critical. And if you think about the ecosystem, there's also a timing factor. Different stakeholders in the ecosystem will make observations, will receive information at different junctures. And therefore, the timeliness of the submission of reporting could allow a prevention of an act to actually occur further downstream. So everyone's got a role to play, and I think that ecosystem concept is critical here.
Yeah, I would agree with Paul there. And the only thing I'd add to that, Senator, is there's an assumption there that every purchase involves a financial institution. Some purchases of houses may not involve a mortgage, so the bank may not be involved. And I think, yeah, together to that, to echo Paul's point on the ecosystem, I think that is where some of these industries can share their intelligence into AUSTRAC, and the reason why the transfer entities are so important.
Yeah, look, I take on board both those points. My concern, though, is replication of the same process by multiple institutions. So Bank A does the CDD to find out if someone's a politically exposed person. The lawyer goes through the same process. The real estate agent goes through the same process. The lawyer on the other side goes through the same process. The bank on the other side goes through the same process. What are we achieving with that duplication? I would have thought there should be opportunities in relation to a lot of transactions, and there'll always be transactions which are somewhat different, which have a different risk profile, to be frank. But I would have thought there would be opportunities to leverage off searches which are done by, which have already been done in relation to an individual, in relation to a transaction. So you don't have institutions having to do exactly the same checks and going through exactly the same processes and potentially providing exactly the same information to the regulator, who gets inundated with all these reports because people are going to be overly anxious perhaps to share information. That's the concern I have. So it's about productivity, it's about efficiency, it's about cost, because if we don't meet those, if we don't get the cost-benefit analysis right, it's just going to add to the cost of transactions. So that's the maybe that gives a bit more flavour with respect to what I'm posing. But I'm left with the impression, gentlemen, and I'll give you an opportunity to respond to this, but I'm left with the impression that you're somewhat guarded about other institutions and professions in a transaction chain, if I can put it that way, leveraging off the work that your institutions do in terms of KYC and CDD. Is that am I right, or are you eager to share the benefit of your processes with accountants, real estate agents, and lawyers? Tell me what you think.
I think, Senator, we already do that via the regulator, via AUSTRAC, and so not only are we compliant with the current legislation, but we are contributors to the Fintel Alliance, which is operated by AUSTRAC. So again, it's both our compliance reporting and our intelligence that we provide. And so if you think about other industries also providing the different touch points, and remember, engagement with an individual will be different through a real estate lens as it will be through a banking lens, as it will be through a lawyer's lens. So it's actually those different points of differentiation, when combined, give law enforcement, in my view, a stronger position to move more swiftly.
The other thing I might just add to that, Senator, is if you don't have the ecosystem approach, you'll tend to find things will gravitate around the parts of the system that are contributing into that financial intelligence. So the example before, if there's not a mortgage or a payment is made in cash, you won't necessarily have the involvement of a bank in that transaction. And so you might see proceeds of crime or money laundering gravitating towards those channels because they're less likely to form part of the intelligence network used by law enforcement. The other point I would make in terms of the customer due diligence piece, I mean, establishing identity is not an overly onerous obligation. I mean, real estate agents, for example, go to great lengths to find out quite prescriptive information about prospective tenants in managing their process. So there is definitely a recognition that the size of the entity does need to be taken into account in terms of the burden that needs to be undertaken. But some of the obligations are not particularly onerous.
Senator Scott, I'll have to share the call in a moment if you've got another question or two.
Yeah, sure. But just one final question. But Mr. Taylor, ascertaining whether or not someone is the sister of a Myanmar general is somewhat more problematic. And even if you've got the opportunity to meet them face to face as a real estate agent, how you actually go about accessing the appropriate vendor or system to identify the risk, I guess, especially if you put on notice that maybe they're not a resident of Australia. You can see the problems raised in practice for especially small practices that don't typically have the experience, don't have the benefit of the gentlemen who are participating with you on this panel, and simply don't have the relationships with vendors, etc., to procure that information. How do we address that situation?
I think it's important to strike the right balance in terms of the obligations, which is why a principles-based approach is the right approach to take. It's also the importance of both AUSTRAC rules and guidance as to how to address these in a manner which is manageable and meaningfully contributes to the intelligence information provided to AUSTRAC. The ABA represents banks both large and small, and AUSTRAC compliance costs for AML-CTF are a sizable ongoing obligation. That's why we see the opportunity for some of this reform, which is about making these processes simpler, does provide even greater capacity for that more proportionate approach. Paul, I'm not sure if you want to add to that.
Look, probably just add the point, Senator. We've been thinking for some time now. We have that dual lens when it comes to these reforms. One is that, NAB, for example, potentially 55,000 of our customers are going to become reporting entities, in which case we want to draw on all our experience, our learnings, our failures, the things we think we're doing well, and share that with those potential reporting entities who are our customers. And I suspect the nature of that relationship is going to continue to evolve. So I think, that shouldn't be underestimated. We're very committed to supporting our customers through this journey.
Okay. Thank you, Chair.
Thanks very much, Senator Scarr, and thank you to our witnesses. I acknowledge your extensive experience in this area, and I'm hoping to lean on that a little in the questions that I put to you. Senator Scarr's put some very detailed questions to you about the issues you've raised, and I understand from your evidence that these are matters that are under discussion with the department. Right. So there's still a consultation going on about how to refine those issues, but otherwise supportive of the regime and the bill.
Yes, that's right. That's correct. Yeah.
Okay.
So we would hope to continue those discussions through the rules, and I think the rules will provide more clarity for us on the implementation of that.
Okay. And sorry to ask a very simple question that is obvious to everyone in the room, but maybe not those people watching along at home. your entities or banks are already have reporting requirements and part of the regime, and what is being proposed in this bill is to expand the regime and strengthen it. Can you explain to us why that's necessary? I mean, I know many of you have a lot of experience in managing this type of portfolio, and I think even Mr. Jetjovic, were you the former? Were you at AUSTRAC previously as well? I think you held a role there previously.
Yes, Senator. Right. I was the CEO of AUSTRAC from 2014 to 2017.
So why is it important we expand?
Yeah. Well, I might lead off and then colleagues will join in. I think, obviously, the bill endeavours to address a couple of things, not least of which it is outdated, and the environment in which the bill was promulgated in 2006 has significantly changed and continues to do so today at a rapid pace. So I don't think there's much debate about the need to simplify and modernise. The inclusion of Tranche 2, again, we've probably touched upon. The challenge in fighting organised crime, both from a government and a industry perspective, it continues to increase. And so we've started to make some, I think, over the last decade, positive inroads where both private sector and government works collaboratively. The addition of some of the Tranche 2 entities, I think, only serves to further strengthen those public-private partnerships. And as I mentioned earlier, one of the important areas that I think in the conversation about compliance gets forgotten is we're very reactive in this regime today. And I'm certain it's a shared desire, both in amongst government agencies, law enforcement and our industry, to become far more preventative. The inclusion of these broader entities will allow us to increase the intelligence dividend and allow us to become far more preventative, so we can harden the environment from the crimes, the predicate offences being committed in the first place. So from my perspective, I think that's obviously one of the important outcomes we're seeing.
Sorry to veer a little bit off your current expertise, but I was just wondering if you did have some views about this. There's going to be a conversation, and particularly probably in the parliamentary debate about this bill, about the cost of the regulations on Tranche 2 providers and what will be involved in them being compliant. But I imagine there's also a cost to the economy of not having these types of regimes in place, and a cost to our system by not having not being as effective as seen in other countries. I'm not sure if you have a comparison with what your colleagues in other countries are facing or the way they've been able to strengthen their regime. We certainly don't want to be grouped into the lower pile of countries that have been unable to lift their regimes as required. We've talked about the grey list a lot today, but in terms of international comparison, where are we standing?
Senator, I don't have any comparisons at my fingertips, but I mean, for us, we bring it back to the fact that the people we're trying to protect here are our customers, are Australian citizens. And yes, of course, there is a cost that comes with playing our role in that. We look to be as efficient as we possibly can, and this is where partnerships help share that challenge. But from my perspective, I don't have any comparisons I could make for the committee's reference.
Yeah. No, that's fine. For the other organisations, Mr. Taylor, you might want to answer this one. The submissions that you've made and evidence you've given today acknowledges that the reforms do actually achieve a goal of simplification and extend a benefit to all stakeholders. I just wonder if you can comment on that. I mean, simplification isn't a word that would be used with a, 300-page bill, I think, which is amending like 1,000 pages. It's a complicated piece of legislation. But the ultimate effect of this is a simplified regime, because the regime itself will apply to a broader range of entities, as I understand it.
Thank you, Chair, for the question. Yes, we do support the policy intent of the bill being both simplification and the extension to tranche 2 sectors. However, you are right, this is a complicated bill and a complicated regime, and it is important that we get it right. So we have said at the outset our support for the bill is subject to the amendments that we have suggested, and there are an extensive list of amendments suggested. We've tried to be as constructive as possible, and we are having constructive conversations with AGD. Having not had the benefit of an exposure draft, though, there is a lot of work that still needs to be done, we think, to just refine these provisions, and we're committed to working with the Department and AUSTRAC on finalising these provisions.
Well, thanks for that. And it's not often that you've appeared in front of our committee, but we certainly take the approach of making those suggested amendments through our report, and quite often they are accepted by the government. So if there are suggestions that we can also include, I think your submissions has recommendations, but if there's things you could take on notice that you'd like us to consider as recommendations in our report to the government, then that would be helpful. The other thing I just wanted to ask was about this obviously modernises the current regime, but there's been a lot of attempts at this type of reform. I think that the last attempt was back in 2004. We've had inquiries, particularly committee inquiries, I think as far back as 2015, and the most recent one was in 2022. This finally seeks to sort of implement some of those recommendations while also addressing the concerns of industry. In terms of those pain points that have come up before, how are they being addressed in the bill, the things that weren't looked at before in previous iterations of the reform? And you mentioned we're not quite there yet, but what are those outstanding things that we need to consider? I know you've mentioned them before, but it would be helpful to understand what has been addressed so far through the consultation you've done with Attorney Generals, and then what are the things that are left over? Mr. Taylor.
I'm happy to talk about one of them, Chair. One of the things I think that has been addressed, which we make in the CBA's submission, is certainly the tipping off provisions, and I think you've heard about this in the committee earlier today on information sharing, and I think that is an important piece that has caused some elements of discussion over those years since 2006 and the implementation of the current Act. And I think with the changing of the tipping off offence, it will enable us, not only as a bank and CBA, but across the industry, to be able to provide far better intelligence through to AUSTRAC and then to our law enforcement partners, but then also in the protection of the community. So I think that is one big step forward, and I think the clarity that we can get around information sharing is a big step forward. And I think if we can, as we put in our submission, CBA, if we can bring that forward on the implementation of that 28 days post royal assent of the bill, that would be very much appreciated.
Yeah, okay, thank you. Mr. Taylor, I'm not sure if you had anything to add to that.
Just to reiterate that point around a lot of the work that the banking industry is doing at the moment in scams, which does rely on a collaborative approach and an ecosystem approach where information is shared to protect consumers against scams and the risk of fraud. One of the reasons why the tipping off provisions and the changes there are so important is the AML law is intended to protect Australians, and in that context it's actually providing an impediment to information sharing that may otherwise help banks and other industries to protect consumers. So I would reinforce that has been something that is well understood in our consultations, and it's very welcome from the industry's perspective.
Okay, great. And one other question I had we've talked about sort of the cost and weighing that up against the benefit. One of the huge benefits of this is that information sharing and the ability for our intelligence agencies to have the information that they need. There's an inference in some of the submissions and some of the evidence or position of witnesses that we can fight this type of financial crime without expanding the regime to tranche 2 entities. Can we, I don't, I mean, that is probably a question for our intelligence agencies, but I thought as the financial experts who are dealing with the reality of financial crime, can we do one without the other? Mr. Jekovic, you might have an answer to that one.
Yeah, Senator, I think it comes back to, it's a really good question. It comes back to the issue of ecosystem, and I hate the mantra, but it does help explain how our thinking has shifted from, government or agencies and industry working in silos and scams is a very good example where it's absolutely unified government agencies and the private sector because of the real devastating impact it's having on Australians. And in that journey, what's become clear is that, initially there was a lot of discussion about the role of banks. But when people understood the ecosystem, what became evident was that banks are actually at the very end of the ecosystem of a scam being perpetrated on an Australian, when in fact you have social media platforms, telecommunication, that are facilitating the actual commission of the crime. And so this space is no different. And therefore, the more we can recognise the holistic end-to-end ecosystems that enable organised crime to launder their proceeds, the more effective we're going to be. And I think, it's often forgotten, scams is a predicate offence of our AML regime. And it's a very good example of how swiftly we can move and become more effective if we take that holistic view. That's what I believe Tranche 2 enables.
Thank you. I mean, and organised crime is just that, right? It's organised. They have an organised approach. So what this bill proposes is a more organised approach to detection and intelligence.
Agreed.
Yeah.
I agree.
Great. Well, thank you. That is all the time that we have to speak with you today, but we really do appreciate your evidence, your submissions and your consultation, your ongoing consultation on this bill. And this is part of that process too of refining those provisions. So thank you for your assistance. We appreciate it. We're going to go to our next set of witnesses straight away, but they all need to come up to the table and also we'll just maybe suspend the broadcast shortly to allow that to happen in a seamless way. I now welcome representatives from the Attorney General's Department and AUSTRAC. Thank you for taking the time to speak with the committee today. Information on parliamentary privilege and the protection of witness and evidence has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Take a breath. For the Hansard record, can you each please state your full name and the capacity in which you appear today? And we'll just start at the end of the table. Thank you.
Thanks, Senator. Tim Lear. I'm the General Counsel and the National Manager of Legal and Enforcement at AUSTRAC.
Senator Jonathan Brewer, the Acting Deputy CEO of Intelligence at AUSTRAC.
I'm Daniel Mossop. I'm the National Manager for Policy, Rules and Guidance at AUSTRAC.
Peter Soros, Deputy CEO at AUSTRAC for Regulation.
Andrew Warnes, First Assistant Secretary at the Attorney General's Department, responsible for criminal justice.
Alex Engel, Assistant Secretary, Transnational Crime Branch, Attorney General's Department.
Caroline Yuan, Director of the Economic Crime Section in the Transnational Crime Branch, Attorney General's Department.
That's a long one. Great. Thank you very much for being here. We appreciate it. Do either of your organisations have an opening statement?
Chair, I have one, but in the interest of time, I might do a very abridged one just to say that obviously the committee has received our submissions. You've received our supplementary submission where we tried to address some of the issues that were raised in the submissions. So we'll take those as read. Happy to answer any questions. One thing I will reflect on, we've all been watching the evidence throughout the day. I think one thing that's come through strongly, which is very pleasing for me, is the level of consultation that you've heard across all of the witnesses, particularly those professions that will be regulated under Tranche 2 entities. I think if you look at previous hearings on incorporating Tranche 2 entities into the AML-CTF regime, we probably haven't had any hearings where lawyers, accountants and real estate agents have all said they would in some way, shape or form welcome the obligations. That's, I think, testament to the collaborative partnership that we've been able to engage with them, and I'd like to put on record our appreciation. We realise AML-CTF isn't their day job, and we've had a lot of engagement from a lot of the witnesses you've seen today, so we very much appreciate it and look forward to taking any of your questions.
Thank you. And we'll come back to you before we go to other senators, but did you have an opening statement?
No, we'll just echo what Attorney General's Department said. We've been in lockstep on this work together.
We do have the benefit of the submissions. Before I hand to other senators, you provided a supplementary submission, I think yesterday or very recently. Could you just step us through, if you can, if you're able to quickly, that supplementary submission? I know I know there's a lot of detail in there, but what issues that supplementary submission addressed, and that way senators will know what we can tick off as being considered by the Attorney General's Department.
Yeah, thank you very much, Senator. So I'm happy to go through and get my colleagues to jump in as we sort of dive through it. So we did go through sort of AML-CTF programs and the requirement to look at foreign branches and subsidiaries. So there'd been some questions about how that requirement played out. And so we've tried to take a little bit of time to step through the high-level principles in which we will do that regulation. And so there was some concern that maybe it would be a bit prescriptive and a bit difficult to understand. We've tried to step out how that will work. I think one of the recurring themes that you will hear probably throughout our evidence, and you heard from earlier evidence, is a lot of this can be worked through in the rules as well, and the rules are really important, and the guidance that AUSTRAC will then provide to work through some of the detail. So the purpose of the Act, I know you mentioned earlier it was some 300 pages adding on to 1,000 pages, but it's meant to be high-level principles based, and then the rules is where you really get into the good stuff and get into the detail, and we're going through that process at the moment and collaborating with industry on that. So the idea of the bill there is to set out high-level principles for all reporting entities that are aligned with the international standards. We talked a little bit about the conflict of laws there and how that would work. We spoke about customer due diligence framework. So some submitters, I think, were a little bit concerned that we were going more prescriptive with customer due diligence. What we would say is the current Act looks a bit like a ticker box regime in some places, and that doesn't really facilitate good compliance. If you've got a ticker box regime, it doesn't require you to think about the outcome you're actually trying to achieve. And the outcome you're trying to achieve in customer due diligence is knowing your customer. So we've kind of set out why we think it's more appropriate to have that sort of principles-based approach. We've talked about some of the timings for initial customer due diligence, which I think was raised just previously. I missed a little bit of the evidence hopping up here, but with the banks. So that was raised as well, and we've talked about that. We've talked about keep open notices and how we envisage that will work. We talked about the scope of designated services. I know that came up earlier in the day about the coverage of barristers, for example. So we covered that off in the submission about how we view that generally barristers won't be covered, but obviously the model that we've come up with relies on a designated service model. So we're not regulating all profession or all of a particular type of profession. So not all lawyers will be covered under this regime, and I think it's really important to understand that. It will be those people who are providing those designated services that will be covered, and not all lawyers or not all barristers will provide those designated services. That's really fundamental. So we spent a bit of time talking about that. We spoke about the tipping off offence and how the tipping off offence is meant to work. So we went through and outlined. Some people had a few questions about that offence. I think one thing I'd say is generally the feedback we've heard from industry is they're really pleased with the tipping off offence, really pleased with the information sharing ability, and we think that'll be really fundamental to improving that offence and allowing more sharing to combat illicit financing. I'm coming to the end.
It's okay. We have time.
IFTs, so international value transfer services and the travel rule requirements. When you talk about complexity, they're very complex, and AUSTRAC can talk you through those more if you'd like, but just talked about some of the criteria and how we're planning on rolling that through. And then some questions that came up around civil penalty issues, the burden of proof, why it's appropriate to have that burden of proof with civil penalties. And there was a question raised about ongoing civil penalties and whether these penalties will be ongoing. And we just clarified that once the conduct stops, the penalties stop. So that clarified some of the questions that arose out of the submissions there. A big one that came up was Australia's risk of FATF grey listing, and we've heard that again today. So we went through, in particular, the changes that will be made to the FATF process going forward. So they will become even more stringent. It's kind of expected already that countries will be technically compliant by the 5th round, somewhere where Australia already falls down, let alone being effective in terms of that technical compliance. So we just stepped through that. Stepped through that there's actually 2 pathways to grey listing, so it's not just your mutual evaluation. That's one way and the most common way that jurisdictions come under increased monitoring, but also there is a way under the new procedures where you'll get a set of key recommended actions, and if you don't comply with those key recommended actions, you will end up probably back in enhanced monitoring, increased monitoring again. And so what that would mean practically is if we went through a mutual evaluation with the law as it is now, if we weren't grey listed, which we think is unlikely, but if we weren't grey listed, what would happen then is we get a key recommended action to regulate DNFPBs or tranche 2 entities, and then if we didn't do that, they would put us into the grey list bucket. So it doesn't matter which way you get there, we think we will end up getting there in some way. We can also be directly referred for grey listing, so just on the basis of our failure to comply with fundamental FATF standards. So countries can automatically just select countries who have fundamental failings in their money laundering systems and direct refer them. Now, in June 2024, the FATF released its horizontal report about compliance with DNFPB regulation. It put Australia right down the bottom, unfortunately, at a very round number of 0% compliant. And so there was already talk. I have the privilege of attending FATF as Australia's head of delegation, and there was already talk of putting Australia directly into grey listing on the basis of that report alone. So I think we've certainly seen that FATF is well aware of our non-compliance and is expecting compliance to be increased and is looking at this very legislation that's before Parliament and wanting to know updates about the progress of it through there.
Yeah, thank you.
I will leave it there.
Thank you. I appreciate that. I know that was a quick summary, but I think it would be helpful. I think some senators might have only got the benefit of that submission recently. Senator Scarr, we'll hand the call to you, and you have questions, I believe.
Thank you, Chair. And Thank you to the department and representatives of AUSTRAC, and I must say I too have been impressed that the witnesses attending today have noted that they've had positive consultation experiences with the department. So that is a positive, and I acknowledge that. And I also acknowledge the helpful supplementary submission that was provided, which anticipated very well some of the questions that would reasonably be expected to be asked through this panel. So thank you as well for that. That was very useful. Thank you. I'll start with the lawyers. There is concern, firstly, in relation to the barristers about whether or not they should be captured by this legislation at all. Can I ask you in simple terms and I followed the comments you made in the supplementary submission, but from the government's perspective, what is the intent in terms of the work that barristers might undertake being captured? What is intended to be captured?
Yeah, thanks very much, Senator. So I think it's really important, as I sort of mentioned earlier, to say, consistent with the designated services model, we don't provide blanket exemptions for any sectors or professions. So what we're really trying to do is highlight where we think there are transactions that go on in the generally in the financial, property, real estate space, advising's about setting up corporate structures that carry with it an inherent money laundering risk. So we've made a risk-based approach has been taken there to list the designated services that we think should have those obligations to make sure that you're checking for money laundering risk, and those obligations, I won't go through them in detail, but as you know, knowing your customer, due diligence, having a program. When it comes to who should have those actual obligations, not dissimilar to what you heard from accountants, Senator, it doesn't, to us, I think, matter what you might call yourself, whether you call yourself a solicitor or a barrister or an accountant or a real estate agent. What matters is, are you performing that designated service? And through our supplementary submission, we've been at a fair pains to say that we don't think generally barristers will be performing those sorts of designated services. Now, we think there might be situations where barristers do perform those designated services. There was quite a bit of discussion about the UK model, and barristers are certainly captured there. So we're not looking... the reason there's not a blanket exemption is because we can envisage circumstances where barristers might provide designated services. Do we think it's highly unlikely that they will? Yes. Do most barristers even provide advice in these sorts of areas? Sure, some do, a lot won't. Just like a lot of lawyers won't as well. Your general family lawyer may never provide advice in this sort of thing. Your general criminal lawyer may not be captured because they're providing criminal defence work. That's generally not going to come within the designated services as they are articulated in Table 6 of the bill.
Okay. All right. Well, look, there's probably some analysis to be undertaken going through those designated services and just comparing it to the concerns that have been raised by members of the bar and very senior members of the bar.
Senator, can I just add? Sorry to interrupt. May I just add that we agree that we're really keen to continue to work with the bar, and we've been in constant conversation with the bar and the Law Council, and we think there's a lot of ways we can address this through guidance material, and AUSTRAC will work and we'll do education to make sure that people aren't kind of over-regulating themselves and putting themselves into a category where they think they need to do this, where we're saying from a regulator approach or a policy approach that they're not required to do it. So we have, as you heard, been in constant conversation with them and will continue to do so. And I think we can provide a lot more clarity through rules and guidance to help allay any of those concerns.
Okay, so just to give you an example, the Victorian Bar refers to, on page 2 of its submission, Furthermore, there is a real risk that making individual barristers register so they can advise on contracts being executed by law firms and accounting firms will force junior and country practitioners to stop servicing basic requests for advice, like whether a contract can be terminated, needs to be stamped, or should be produced to the Commissioner of Taxation for discussion, end quote. So they're referring to basic advisory roles where they're not actually implementing a transaction themselves, but advice is sought with respect to a transaction that is being implemented. So they're one step removed from the process in terms of providing advice, but there's a clear concern that they might be captured as providing a designated service because they're associated with the transaction in some way.
Might let Mr Angle respond to that one, but
No, thanks, Senator. Yeah, that would be right, is in our view of how the designated services work, is that they don't have that sort of direct relationship under the Act. It's customer, but for a lawyer with a client there. So when they're doing that advocacy work, that's not intended to be captured by the designated services. So if they're one step removed like that, they're not involved directly in the underlying transaction, which would normally most of the designated services go to. So there is that, I guess, distance that they have, and in the way that the policy intent and our view of the bill is that they would not be captured by the designated services.
Okay. An issue's obviously been raised about legal professional privilege, and the issue's been raised from different sides of the debate. One question that has been raised is, what are the checks and balances in place to mitigate a situation where legal professional privilege is claimed illegitimately? What process responds under the legislation to prevent the improper claiming of legal professional privilege to frustrate reporting obligations?
Yeah, thanks very much, Senator. We've heard that evidence. I think generally the process is by which there has to be a submission of the form, the LPP form, to AUSTRAC, and then AUSTRAC have the ability to ostensibly contest that under the bill. So it provides a mechanism by which to contest it. I think it's really important to say that the court will be an ultimate arbiter of that. We don't want to take everyone to court every day, so there's a range of alternative dispute mechanisms, and we envisage a lot of these things will be resolved through conversations with the regulator and the lawyer involved, but ultimately it can also be decided by the court as well. I like to give lawyers a bit of credit. I think hopefully we will see them use legal professional privilege appropriately in most cases. I mean, we've all heard about the cases where there's been some particularly bad actors with that, but we think by and large people know what constitutes LPP. It's a well-established doctrine. It's claimed in a variety of other cases across the Commonwealth statute, and all we've done here is sought to preserve that well-established common law doctrine and provide a mechanism to resolve dispute.
Well, I agree with you that it's, I think in the vast majority of cases, legal professional privilege will be properly claimed, but it's good to get your observations and the check and balance on the record. I want to read to you from paragraph 480 of the explanatory memorandum. For those listening, I got that far, page 102.
Did very well.
And it says this, and I'll read this for the benefit of Hansard, in the context of legal practitioners, qualified accountants, having made suspicious matter reporting and then engaging with a client. For example, in discussions with a client, a legal practitioner or qualified accountant should focus on the client's financial activities and how they could be breaking the law. The reporting entity should try not to disclose that they have submitted or are required to submit a SMR. Specifically disclosing that they have or will submit an SMR would or could reasonably be expected to prejudice an investigation, even if the exception allows it, end quote. Now, I must admit, in previous life I was a legal practitioner, trying to work out how that would work in practice as a legal practitioner in a situation where you're dealing with someone who is perhaps quite sophisticated and trying to maintain compliance with the policy intent expressed in that paragraph could be an extraordinarily difficult thing to do in practice. The client might well just ask you, have you made an SMR, right? And that then leads to the issue that was canvassed earlier today about, in particular, a legal practitioner who's also an officer of the court being left in this invidious position of having on the one hand an obligation which, as you state in the supplementary submission, trumps the fiduciary duty to the client, having an obligation to make an SMR, but on the other hand, being faced with this practical dilemma as to how to continue to act for the client in those circumstances, and add on top of that a situation where if the legal practitioner seeks to withdraw, it may well be a court, a judge seeks an explanation as to why the legal practitioner wishes to withdraw, because it could well prejudice the conduct of the trial. To what extent has the department engaged in discourse with the profession in relation to those sorts of practical examples which are causing discomfort to the profession? In terms of what do we do when we're torn between our obligation under this bill on the one hand and our ethical obligation, fiduciary duty to our client, and our greater duty to the court as part of the administration of justice?
Thanks very much, Senator. And it's certainly a complex question, but what I would say is that when you think about the types, I don't think it will come up in a trial sense too often here when you're talking about this obligation. We're talking about advising on transactions here, and you imagine someone walking into a small suburban practice and asking to come up with a complex legal structure to deposit this bag of cash. I think what you are going to find is that very quickly there is a suspicion triggered, and when that suspicion is triggered, it wouldn't be that a solicitor would continue to act and say, no worries, I have a duty to you. I will now set up a structure that I think is going to breach the law here and allow you to launder money. And I think Dr. Zernzak's evidence that he gave sort of went to that point, that lawyers aren't going to switch off their brains here. What will actually happen with an SMR, I imagine in most cases, is the SMR will happen after that interaction is finished, and they will say, guess who came into my office, AUSTRAC? This didn't smell right at all. I sent him away, and here's the details that I was able to get. And that may well then build in a piece of the financial intelligence picture for AUSTRAC to go about its work trying to dismantle serious and organised crime. Pete, is there anything you want to add to that?
No, look, other than, Senator, some of these very detailed scenario-based questions are things that we're going to be working really constructively with industry on, you know, well beyond the passage of any legislation. We'll be working with industry, and we've already established workshops with each of the separate industry sectors on how we'll draft rules with their input, how we'll develop guidance with their input. And so a lot of these detailed scenario-based things are things we fully expect to work through. And I think some of the industry sectors have already alluded to the fact that that's already kicked off. And will be continuing for months as we, you know, work through that level of detail with them. So,
you accept the proposition that an outcome we do not want is any of the members of the professions, including the lawyers, any of them, looking at their obligations under this regime and looking at their obligations as officers of the court. And saying, I can't comply with both, I don't know what to do. Is there a determination to avoid that outcome? Because that would be quite appalling.
Absolutely, Senator. And what I would say is we're confident we can, because we've seen in a very, very, very large number of jurisdictions across the world, they've been able to regulate lawyers in a way that they have been able to do that.
Okay. Okay, if I can move on to the real estate agents. One of the, did you have the opportunity to hear their evidence during the course?
Yes, I did, Senator.
Okay. What else would you be doing but following this Senate committee hearing?
Absolutely nothing, Senator.
I think one of the themes, and I've given the scenario to a number of witnesses, but obviously we want to promote efficiency, productivity. We want to limit the cost imposition. We don't want people going through the same processes that have been done before, from my perspective, where there's no real incremental value added. So the Real Estate Institute of Queensland has put forward proposals with respect to how their members could potentially leverage off existing platforms like PEXA to meet their obligations. To what extent is government looking through the vehicle of the rules or some other way to leverage off those technology-related systems that exist in order to mitigate the potential cost implications, especially for small real estate agent firms?
Yeah, thank you, Senator. The short answer is to a very large extent. That's exactly why the bill sets out high-level principles and doesn't ascribe prescriptive ways in which each sector has to comply with their obligations. We're really cognizant that in a range of these professions, they're already undertaking a large range of customer due diligence. There's not too many real estate agents who don't want to know where their customer is. There's been some evidence today, who their customer is. There's been some evidence today about in tenancy arrangements, how much details they ask for. We know there's a range of people involved across the transaction. I thought some of the answers you got from the banking sector just before our appearance was really important there, but there's a whole of ecosystem approach, and people do see different things at different times and different points in the transaction. And so we're really committed to making this as easy to comply with as possible. On the costings, I think it's really important to note that some of those upfront costings go particularly to having an AML CTF program. So it's not actually the customer due diligence when you look at the impact analysis that has the large amount of cost associated with it. There is certainly some cost associated with it, but having an AML CTF program and complying with your AML CTF program, I think I might throw to AUSTRAC, if it's all right, Senator, to talk about what they're going to do to try and help small business reduce that initial cost of having a program.
Excellent, thank you.
Yes, Senator, one of the things that we've already indicated to the tranche 2 industry sectors that we're keen to explore with them in some detail through these workshops that we're going to be having is looking at particularly small, low complexity businesses, you know, your suburban real estate agent or your accountant or lawyer, and where their risks aren't as complex and as significant and they've got a smaller, more containable operation. We want to work with those businesses to basically develop a program kit or a starter program that they could simply apply. I think the impact analysis may have envisaged that small businesses would need to hire a consultant to help them with that. But what we're keen to work with these sectors on and with their peak bodies and membership groups themselves is how we can consider the risks that a small real estate agent or a small accountant or a small a solicitor may have, and then think about having sectoral program kits that they can use with some tailoring, adapting to their specific circumstances. But they don't have to start from a blank piece of paper and get advice on how to do it. They can work with AUSTRAC starter program or starter kits and look at our guidance and then be able to do that. So we're always looking at how we can relieve the burden, particularly for the small businesses that don't have so much complexity. As your business gets bigger and more complex, of course, we would expect the businesses take that time to understand their risks and develop more fulsome programs. But for a lot of those small businesses, we're very committed to supporting them through that process.
Well, I really compliment you on that because I think that's really important. And one of the concerns I had was all these one or two member practices are going to be running around trying to get a consultant to come and develop their systems for them, and there's going to be a scarcity of consultants in the market. It's going to take time, it's going to take cost. So what you're telling me indicates that AUSTRAC's aware of that issue and you're looking at ways to mitigate that. So potentially they can get going simply through off-the-shelf, if you like, guidance through their professional organisations or directly through AUSTRAC. Is that correct?
That's correct, Senator. I mean, yes, they'll have to still consider, it won't just be off the shelf, there it is. They'll have to do a tiny bit of tweaking, but they won't be starting from a blank sheet of paper. And these are the exact things that we want to work through and design with those industry bodies to leverage their expertise and knowledge of their sectors. Okay. Property Council of Australia raised leasehold interest thresholds. Should the period of time for a leasehold interest be 20 years, 50 years? What should it be? Is it a Dutch auction? Should it be 35?
I noted that conversation, Senator. We think the bill strikes an appropriate balance. What the policy intent here is to try and convey when does something go from a short-term lease into something that resembles ownership and attaches with it some form of money laundering risk. We agree in some senses there's no exact science to that. We've drawn in conversations from sectors, we've gotten our own advice about it. We're reasonably confident with where the threshold sits. I think when you heard the evidence from the Property Council, and I don't want to misquote it, but it didn't sound to me like they were concerned about thousands and thousands of 30-year leases that were, we're talking about some niche scenarios here where it might pull them in, and we don't think that's inappropriate. If you went to something like a 99-year lease, you could see some issues with that. So that's why we drew the line where we did, Senator. Okay.
Senator Scott, I'm going to share the call in a moment, but as I've indicated previously, we'll probably have time to come back to you again, but I'll have to hand the call to Senator Polley in a moment. Yeah. She's itching to ask some questions.
No, I can tell. I can sense it all the way here in Brisbane. Well, my final question then before you share the call, Chair. In relation to politically exposed persons, I understand the sensitivity, the elevated risk, but one of the concerns I have is the big banks have access to systems provided by vendors, which they have access to. They've got economies of scale in that regard. If you're a small practice, you've got someone who comes into the office. They might be someone from a close neighbour in the Pacific. You're not necessarily going to know whether or not they've got any link to government at all. How are small practices in particular meant to practically undertake a process to identify and verify whether or not someone is a politically exposed person? What's the practical expectation in that regard?
Yeah, I might pass to AUSTRAC, Senator, because there is 16,000 entities roughly already regulated under the regime, and some of those, we talk about the big four banks a lot, right, because they are regulated and play a big part of the market, but we already have a wide-ranging sector size in there, and there is guidance that AUSTRAC have around how to think about this and how they can support people with this sort of consideration. So I'll pass to Mr. Soros.
So, Senator, as Andrew said, we already regulate big and small businesses, small money remittance businesses or pubs and clubs who have a certain amount of pokey. So we already work with guidance with those sectors about how to do your PEP screening or how to look out for PEPs, and I'll hand over to Dan Mossop, our National Manager, who writes most of it. So.
Yeah, thanks, Senator. Look, it's a really good question, and you're channeling industry because that's the question, we get a lot, and there's probably a couple of different levels to it. I mean, the first is that the entire risk-based regime of AML-CTF regulation talks about the nature, size and complexity of the business, and that's really about having different expectations for very large entities down to very small entities, and that plays through when we talk about establishing whether someone is a PEP. we talk about that establishing on reasonable grounds. So there's a reasonableness test that's built in about whether they can identify that someone is a PEP. So I think if they take reasonable measures based on the nature, size and complexity of their business, for a very small business, that may be simply Googling the person's name and seeing if anything relevant pops up. For a very small business, for a low-risk transaction, as those risks go up, you might think about plugging into one of the WorldCheck systems that's available so you can get more detailed information. But at the lower end, for lower risk transactions, I think that's what we're talking about, and asking some questions. I think, as you've said in your earlier discussions, they have the opportunity to ask people questions about their occupation, their nationality, to try and maybe give some clues as to whether they might fall within the category of a politically exposed person.
Is there any central system that I can access apart from Googling to access that sort of information if I have?
There are public sector.
Something?
Sorry, there are private sector companies that offer these sort of solutions and have a range of commercial arrangements that are pretty widely used and accessible. Okay. So there are lots of private sector companies that offer those sort of services.
Okay. All right. Thank you, Chair.
Thanks very much, Senator Scarr. Senator Polley, we are coming to you.
Thank you very much, Chair. We've actually canvassed through the course of evidence today, talking about the potential of Australia being listed, being grey listed. So I was just wondering if you could talk us through whether or not that is something that the department is concerned about and what impact that would have on Australia.
Thank you very much, Senator. The department is very concerned about that. As I think I mentioned earlier in my evidence, Australia's head of delegation, and I'd prefer not to be the first head of delegation that presides over Australia's grey listing. It would not be my preferred approach. And so we're concerned about that because we're one of only 5 jurisdictions that has 0% compliance with regulating DNFPBs. It's important to note, as some submitters have pointed out, it's not the only criterion in which you can get grey listed, but it is a substantial deficiency in our regime, and we have a range of other deficiencies in our regime, as do a range of other countries. So we're not the only country that doesn't have perfect AML-CTF compliance across the 40 FATF recommendations. But these recommendations are seen as being special in some regards and extra important because they regulate what the FATF and the international community has agreed are high-risk professions. They are the gatekeepers to the financial sector, and they provide a special and kind of privileged pathway to the laundering of funds. As I mentioned earlier, Australia's been repeatedly criticised for its total non-compliance. In July 2024, the horizontal report by the FATF gave us a 0 rating, and failure to address this serious long-standing deficiency does put us at significant risk when we're assessed next in the back end of 2026. As I mentioned, the FATF requirements aren't static, and in each round, so we're about to move into the 5th round of assessments, and in each round the expectations ramp up because people expect that you've made some efforts already to comply, and so the expectations get higher. We're going to be going in, if this legislation isn't passed, we're going to be going in with a situation where we've not been compliant with this since 2005. It's not a particularly good look for Australia. It's not a good look when we're a founding FATF member and we help set up these standards, and it's not a good look for us when we pass judgment on other countries who don't implement these standards. So we sit in judgment and send other people to increased monitoring or the grey list, as it's colloquially known, for similarly not complying with these sorts of regimes. So it does give us some cause for concern. I think the second part of your question asked about the costs of that and sort of what would be the impact. We think it would be incredibly significant. It's set out in the impact analysis. It talks about $10.1 billion of potential cost to our economy. You've heard some conflicting evidence throughout the day about the likelihood of that and the size of that impact. I would say I think it's somewhat undercooked. We were very much trying to hold a hard line about costing only the things we thought we could reasonably justify in this impact analysis. You've heard that some countries in the IMF study suggest it could be a 7.6% decline in GDP for countries that are grey listed. We don't think as a developed economy will experience that level of decline. But for example, even if we were to experience a 1% decline in GDP, I think that equates to about $20 billion a year in costs. So we haven't costed that out here in the overall $13.1 billion of benefits, but there are a range of other things that could impact Australia that we just don't know. No country, no developed country the size of Australia, $10.7 billion in grey listing. No country the size of Australia's economy has been grey listed. We would be a bit of a test case for what would happen to such a developed economy, and I don't think it's a test case that we particularly want to be.
Thank you for that. Just in relation to, this is tranche 2, when was the first tranche and who brought that in? Which government? Tranche 1, or bringing in... When was that?
That was in 2005, 2006? 2006. It came in to... so yes, and I believe that Attorney General Ruddick brought that in. I had cause to look at his second reading speech as I was preparing for this hearing, and he did note that work on the second tranche of reforms will commence after implementation of the first tranche. So we've maybe taken a little bit longer than he envisaged in 2006.
I know people do say government wheels turn slowly, but that's ridiculous. Just in terms of your submission refers to the cost of regulation to businesses, and we've heard a lot, and I know you've actually made some points already about smaller entities and the cost on them. These reforms need to happen very quickly. How damaging would it be for us not to get these passed this year before the end of the parliamentary session?
Yeah, thank you. I mean, obviously, as always, passage is a matter for Parliament, and I wouldn't comment on that. What I would say is what we've heard from industry throughout the kind of almost 2 years that we've been consulting on these reforms is the need to give industry time. Time is the one thing that we've heard. They want detailed consultation, but more than anything, we've heard repeatedly over more than 100 consultations that we've done, and I think we've received over 270 submissions, that they want time to implement this. And the importance of passage is that it allows time. So you'll see in the bill that we've allowed for commencement of some of these obligations in mid-2026. And so the importance of passing it now is to give industry certainty about that, and then also to be able to give them the time to make the system changes they might need. For AUSTRAC to do the educate, it's a big lift for AUSTRAC as well. They're about to regulate a lot more entities, so to give AUSTRAC time, both with their systems and also to allow them time to do the education and work with the professional bodies. If we don't have passage of the legislation, it's very difficult to work on rules and guidance without the primary legislation in place. You need that certainty. So that's one aspect of time. The other aspect of time is that we have the mutual evaluation looming. That will come up on us very quickly. We will need to start preparing for that next year. The first part is kind of a desktop review of everything and submitting information to the FATF. So we need time to be able to do that, and we need time to be able to demonstrate our effectiveness. Now, even if we put these laws in now, we won't get a lot of points for effectiveness of our regime because FATF looks back over a 5-year period, but we'll get more credit for doing something than we will get for doing nothing, and we won't get any effectiveness at all if we don't have that legislation in place.
Now, before I move on to AUSTRAC, in terms of in the consultation process, and it's been raised today, the need for training. Has the department been involved in consultation, and is there any assistance going to be provided for training for these new smaller entities?
Yeah, I think I'll pass that question to AUSTRAC, Senator.
So, Senator, we've been engaging with AGD in lockstep on the legislation, but we're already moving beyond the legislative engagement into the rules and the guidance and the education, and we're working incredibly closely with all of those industry sectors. We want to learn from those industry associations about which channels their members choose to get information from, what sources they trust, how they learn best, so that we can develop really targeted education and guidance programs to help these small businesses get up and running and be able to implement these laws effectively. We'll be doing that right up until the commencement date in 2026, but we're starting now well in advance so that we can learn with industry together and be able to use the best channels and tools to help them understand their obligations well in advance. So that is a key priority for the CEO downwards, for the whole agency to really invest heavily in that work early.
Now, I'm fairly aware personally of the work that AUSTRAC does because of my other committee, but I was just wondering if you could outline to the committee the work that you do in combating money laundering and counter-terrorism, and what this will actually mean to your workload as well.
Yeah, sure. Well, look, I'll hand to our Deputy CEO for Intelligence because we've talked a lot about the regulation that businesses will face and how we're helping them on a regulatory perspective with education and guidance. But it's the intelligence side of our business that benefits when we have that really good reporting coming in from industry. So I'll hand over to my deputy colleague John Brewer to talk about the intelligence collection, how we work with law enforcement partners and what Tranche 2 will hopefully enable us.
Thanks, Pete. Senator, probably one of the first things I'd say is we've heard some evidence today about the ecosystem and the gaps in the ecosystem, and if those gaps were filled through the passage of this bill, then there'd be more information, more reporting into AUSTRAC. So that's the very first step of what we do, is we receive that reporting. We've got some very clever analysts make sense of it at the higher order end of financial intelligence, and our colleagues in AFP noted how important financial intelligence is to everyone in their investigations earlier today in evidence. So it's our provision of that financial intelligence to our law enforcement partners is just one aspect of what we do to combat it. We also make that data, that intelligence available to a number of our partners who are authorised to access it for themselves. And in not the last financial year, but the recent financial year, it's about 10.3 million searches have been done by our partners on our information. So it's not just us providing the higher order of financial intelligence, it's the partners getting what they need for themselves to allow them to undertake their mandate. And probably the last aspect I'll touch on is our engagement with industry. And you've heard some of our colleagues in the banking evidence session talk about the Fintel Alliance and our membership with industry in that and the collaborative approach we take in working together. So we will identify, assess things, provide intelligence to law enforcement for them to take action, but we'll also turn that into guidance and advice for industry, and that's all industry, not just members of the Fintel Alliance, so they can harden their systems and again make it tougher for the criminals against whatever the crime type is.
So AUSTRAC has obviously been very involved, I assume, within the consultation process. So you've outlined some of the things that you're doing in relation to training and education. So is there a future plan in relation to consultation, particularly with these new smaller, medium entities?
Absolutely, Senator. So our CEO has already kicked off industry engagement forums. We've got one forum specifically for the existing regulatory population, and we've got a whole other forum for all of these new Tranche 2 entities. So we're already engaging with those industry associations in those sectors. Beyond that, we've also established a series of industry-based workshops, and they're kicking off from next week, where we'll be having a workshop with the accounting profession, a workshop with the legal profession, a workshop with the real estate profession, and we'll start workshopping through with them how we will develop the rules, how we'll develop guidance. And so those workshops will be ongoing. We're really investing time and energy now, as I mentioned, so that we can get their views and perspectives on what guidance and what rules are going to work best for them. And we're developing guidance now quite early so that industry knows well in advance of things commencing what they need to do, how they'll be able to do it. And so those workshops and industry forums will continue on during the course of all of next year, all the way into the lead up of implementation. So we're very committed. Our CEO personally is chairing those industry engagement forums, shows his level of commitment, and therefore all of ours, to make sure that industry is positively engaged, really understands what they need to do, and is supported as much as possible through AUSTRAC.
There's going to be a significant workload increase for AUSTRAC. How are you managing that going forward?
Well, Senator, we've been fortunate in that we've already received a significant funding injection in the budget earlier this year. The government's already provided 2 years' worth of funding and a significant amount of funding. I'll just turn to my colleagues for the dollar figure for that, but it's $160 odd million. So it's a very big funding injection boost for us, and that's in recognition of the fact that not only is this significant for industry, but it's also going to be quite a big shift for AUSTRAC. We're going to need to have our systems in place. We're going to need to develop all that education and training for industry. We're going to need to have a different regulatory model that helps us supervise 100,000 businesses. Potentially it may be that sort of size population. And so the government's very committed to supporting AUSTRAC very early on with that significant funding injection to help us really kickstart this nice and early and support industry and help us get those intelligence benefits that we need.
Thank you for that. So obviously planning has been beyond just this legislation, but my final question before I get booted is to the AG's office. Barristers and other witnesses today have actually raised concerns about the onus being placed on them. But this new regime, how will it impact potentially any pro bono work or public interest work that's been done? Have you got any views on that? Can you just talk us through that as a lay person about the impact that it's going to have in those areas of concern?
Senator, I'm just going to check with my colleagues, but I don't think there's been any concerns raised with us to date, but I'll just check along the table if anyone's... Yeah, generally a lot of that pro bono work won't fall into designated services. I don't think there's too much pro bono work going on around creating complex corporate structures or other things. It tends to be, a different type of work. So I'd have to say there hasn't been a lot raised with me. I'm just looking down the table in case I'm corrected by my colleagues.
Mentioning some of the submissions to the committee that we've looked at, but I think that would be accurate depending on the pro bono work. A lot of them wouldn't fall into the designated services that we're proposing. And then depending on how they're undertaken, if we're talking about barristers and advocacy work, once again, as mentioned earlier, most of that would not fit into the designated services as well.
I think that's important to have that on the record. So thank you, Chair.
Thanks so much, Senator Polly. Senator Scott, as promised, we've got a little bit of time left if you have a final question.
So I just wanted to confirm with AUSTRAC that given the significant funding boost received under the last budget, AUSTRAC doesn't need any more funds. Is that the evidence that's been given today?
Senator, they're matters for government about future funding, but that's for 2 years worth of funding. I'll just point out.
Okay. Sorry, I'm being a bit cheeky because
that's okay. That's okay.
It's very rare for a government entity to say that the cup runneth over. No, I don't think you said that.
No, I don't think a regulator would ever be happy with the amount of, they're always going to be tight for funding. Any regulator or law enforcement agency would say that, Senator.
Can I just one final question? The Australian Bankers Association did give us an extensive appendix of proposed drafting changes, and they say they are in constructive discussions with government in relation to those changes. Is that still a work in progress?
Yeah, I won't comment on drafting by bankers. I think what I'll say is we're working really closely with them because I think we can work with them through a lot of this, as I said before, to allay some of those concerns through rules and guidance. So that's what is in progress. Obviously, the bill that you see before you is the bill, Senator, but we're working incredibly closely because there's great scope to pick up a lot of that stuff in rules and guidance, and we've given an ironclad commitment that we're going to continue the strong engagement that we've had to date with all of these sectors to pick up that as we go through the rules process.
If it helps, Senator, there's probably two major issues that they did raise. One was around the CDD issue. That's something that we can resolve through the rules. The second one was some timing around changes to what they call IFDs, or which will change to IVTS. But you'll see in the bill that there's an arrangement there for a commencement period that takes into account some technology changes and other changes that might be happening globally. So that's a little bit different to most or the vast majority of the bill. There are some transitional powers in there to account for IT and technology changes, particularly for those banks.
Okay. All right. Thank you, Chair.
Thanks very much, Senator Scarr. That's all the questions we have for you. Thank you very much. We will see you next week. We all get to spend another day together. It's going to be great.
Much longer way.
Yeah, much longer day. But thank you very much. That concludes today's proceedings. The committee, I'll just take a motion moved by Senator Scarr on the date of return of questions on notice. The Secretariat suggested the 6th of November to give us plenty of time to prepare our report. Happy with that, Senator Scarr? Yes, he's nodding. So the committee has agreed to answers to questions on notice that this hearing should be returned by close of business Wednesday the 6th of November. I thank all witnesses who've given evidence today to the committee. Can I also thank Broadcasting and the Secretariat, and I declare the hearing adjourned.